distant lands we gather, hearts of fire all along. Oh, big Nick, cause we follow through the storm and through the fight. For Valhalla we will borrow strength and might under moonlight. Warriors of the ancient sea, songs of glory dark and bold. In the night, our spirits free, legends born, tales unfold. Oh, big because we follow through the storm and through the fight. For Valhalla we will borrow strength and might under moonlight.
Hey, oh, folks. Hey. All right. Welcome to a marathon. What I did, because if you follow Judge Simpson, his channel, you know that he deletes. If he has a morning session and an afternoon session, the morning session disappears when he starts the afternoon session, because I'm really not sure why. But that is how he runs it, and his office runs it. So what I did was I recorded as much of it as I humanly could. Now, I did not catch it all because, as I said, once he starts this afternoon, the morning is deleted, and if I was mid-recording, gone. So I have then all the days, removed the breaks, removed the pauses, removed the silent parts, when he's only shuffling papers, and I did not get 8+ hours. I did not get 9+ hours. I got 10.5 hours of just Judge Simpson. I will be with you in the background or in the forefront or talking or chatting with you guys the entire time. As much as I can. For 10.5, at least. If something really interesting happens and I need to talk about it, yes, I will pause, I will show up, and we will talk about it. So I actually don't know how long this will take. But the video in itself, the compilation, is 10.5 hours. Now, for you who say, oh, that's too long, well, keep it on in the background. I will do tomorrow. I will chop it up in half-hour segment. And I will know what piqued the interest by how many viewers are there, if the chat is going wild. So I will know which ones are the most interesting and stuff like that. And yeah, so for instance, if you are a content creator and want, hey, can I use this? Of course you can. Because it's not mine. It's Judge Simpson's. I'm using fair use to restream with me doing some alterations. And now if you want to use the things where I am in and talking about it, CC, Creative Commons International 4.0 or whatever it's called. So yes, of course you can clip it. of course you can clip it. So yeah, so that is what will be going on today. I will be here. I have my coffee, I have my nicotine pouches, I have some crackers. So I will be here with you as much, at least the first hour I will be here. Then if I have to take a call, I have to do stuff, visit the big boys room. But yeah, we will have a full day of Judge Simpson. So let's get on with it. Yes, get on with it. I actually look like my. Yes, Christine, you can stream it yourself.
Simpson, all those happened for the court are here, the Honorable Judge Jason.
All right, you may be seated. Court does call the case of Ryan Palmer versus Sonia Stoneburn. Huh?
He just went to the best.
All right, where are we on this case?
See her.
She hasn't been here? Okay, like take a default. All right, it's gonna be, do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God? All right, it's a claim.
For determination tendency based on the damage that least violations, of damage she's caused to property. She denied it, but I'm happy to show you a picture of the damage. Just
All right, but she has damaged the premises.
yes.
All
right. The holes literally extremely built out. And we've got major testing for violations of these costs, classes, time handling. Parenthetically, she has big residence. And I did set her notice, a 7-day notice, not 8 months.
All right.
So that's for judgment for possession, and I asked that escrow be released. But
All right. Judgment.
you didn't pay her a full escrow.
She did not. She only $550. Judgment to the plaintiff. That is by default for possession. There is no redemption amount. The writ to issue 10 days. The escrow released to the plaintiff. He can have those. Man. Okay. Thank you.
Thank you.
Yep. Thank you. Take care. Evergreen Apartments versus Matthew Chavez.
Morning, Your Honor. James Fink for the plaintiff.
Good morning.
Good morning. Matthew Chavez.
All right. And where are we on this case?
Yes. ESA paperwork in, you got it approved, the ledger's been adjusted to reduce pet rent from the date he turned it in. The current balance including costs is $1873.61.
We just started
It's a practical
solving.
issue, but that's up to you, sir. 1873.61.
Sir, your position.
Yeah, I don't see where they took the pet rent off.
Yeah, great. It's minus 17 months of pet rent. It's prorated from the date. It's $30 a month from the date you turn your paperwork in. $30 a month. You turn your paperwork in. So they should about 17. And you won't get charged going forward.
Okay, well, I have to, well, my Evelyn housing, she said she needed a total for what I owe, so she can try to get.
1873.61 is what you know.
That's what I'm.
Okay, all right. So
So she's not here, I guess. She said that she needed a total so she could try to get some different, organizations to.
Try to help you out. Okay. So let's do this. Already issue, today's 22nd, right?
Yes.
Sorry, we're going to be on the 2nd. Here's what I'll do. I'm going to find no tribal issue after hearing in this case. I'm going to issue a judgment for that amount. Okay. At the same time, give your worker time and you to work it out. No written until the 9th of May. All right.
Okay.
All right. That extends your time a little bit, about a week or so out.
Must have been a judgment, Your Honor.
All right. And you were able to get, the Humane Society took care of you, right?
Very next day. Thank you very much.
You're welcome.
Thank you, sir.
Thank you. Onyx Real Estate Solutions versus Daryl Daniel.
We think the party just stepped up.
I'll pass it.
That's it.
Where are
Yeah, Judge
They said
Simpson
what?
really doesn't mess around.
they ready? Jerome versus Cassidy. Who's in the hallway?
Signing a COD right now.
On,
You're right.
Daryl Daniels.
okay, they're signing, that one they're signing. the COD. All right. Council, want to state your appearances, please.
Your Honor, Agnes Cooper, appearing on behalf of Alec and Carolyn Jerome. Morning, Your Honor, Francine Over, appearing on behalf of Barry Cassidy. Mitchell, on behalf of Cambridge Junior Holdings. And Gail Rosen on behalf of Paul Cassidy.
All right. Okay. And where are we? I'm almost afraid to ask, but
Your Honor, we've attended mediation. We have continued discussions since that time, but as of right now, we're unable to resolve the matter on our own.
what's that mean?
I think it means we need a trial date, Your Honor. We need a scheduling order so that we have time to file an answer and a counterclaim because we've
Oh.
done that with the fourth claim, the fourth case.
Oh, I know what,
Okay.
but that's because you guys told me you'd be settled.
So
I didn't.
Then we're gonna file a motion to remove to the circuit court after we get our answer and counterclaim.
Why don't we do this? I'm gonna pass the matter and then I'm gonna meet with counsel and back, figure out exactly where this thing is and what we're doing on this, okay?
Thank you, Your Honor.
Thank you. Next, Real Estate Solutions versus Daryl Daniels.
Good morning, Your Honor.
Good morning, sir.
For the record, Neil Chan is appearing on behalf of Frank. Good morning.
Good morning, Mr. Daniels. How are you? Good. Okay, where are we?
Your Honor, we've agreed to the terms of a consent order for conditional dismissal. It indicates under further conditions, paragraph 3, that the defendant shall vacate the premises on or before May 23rd, 2025. Plaintiff shall reimburse the defendant for the rent paid in the month of February in the amount of $500. Return the security deposit in the amount of $650 and pay for moving expenses not to exceed $500 upon vacating premises. Paragraph 4B has been checked. I will explain the court rule 4.201J to Mr. Daniels, and then he has 3 business days to ask for the hearing date. If you believe you should not have entered into this, Mr. Daniels did sign the consent order.
Sir, is all of that correct?
Yes, sir.
Regarding that conditional order dismissal, do you have any questions whatsoever regarding that? No? All right, you have no problem with me signing it? All right, great. Have signed it. Thank you guys for working it out.
Thank you, Your Honor. Have a good
Thank
day.
Take care. S&G Holdings versus,
Yeah, before. Yeah, so sometimes even though both parties think that they can mediate and come to a conclusion by their own, sometimes it's just not going to happen. And they need a trial date. And then everything, if this is a civil case, everything becomes so much more expensive. But sometimes the clients just don't want to. They rather spend the money on principle than come to a cheap agreement.
Michelle, Stacy?
Your Honor, the attorney for the plaintiff has been in and out of Zoom. This is an objection to garnishment. He is not currently in.
He's not currently in.
Correct. He apparently has another matter as well.
All right, I'll have to pass it. The attorney on this for the other side is supposedly in Zoom. They were in, but has another court hearing that they're in right now. So then I'll call you back up when they're in. All right, thank you. Town Center Place versus Jacqueline King. She can have a seat there. All right. This is your motion.
Your Honor, we request, per COD, that an opinion be granted an additional 30 days to move. As per the terms of the COD, her condition was to show that she had, been looking for new housing. I provided a letter from your local housing, your senior showing the, properties that she's applied to. Since that letter, she's even applied to even more. She's been accepted at about 3 of them, but she hasn't had her interview yet. And then there, even after she has her interview, there's no guarantee that the apartment will be ready in a certain time. And I also filed a
So when are her interviews?
Would you mind a little?
Yeah. That's fine. Okay.
So yeah, so Ms. King has been selected for 3 apartments. And one specifically, she's in the process of an interview. We don't have a date yet. We're still seeing the paperwork. It's a really long process to get all of this done in such a short time frame, honestly, to get everything done. And so I would think the interview would be next week or so. She needs to get down there and get it scheduled. I mean, the apartment that, have the biggest lead on isn't one we really want her to go to, because obviously in this short time frame, she's not gonna get a great option to move into. So it'd be nice if we got her from the others, so we'll probably have to.
Okay. All right. Thank you. Response.
We're asking, for a written conditional order of dismissal to be enforced. Part of the conditional dismissal order was that she paid rent, she paid full rent, she paid timely rent. And we've informed her, as you see in the answer, of she recertified, her rental increase went up to $270 a month, and she's still been paying $247. So she owes currently $79. And she was supposed to pay on time, full amount of rent stated in the conditional dismissal. She has not. she's been informed that she had been paid by a letter from Invest both times, and she has not submitted any extra money.
Okay.
Yeah.
Your Honor, the ledger that, plaintiff added, submitted with their, answer is not the ledger that they. It seems to have removed all of the hat payments and Ms. King's credit, and produced this ledger that they claim is what she has paid. However, I've asked on more than one occasion for a complete ledger. This ledger starts in April of 2020. Ms. King has lived at Town Center for at least 8 years, and she's been in this new apartment for.
When was she recertified?
She was recertified.
I think it's in April or March.
It was January 16th, 2025.
January of this year
The effective date was March 1st, 2025.
of the rent. So it's March and April. That,
And
Go ahead. Your Honor, as part of the terms of the consent order for conditional dismissal, we were to wipe her ledger as a.
I recall. I
Did
recall.
that. So before that date, shouldn't be a controversy here.
Well, that's what I was curious about.
Your Honor, the reason it's in controversy is because they wiped her account and included her February's payment, supposed to be February 7th, and they wiped her credit. Now, what my understanding of wiping her account was to remove the charges that she had since.
She was to zero out that's what was supposed to happen.
Okay. So she gets zeroed out the credit that she has and the payment that she made for February? Because if you look back to prior to them filing this case, she had been paying $200.
I'm not relitigating the case.
Okay, well, Your Honor, the COD says that she abide by the terms of it. This is subsidized housing, paying rent late, which she didn't do because she paid on the 5th, and they didn't process it until the 6th. And not paying the full amount of rent is not a eviction cause for subsidized housing. They are required to offer payment arrangements. The goal is for subsidized housing.
She entered into a COD that she was going to pay her rent timely.
No, COD says she would not violate her lease. This is not a non-payment of rent case. Never has been.
Does she have the 79?
Yes, Your Honor, she has $79.
Then why are we arguing? Why doesn't she pay it?
Because she has credit on her account, Your Honor. It's not fair for them to keep the credit, and they reverse the half payment at a different
All right.
time. And
This is ridiculous. It is simply what your argument is ridiculous. Because what I'm going to do is she was to abide by the terms. She has to pay her rent on time, got her account zeroed out, gave time for her to find new housing, gave an opportunity to then come before the court and ask for additional time if she showed that she was doing that and complying with the COD. She's not in compliance with the COD. I'm going to deny the motion to extend the time.
How is she not in compliance with the COD? It doesn't specifically say that she has to pay her rent one time.
It
or the
does.
full amount. It does.
It does.
It has things for late payments. It has other things that if you go to paragraph 23 or whatever,
Oh, Judge Simpson is about to blow the gasket, or doing it very calmly, I suspect. So this woman pays her rent except $79, and she refuses because she claims she has credit. You know what to do? You pay the damn $79, and then you make a claim back for the credit you have. You just don't withhold it. And Judge Simpson said, I did all of this for her, and she didn't do it.
If the thing that you can terminate, but you have.
You sign, I'm sorry. Your Honor,
Yes.
the second line from the last line says defendant will pay March and April rent at normal time. Your signature is right here.
And she pays on the fifth.
She did not pay her full rent.
Okay, but she paid on the fifth.
She didn't pay her full rent. We can go round and round in circles. Motion denied. Motion denied. I'm not going around and round in circles on this.
So Your Honor, we'll submit a writ.
Thank you.
Thank you. You have a good afternoon, Your Honor.
Yeah, too late. Good, thanks. All right, he's back in Zoom, so let me deal with him and then
Hello, Brandon.
I'll deal with the gang of four.
Now, this is a compilation of the entire week of Judge Simpson. There will be what do you call it, tenants court. There will be small claims court. There will be criminal court. There will be all of it for the next 10 hours or so.
Court recalls the case of S&T Holdings versus Michelle Stacy.
Ready, Your Honor. Tracy Thomas, appearing on behalf of plaintiff.
Hello, your name?
Michelle Stacy, representing self.
All right, and this is your objection to garnishment?
Yes, sir.
Okay, and what's your basis for the objection?
Received any information to defend myself against the garnishment before the garnishment has been issued.
What do you mean by that?
I filed my state tax return, and I received a letter from the state saying I will not receive my tax return because it has been given in the month to SC Holdings.
Correct.
So there was paperwork saying that I could defend myself to get that tax return.
Where you could say that again. Did you could defend yourself to get the tax return?
Yes.
Well, I'm not-
It's the same thing as getting garnished from a paycheck. I have a minute to say that I still need a paycheck. Is that the same thing as being garnished from my tax returns? That's my understanding.
well, I guess I'm unclear as to what you specifically wanted, because what I have here, ma'am, is that on June 18th of 2023, there was a money judgment in the amount of $3,381.14. Okay, there was a money judgment. So that would have been your first notice that there was a money judgment against you. Okay. The garnishments are usually sent without notification to the party, particularly tax garnishments. Okay, so I think you may be looking for something that really doesn't exist. Certainly with regard to wage garnishment, theoretically, you get one of those without notice too, but usually the employer or whoever is issuing the check kind of notifies you that something is going on. They may or may not, right? But in this circumstance, your notification to challenge the withholding of your taxes, you may be able to take it up with the state, but certainly as I look at the file and have reviewed everything, there's not anything improper in terms of what the plaintiff in this case has done in terms of garnishing your taxes.
I apologize for the time.
You apologize for?
We're wasting time.
Oh, no, don't apologize for that. That's fine. But as long as you understand what I'm saying, I just want to make sure, okay?
Please, could you tell me who exactly you're representing? Are you representing someone in Milan to come see Belleville?
Say again?
I don't know who SC Holdings is. They owe a lot of people a lot of money. I'm 6 to 8 weeks away from filing bankruptcy.
I got you. Was it
Your Honor,
that's Go ahead, Mr.
It's her former landlord. S&C Airlines is Park Lane apartment.
Okay. Okay, so the minor comments. Thank you so much.
Okay, got that? Okay. All right. So your objections are denied. Okay? Thank you.
Thank you, Your Honor.
Thank you, sir. All right, there's that. And can we get my 4 favorites back to the, huh? Oh, we only have 3 of them? Okay. We can get them into the jury once they all get there, and then I'll be in short.
PA District Court for County of Washington, State of Michigan, now back in session, the Honorable Judge Simpson.
You may be seated. Court does call the case of Sycamore versus P.
It's 50390 on behalf of plaintiff. I do appreciate you putting this dilemma and being able to make it.
Not a pro, not a pro.
I appreciate that as well, Your Honor. That's
Oh, you were just trying to tag on. No.
Jill Bauer. Jill Bauer, on behalf of Ms. P, who is present, I'm from Legal Services, P number 69260. I do want to let the court know Ms. P was assaulted this morning.
Oh, I'm sorry.
A near stranger and, is,
That's
definitely want to be here.
understood.
She's not feeling the best.
All right. Okay, this is your request.
Your Honor, first of all, I would never want court to think that I have been misled before, so I did lose track of the order that Ms. Newman highlighted in her answer. However, I do think that the order is subject to interpretation. And it does say that my client would remove any and all belongings, and I think the definition of belongings tends to be smaller personal items that can be easily moved. At this point, the other thing is, we had a discussion on the record of Ms. P back in January of our request that Ms. P be able to move her items to a part of the house where they wouldn't interfere with the repairs. And it was represented at that time that there was structural damage to the unit. However, I reviewed the fire report. It doesn't say anything about structural damage, and now that a lot of the drywall debris has been cleared from the ceiling, I really don't, I mean, I'm not an expert, but I don't see that there was structural damage to the unit. So where we are at this point is.
I think the import of that, I don't mean to interrupt you, was that in essence, there was going to have to be a gutting of this place. And so the issue of whether or not there's actual damage may have to be assessed at some other point, because my understanding was the unit needed to be gutted, which is why things could not remain there.
I just don't think that that's accurate at this point, that it actually had to be completely gutted. But I just wanted to, where we are at this point, Ms. P went in, she removed what she could into 2 vehicles that were in the parking lot. And then those vehicles were recently towed and she wasn't able to get any of those belongings. So now she's down to.
What do you mean?
She had 2 vehicles that were parked outside of her unit at Sycamore and they towed them. And all, those vehicles had all of the belongings that she was able to salvage. So she's down to a few items that remain in her unit that she doesn't have the finances or ability to move, and she would like them to remain in the basement. And it's a washer and a dryer, an air conditioner, and 2 barbecue grills. Is what she's asking to store there while the repairs are made.
Council, my problem here is this. As we were working through this case, and why the order reads the way that it is, was to give Ms. P time to get her things out of the unit. And I'll be honest with you, and I don't think you're trying to mislead the court or anything. I mean, there's a lot of orders that fly around here, so I'm not thinking that at all. But she's got to get the things out. I mean, that's kind of where we were trying to figure out how that would come about. And I mean, the date and the timing of everything, if you recall, I think we went through that 2 or 3 times to try to get that done. One time where there was sort of a ruling from the bench, but there wasn't an order, and then that didn't happen. And then we had to come back and try to deal with it again. And now I'm here again. Saying yes.
And I would like the court to know, every time I've been asked from opposing counsel for her, whether it was, if we go back to the date that you ordered, which was, I believe, February 6th, Ms. P didn't show up until 4 o'clock to remove the items, and office closed at 4:30. I received an email, 2 weeks later from opposing counsel. We gave her that entire day to do it. She took what she wanted. I just want to address the cars. The cars were inoperable. HUD actually sent my findings, and it's in my brief. It's in my motion, the copy of the email. HUD made Sycamore tag them. They were inoperable. The day they were tagged on Friday, they were not moved until Tuesday. Council knew about it. As soon as they were removed, I got for council a copy of where the towing company and where they were at, so she could go get her stuff. I feel like we bent over backwards to give her time. Then I had a message about the washer and dryer that she didn't want to lose that. I got my client to agree to give her 7 days to do it. Then last Friday, the time frame came and went, and she never came and got it. This is not Sycamore has bent over backwards to give Ms. P the opportunity to get her things. And here we are again, and we're asking for it again. And last week when council reached out to me, I said, get it done by Monday. Because I told my client, hold off. You can see it in the emails from my client. We're holding off. And here we are, we're asking for more time. It's been 4 months, 5 months.
Your Honor, the reality is that Ms. P is in this situation because she's living in poverty. She doesn't have the resources to move or store these items. She tried to get a storage unit. They wouldn't rent her because she doesn't have a debit card. I mean, she has done nothing wrong, and she's basically too poor to take advantage of the opportunity to move and store these items. And I just don't know why they can't remain in the basement while the unit is being repaired. There's no damage to the floor on the first floor. If you look, there's minimal damage to the structure of the ceiling on between the first and second floor. I brought pictures that shows no
minimal damage, as in what? Only 1/5 of the ceiling is gone? I mean, rarely a landlord goes to this extent to get its money back, because getting a lawyer, going into court, all of that costs money. But hey, what do I know?
burning into the wooden structures between the 2 floors. So I don't know why they would be in the way if they remain in the basement while they repair.
The email from HUD is very clear. The cars needed to be removed. The property needs to be trashed out. My client is doing what they're being told to do at this point.
And if we just look at it just on a whole other angle, but I mean, I'm not even there necessarily, but Ms. Bauer, if the property were to remain there and something happened to the property, whose responsibility would it be?
I haven't discussed if my client is willing to waive unintentional, or as long as it's not intentional damage.
Well, but see, that's where the problem comes in. I mean, if somebody, and I'm not even saying that it really by order is reflective of this, but even if the property was there and then we get into and somehow gets damaged, which can happen when people are doing construction. I mean, it can just happen. But then you get into all this litigation and hearings about, was it intentional? Was it this? Was it this? They didn't put it in a safe spot. So really, Sycamore or their contractors, I mean, you get into a whole bunch of other issues, which all can be avoided if the property is not there. We don't have that issue. I'm sure that's one of the reasons HUD is saying you got to get everything out. We're not, looking for Sycamore or HUD or anybody else to, or any contractor we hire to be placed in a situation of trying to be the guarantor of the safety of somebody's property.
Well, Your Honor, she's been homeless for 6 months now, and the repairs really haven't begun. There's been some clean out. I mean, even if they would let her move them into a unoccupied unit or something, she just does not have the resources to store them.
I know, but you're asking the landlord to assume basically to bail this property, which with that comes certain responsibilities for the landlord. I don't know under what possible theory I would ask the landlord to do something. To care for somebody's property. I mean, it's not their business. It's not what they do. And again, just hypothetically, let's say the landlord did put them in some other place on their property, and somebody comes in and like creates some vandalism at that place, destroys the property or damages the property. Who's the one responsible? And that's the problem. To answer your first question, in looking at my order, the intent of that order is that she remove from the premises everything that she wants to keep. That at the point at which if she leaves something, then the landlord's in a position to say it's abandoned, the landlord can get rid of it and do what they need to do in terms of repair that unit.
Miss P, she's just pretty devastated and was hoping to be able to hold on to those last few things. So that's why.
Right. No, I understand. I understand why you're doing it. I get all of that. Problem is, with the cars. The cars are you can't just put them there because ultimately they're going to be taken off the premises. That would happen anyway. So, I don't think.
I'm sorry.
Go ahead.
I wasn't assessing any particular, I wasn't like making a judgment about that. I was just letting the court know that it's been like a domino effect. Like, okay, I want to keep these belongings. These are, my personal belongings, and I can't get a storage unit, so I'm going to put them in these vehicles. And then they were in the vehicles for a while, and it seemed like that was going to be a solution. And then all of a sudden, she finds out, like they may have been tagged before, but she didn't find out immediately that they were tagged. And then suddenly the vehicle, she goes to look for the vehicles and they've been towed. And then she wasn't able to get the belongings out of them. So it's just been a domino effect where she's done nothing wrong. she's just a series of unfortunate events. And now she's lost almost 100% of everything material in her life. So it's just the thought of maybe being able to hold on to those last few items was. Ms. P just wanted the court to know that when she first put her belongings in the vehicles, they were operable. But because she was homeless and they were sitting there, I think one of them, the battery died, and one of them, a tire went flat.
And they become inoperable, which is why then after those, if those are the only two things, they tag them with the thought that whoever has the flat tire or the battery or the vehicle won't move or the like will then come and do what they need to do, either to move the vehicle or to put it back in operate. I mean, so I get that.
I think she just wanted you to know that she didn't intentionally leave.
No, and I'm not saying that. I'm just saying at some point, this part of it has to end. You know, and Miss Bauer, you know, a lot of folks come before the court with a lot of problems and a lot of issues, and a lot of sort of obstacles to overcome. And I think in trying to get through this, and I have to give Sycamore credit because, you know, they could have just taken a really hard line. They didn't, trying to get this going. I've been patient with what might be scheduling or trying to have her get the stuff out. But, you know, at some point, sadly, we just have to be done.
Thank you, Your Honor.
So I'm going to deny your request for an additional time. What is, having said that, then what is Sycamore's intention in terms of they're not intending at this point to let her back in to get her things set?
I mean, I can make it happen. And that was, I've offered multiple times. So if she wants to go get the washer and the dryer and the air conditioner or the grills, she wants to do it by today, I can go. I have no problem with that. I've never had a problem with that. I just need her to actually do it.
But she would like a chance to get the grills, but she doesn't have any place to put the washer herself. So can you go today by 4 o'clock today to get those grills? They'll happen. I'm assuming if they're offering for you to get that.
If that they're there, I don't know what's there, what's not there. Like I'm just, you're telling me that that's what's there, and then she can go.
Well, she saw Sycamore personnel roll the grills to the office.
I asked
And-
for more, and I'm putting on charge. They told me they did not do that. But if she wants to go today by 4 o'clock, go get this one. Let's put it on the record. I need to know what time she's going, so I can tell them. So let's give me a window.
Okay, so she just wants the court to know she videotaped them moving the grill, and she has talked to someone that said that they're at off. So
You want to know what? I'm done. I'm not going to litigate anymore. I mean, you know, at some point, the problem is everybody is, as we've said, bending over backwards to try to do this. I issued just now denying your motion, which means really we're done. I was looking maybe, and I think Ms. Zanin was trying to do the same thing, a bit of compassion to say, okay, if you can get these now, do it, but you got to give us a time. but I'm not gonna go through litigating. They took my property, they did this. I'm done. Whatever else anybody else wants to do, you can do it, but you're not doing it with the court sanction. That property at this point, since she has not removed it, is considered abandoned. And that Sycamore may do what they need to do with reference to taking that property out. If you guys work something out without my involvement, do what you gotta do. But I'm done.
I do appreciate the court here.
All right. Thank you.
Court does call the case, People versus Jamal Dow.
After one of the people,
All
Nice of
right.
you to share your courtroom, Gunnar.
Pardon?
Nice of you to share your courtroom with others.
Yeah, kinda.
All right. It seems like landlord hour is over, and now it's people versus. I forgot his name.
Be kicked out of mine.
Dan Garrett on behalf of Jamal. Law, you said your name, Jamal.
Jamal DeLaw. All right. And this is your petition.
Your Honor, so I motion for set aside. I always start with eligibility. It is clear that he is eligible. AG response indicates as much. In terms of suitability, Mr. Jalal has no prior criminal history, no subsequent criminal history, paid full restitution and completed, well, there's no probation, fines and costs, and would really help him with his job and his career search to have this removed. We're asking Your Honor to sign the order.
Is there anything you want to say?
Nope,
What are you doing these days?
working,
Working? What kind of working?
janitorial works. I own my own company.
Do you?
Yes.
Oh, fantastic. In the Ypsi area, huh?
Yes.
All right. Very good. The court, having heard the petitioner in this case, and the opportunity has been given for the Attorney General and prosecuting official to contest this application. Court does believe that circumstances, the behavior of the applicant, from the date of the applicant's conviction to the filing of this application do warrant setting aside this conviction. Court also does believe it is consistent with justice and the public welfare. Therefore, I will sign the order. Petition is granted.
Thank you very much, Your Honor.
Thank you. Court does call the case. People versus Jimmy Lee Mack.
after one of the people.
How you doing, Your Honor? Doing well. Jimmy Lee Mack Jr. for the record. Is this your petition? Yes, Your Honor. All right, go ahead.
Your Honor, well, I have put in numerous applications. The AG responded, before, my set aside for a few felonies was, placed on lien. Her response was reflective of my record, that was on lien before the set asides that was, set aside. So the information, her response was based off the felonies that was on my record before they got expunged. I would like can I give the court a copy of, the order from I have set aside? Your Honor?
Well, I'm not sure that it's gonna do me much good, Mr. Mack, but I mean, have you seen it?
I looked at it briefly, Your Honor. I did inform, the petitioner that if he wishes to update his request to the Attorney General, that may be something he can do. I can't give him any advice about how to proceed, but I did tell him that based on the Attorney General's response today, I'm not going to be agreeing. I mean, I'm not going to be situating or otherwise standing aside. I'm actually going to be asking the court to deny the petition. So I'm not sure if it's better for the petitioner to ask for an adjournment to supplement his petition, to ask that this get dismissed and he can file a new one, or what's better for him, because I don't know if there's a prejudicial effect on a denial today.
Correct.
So that's the concern I have, is that if the petitioner wishes to have additional information or different information for the Attorney General to consider to inform the people about the position they might take, if it would be better for him to ask for an adjournment or to try to start over from the beginning. I don't know what the answer is, but based on what I'm seeing today with the number of felony convictions and misdemeanor convictions, and frankly, the very recent 2019 felony conviction,
The people are not in a position to stipulate or agree to this domestic violence offense for 2000 being set aside.
I understand the people's response. However, Your Honor, again, my life has changed. I have my own businesses. I have a tax business. I have an ice cream business. I'm a licensed minister. I'm just trying to expand my outreach to work with people. Again, when I put in my applications, I put in all of them at the same time. So when the AG responded, before the information was entered on lien, her response was based on what was on lien instead of what was actually should have been on lien. And I asked that the court give the Attorney General opportunity to reflect at the my true record, which is actually only have 2 felonies on there. And I got to go to court next month, Your Honor, before Judge Slay for the other felonies, Your Honor. So I've been hitting every angle that I'm trying to get my life in order. I'm trying to start over on a clean slate. Again, Your Honor, I'm not engaged in a criminal activity. I am a pillar in the community. I'm up under Reverend Apostle Robert Ford. I'm one of his ministers, and I'm active in the community. I just asked the court to take a look at all the circumstances in this situation and do what's best in this matter, Your Honor. Again, I'm just trying to get my life in order. I done changed, and that was the things that this happened 20 years ago, Your Honor. I mean, I'm not that same individual from 20 years ago.
I understand all of that, sir. I guess that the problem is that your initial petition, the Attorney General has indicated that you're ineligible under statute, and they're correct in their assessment in terms of at least what they're looking at, because you have 5 convictions, when at most you can have 3. The real question is does an expungement then take care of those? I mean, if you have 2 expunged, does that make it 3? And I'm not sure that it does do that.
Well, Your Honor, what happened was the reason why I had so many felonies, because 20 years ago, I had got 5 felonies out of one situation. So under the one bad night rule, that's how they consolidated them all to one felony, because I had like 4 or 5 felonies out of one situation. So they consolidated.
I get that, sir. But the issue really is, for me, is that the Attorney General has objected. The prosecuting attorney here has objected because there are too many felonies. I don't think there's much I can do, because I don't think the petition as filed comports with the statute, which would allow me to grant your relief, even if I wanted to.
Your Honor, can I just reflect one thing? When I went before Miss Washington last week on a matter, this is what she had suggested, is she adjourned the matter and gave the prosecution a chance to reflect back out to the AG, and then to give a updated response, because if the AG sees that I don't have as many felonies that she says, then I'm pretty sure she wouldn't object to it, Your Honor. So I asked that the court at least adjourn this matter.
I don't have a problem adjourning it. I can't grant your petition with what I'm seeing here.
What I'm saying is, if we adjourn the matter, then maybe that the AG may give you a new response instead of.
They may, and then I take a look at that too.
Yes, so let's just go with that, Your Honor, if that's.
And Your Honor, I think the court has also highlighted one of the, I don't want to call it a catch-22, but one of the issues with the expungement language and I kind of, if it's expunged, is still one of the, like the sort of issue that we're having and we're seeing now with a lot of this. So I can't promise that if there's a different response from the AG, my response will be different next time, but I'm willing to give the petitioner that chance to at least try to have a different outcome.
It seems like the petitioner here, who has tried to better his life And 20 years ago, he did something stupid that resulted in multiple felonies. And he's doing everything by himself. And I think most of the issues why the prosecuting body, the Attorney General, and Judge Simpson can't do much is because he doesn't have a lawyer writing it up properly. Now, I hope he, even if I don't know about this jurisdiction, if he can get legal aid of some sort, but it seems like most of his issues here is in the actual paperwork he has filed, because he's not a lawyer, he's not knowledgeable.
When did your matter before Judge Washington get adjourned to?
May, I think she said June the 5th, I believe.
Okay, I can adjourn it to May 20th, or I can give a new date after that in June.
Yeah, after the new date, could you make that in
The
June?
June date?
Yes, make it, yeah. Because Your Honor, I believe, that response that I can get, that I should be getting for that hearing could be legitimate. And I'm gonna also reach out to the AG office myself with, this order that I have.
I'll adjourn the matter to June 10th, 2025, 1 p.m. Okay, all right.
Thank you. Yeah.
Court does call the case, People versus Keenan Grimes.
After a lot of the people, some people when they come, they start to report, you have to public defender, people that the conflict exists, they wait all that. Good afternoon, this is Smoke Defender Board, on behalf of Public Defender's Office. The Public Defender's Office, likewise, believe does not believe the conflict exists, but if one does, we also waive.
All right, the court for its part does not believe there's a conflict other than Michigan court rules. Other cases decided they were, to the extent the conflict does exist, given the waivers, the court will consent to hear the matters. Court does call the case of the People versus Keenan Grimes.
Ashley Lonnie for the people. I'm thinking that's the case, Your Honor. I don't have a file for Mr. Grimes. An expungement file, at least. I have other files. This is set for reinstate conviction. I think it was an automatic set aside.
It was an automatic set aside, but there's restitution owing.
Yes, Your Honor. I think that's correct.
I'm not being here to challenge it. It was an automatic set aside.
Yes.
All right. The conviction in this matter is reinstated. Let's call the case, People versus Jury Tools.
This one I know we're on. Good afternoon. It's Public Defender Lauren Kearney on behalf of Mr. Tools, who is on Zoom. Mr. Tools, can you please state your name for the record?
Yes, Jory Tools.
Go ahead, counsel.
Your Honor, we're here for an expungement hearing. We do believe and did receive word from the Attorney General's office that he is eligible for an expungement. If I may, on behalf of Mr. Tools' behalf, he is fully employed at E.B. Brown, where he works as a warehouse supervisor, excuse me.
Easy for you.
He's received significant promotions since being hired there, and is hoping, or maybe he already has gotten another promotion into management. Since this conviction, he received an associate's degree from Washtenaw Community College in 2022.
He got married in June I'm sorry, 2020. He got married in June of 2022. And he bought a historic home in Ypsilanti in September 2019. So he is local. His free time is spent with his wife and 2 children, visiting family members and doing various projects on his house. He is involved in his children's schooling, and they also attend school here in the area. He is involved in his community. He assists neighbors. He gave us an example of assisting an elderly neighbor move up rental. He does car repairs, shares fresh eggs, and helps shovel snow.
Shares fresh eggs?
I know, I want some of those
Yeah,
too.
wait, hold on. All right.
We don't have chickens anymore, so sorry, guys.
What you say?
Ah,
I said, we don't have chickens anymore, so sorry, guys. No fresh eggs.
Oh, boy, oh, boy.
did you make chicken noodle soup?
Wow, wow.
You did not. It would have been tough.
Parody. Jeez, oh, Pete.
You gotta use the whole thing.
Wow.
Mr. Tools really values a work-life balance, is trying to get a new job, and is this expungement of this case will help him confidently apply and interview for new opportunities.
All right. Sarah, is there anything you'd like to say?
No, I think that covers most of it. I am actually back in school at Eastern, pursuing my bachelor's degree. And I actually don't think that this is going to interfere with my job search moving forward because of how long ago it is. But it is something I just kind of like to put behind me. It's nearly 20 years old now at this point. I think I got it when I was 18. I'm going to be 36 in July. So I just like to move forward with a clean slate, so to speak.
Okay. What are you going, what field is your degree in? Or the one you're attempting to get?
Supply chain management. Supply chain management.
Oh, okay, okay. When you said, Ms. Purdy, I almost had to laugh when it said work-life balance, as she was listing all of those things that you do. I'm like, that doesn't seem like balance. I'm just trying to figure out when he sleeps.
I still get about 7 hours, which I'm happy with for now.
Okay. Well, that's good. How old are your kids?
My son is 10 and my daughter is 5.
Ah, okay. Well, you'll get sleep until they hit their teenage years. Then you'll be awake all night. Don't worry about it, though. Every parent has to go through it. All right. Well, sir, it's great hearing all of that. And I've reviewed the petition. And an opportunity has been given for the Attorney General and prosecuting official to contest this application, and they have not. Court does believe, after hearing the allocution, that the circumstances and behavior of the applicant from the date of the applicant's convictions to the filing of this application do warrant setting aside the convictions. The court certainly believes, after having heard everything, that it is consistent with the public welfare and with justice. Therefore, the petition is granted, and I have signed the order. Congratulations, sir.
Thank you. Appreciate it.
Yeah.
All right. Keep doing.
Congratulations, Mr. Tools. You now have a blank slate. Whatever you did when you were a teenager is no longer on your record.
Some good work out there, okay?
All righty. Thank you.
Is it possible to turn on captions? Sadly, my channel is not big enough to have the closed captions because I had to record this and I don't have the capabilities or anything to. I hope that YouTube one day allows me to have closed captions, but as of now, sorry, there's no way. Now, what I will do next week, because I will do the same next week, record everything, is when from Judge Simpson's court, I can turn on their closed captions and record with closed captions on, if they have it. But that's all I can do for now.
All right. 14th District Court of the County of Washington, State of Michigan is now in session. All those having business before the court draw near, the Honorable Judge Davis.
You may be seated. Ms. Lonnie.
Good morning, Your Honor. Ashley Lonnie for the people. At this time, the people would waive any conflict between this honorable court and the Office of the Public Defender. People do not believe that any conflict exists. We have to waive it for the avoidance of all doubt.
Thank you.
This is Public Defender's Office. Likewise, Your Honor, we do not believe a conflict exists between this honorable court and our office, but one who has to work for a ride, we would waive such a conflict.
Thank you. This court also does not believe there's conflict either of the Michigan court rules or the cases decided they were to the extent conflict does exist, given the waivers, court will consent to hear the matters. Court does call the case of the People versus Elizabeth Wilson.
Ashley Lonnie for the people.
Good morning, Your Honor. Attorney Michael Kelly, P77187, on behalf of Ms. Wilson, who's present to my right. Your Honor, today's date.
Can you state your name, please?
Elizabeth Wilson.
Thank you.
Today's date and time set for pretrial in this matter. At this time, I will be asking the court to schedule this for a final settlement conference.
6 and 9.
Yes.
Jury final settlement conference, June 6, 2025, 9 a.m. Jury selection, if necessary, June 9th, 2025, 8:30. Both of those proceedings are in person. And we'll continue.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you.
Court calls the case People versus Daniel Bowe.
Conrad Siller on behalf of Richmond Township.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Bowe, who should be dialed in, Your Honor. Mr. Bowe, can you please unmute and state your name for the court?
I only have one dial in, right?
Yes. 303.
Is that the number?
I believe that is him, Your Honor. He did text me this morning that he had dialed into the Zoom hearing.
Mr. Bowe, if you can hit *6, that will unmute you.
Can you
tell us your name? Yep, we can hear you.
Daniel Bowe?
What's your name? Thank you.
Daniel Bowe?
Thank you, Your Honor. We're respectfully requesting adjournment. Mr. Bowe has a Secretary of State appointment scheduled for next week. He believes he's on his way to getting his license valid. We're asking for an adjournment so that he can have that appointment for that to happen.
Any objection from the people?
No objection.
Agenda matter 2,
May 21st.
May 21st, 2025, 9 a.m. On continue. Thank you.
Thank you, Your Honor. Thank you, Mr. Bowe. You're all set for today.
All right, thank you. People versus Ahmad Kahala.
Ashley Lonnie for the people.
Ready, Your Honor. Joe Simon on behalf of Mr. Kahala. Your Honor, there's a co-defendant that Mr. Guerin represents. Do you want to call them successfully or together?
I really don't want you and Guerin up here at the same time.
That's a good point.
I mean, that's really what my issue was.
It's a fair point.
What are we?
Excuse me, Your Honor.
They're gonna-
Excuse, this, I would just want to clarify, this is Deborah Ford. Is this Isa Mohad Awad or a different case?
Say again?
Is this Isa Mohad Awad?
Nope.
All right, I'm sorry. I don't want to make an error.
Oh, we already have.
All right. They're both will be pleased in both cases.
Because I'm not listening to Simon this morning. Mr. Guerin, what would be your preference? Thank you. See, he knows how to act. I'll just take it one at a time.
Thank you, Your Honor.
All right.
There's an offer in this case to exceed its charge with prosecutors defer.
All right.
That is true, Your Honor, but it would be a no contest plea. Mr. Guerin forwarded the court by email a copy of the police report.
And I have reviewed it, so. Prosecutor's deferred, may I have him sworn, please?
Raise your right hand. Do you solemnly swear the testimony you're about to give be the truth, the whole truth, and nothing but the truth, so help you God? State your name.
Ahmed Kahla.
Sir, it is this court's understanding that you're going to be pleading no contest to the charge of assault and or assault battery. Is that correct?
Yes, Your Honor.
You understand what a no contest plea is?
Yes, Your Honor.
All right, two things about it I have to make sure that you understand. First of all, it means that you're not further desirous or wanting to contest this charge. You understand that?
Yes, Your Honor.
You also understand that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes, Your Honor.
I should also advise you that this is a misdemeanor punishable by up to 93 days in jail, $500 fine plus court cost. You understand that?
Yes, Your Honor.
The basis for a no contest plea.
Schedule civil liability, Your Honor.
Sir, to this charge, how do you plead?
No contest.
You understand that by pleading no contest, you'll not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form, correct?
Yes, Your Honor.
Any question regarding those rights?
No, Your Honor.
Please look at paragraph 5. Those are your rights which are part of a trial. You understand that by pleading no contest, you're giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of?
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No, Your Honor.
Anybody threaten you or coerce
No, Your Honor.
you? Doing this voluntarily?
I'm sorry.
You're doing this voluntarily
Yes, Your Honor.
and of your own free will?
Yes, Your Honor.
All right. The court has been provided and has reviewed Pittsfield Township Department of Public Safety report for their case number 2421-202. Any objection to the court having reviewed the report?
No, Your Honor.
No, Your Honor.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Counsel, have I complied with the court?
People are satisfied.
Yes, Your Honor.
Court will accept the defendant's plea of no contest to this charge. Is what? 23rd. Defendant is referred to probation for a pre-sentence investigation and report and determination of prosecutors deferred. Sentencing in this matter will be
May 14th.
May 14th, 2025, 9 a.m.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor.
Thank you. We'll continue.
Conference room. Okay.
Or does call the case People versus Najee Kahala.
Special line for people.
Good morning, Your Honor. Dan Garrett on behalf of Najee Kahala, who's standing to my right. Najee, can you identify yourself?
Najee Kahla.
All right.
Here, we're at the point for pretrial. There's an offer in this case. We just started the prosecutor's deferred.
That's correct, Your Honor. My client has filled the vice rights. Thank you.
May I have him sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your name.
Najee Kahla.
Sir, it is this court's understanding you're going to plead no contest to the charge of assault and or assault and battery. That is a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. Do you understand that?
Yes, Your Honor.
All right. Do you understand what a no contest plea is?
Yes, Your Honor.
All right. Two things about it I have to make sure you understand. First thing is it means that you're not further desirous or wanting to contest this charge. Do you understand that?
Yes, Your Honor.
Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes, Your Honor.
All right. Basis in no contest plea.
Civil liability, Your Honor.
May I have him sworn? I did. Oh, you're right. So to that charge, how do you plead?
No contest, Your Honor.
All right. You understand that by pleading no contest, you'll not have a trial of any kind?
Yes, Your Honor.
All right. You signed an advice of rights form today?
Yes, Your Honor.
Any question regarding any of those rights?
Oh, Your Honor.
All right, look at paragraph 5. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal all right?
Yes, Your Honor.
Are you on probation or parole?
Oh, Your Honor.
Anybody promise you anything other than what's been stated here today on the record to get you to plead?
Oh, Your Honor.
Anybody threaten you or coerce you?
Oh, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
and of your own free will.
Yes, Your Honor.
The court likewise in the previous case has been handed and has reviewed Pittsfield Township Department of Public Safety report for their case number 2421-202. Any objection to the court having reviewed that report?
No, Your Honor.
No, Your Honor.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Counsel, have I complied with the court rule?
People are satisfied.
Yes, Your Honor.
Court will accept the defendant's plea of no contest to this charge. Defendant is referred to probation for pre-sentence investigation and report. Sentencing will be May 14, 2025, 9 a.m. Bond will continue.
Thank you, Your Honor.
Thank you. Court does call the case of People versus Lisa Keebler.
Actually, one of the people.
Morning, Your Honor, John Bagwood on behalf of Ms. Keebler. Madam, may Ms. Lundy and I approach briefly?
Okay, we're back on the record in the case of People versus Keebler. Record should be reflected at the bench conference in this case. And so I'll just say it for the record. I do know Ms. Keebler, I've known her for a period of time, haven't seen her, I don't know how long, it's been ages. I explained that to counsel. I had made the decision that I would not recuse unless requested to do so. And I think everybody knows I'm going to handle it just like I handle any other case. Good, bad, or indifferent. That's the way that I roll. Thought I'd place that on.
Thank you, Judge.
Thank you, Your Honor.
Your Honor, Ms. Keebler has not been arraigned yet.
Yes.
So I would acknowledge to the court that we've received a copy of the complaint. And we waive its formal reading, and Ms. Keebler stands muted this time.
Good, and having waived formal readings, the court will enter a not guilty plea on her behalf. What do we wish to do with the case today before I sit down?
Your Honor, I am awaiting some recordings. Ms. Lundy is facilitating getting those to me. I'd ask for a number of them. I'd ask for a 4-week adjournment.
All right. What's the next day? I got a May 20th. Adjourn the matter to May 21st, 2025, 9 a.m. or as your invite indicates. As to bond in this case.
Your Honor, as to bond in this case, I misspoke at the bench. The alleged BAC in this case is 0.194. I said 174. I apologize. For
Okay, no,
this mistake
that's
on my
fine.
part.
194.
There was also a lab result showing the presence of cocaine. This is a single vehicle incident where the vehicle either crashed or got stuck. And the defendant does have a prior from 2014 of high BAC. People are requesting a scram tether as well as twice a week testing.
Mr. Okay.
Your Honor, we understand the request for alcohol monitoring. We'd request a sober link rather than a scram. And no objection at this time to the testing, and assuming that Ms. Keebler does returns results on those as I anticipate at some point, we'll be asking the court to modify that.
Yeah. Set the defendant's bond at a $20,000 personal recognizance bond. All other standard conditions, including no assault behavior, possession of any weapons or ammunition. There's to be no use of any alcohol, recreational marijuana, or any illegal drugs. I will indicate also that she is to report over to community corrections for placement on the SoberLink testing device, as well as I'm going to order random drug testing 2 times per week.
Thank you, Judge. Appreciate it. See you in a month.
Let's call the case. People versus Michael Klustra.
Question money for the people.
Good morning, Your Honor. Uwe Dalsmith on behalf of Mr. Klustra. Might please state your name for the record. Michael Klustra. Here for the adjourned pre-trial. I think we're in communication.
Sure. Okay, record should reflect that there's been a bench conference. I will adjourn this matter to May 21st, 2025, 9 a.m. Wow. How was Ohio?
It was good. It was productive. I caught some walleye. Good memory.
You don't like the Michigan ones?
Well, I stand in a river that goes into Lake Erie, so I don't have a boat to go to Detroit River. Thank you for allowing me to go there.
Not a problem. Okay, but it worked out for you. It did. Okay. All right. We're good. Thank you. On continue. Court calls case, People versus Aaron Salazar.
Ashley Lonnie for the people.
Morning, Your Honor. David Shan on behalf of Aaron Salazar, who's approaching. Please.
My name is Aaron Salazar. All right, thank you.
Your Honor, Ms. Londi would like to have Aaron on the sober link for another 30 days to see how he continues to do. He's doing well right now. And then we have a potential plea on that matter, but a 30-day adjournment to continue him on the sober link and see if he continues to do what he's doing so far.
We'll adjourn the matter May 21st, 2025.
Thank you, Your Honor.
Thank you. Court calls case, People versus Ronald Altman.
Ashley Lonnie for the people.
Morning, Your Honor. Don Smith on behalf of Mr. Altman, who's approaching the podium. P65339.
Yeah, in this case, I have.
Can you state your name? Hang on. Thank you. All right.
We have spoken with defense counsel in this case. We have some different things going on. I believe ultimately there will be a request to adjourn and see if we work something out. And may end up going to the final settlement docket in June, but right now I think that's where we're going. It's an adjournment of today's briefing.
I agree. Yeah, I hear you using the date of May 21st.
It's only because they gave it to me.
Oh. I have a trial that morning. I am the prosecutor for all child protective proceedings in St. Joseph County, and we have a trial that morning, just the morning. I don't know if you do any of these in the afternoon at all.
Like a prosecutor. I don't know. I don't know if I like. Do I like it? Do you like St. Joseph County? We do? Okay. All right. All right, let's see if we can find you another date there.
I don't know if you do them sooner than a month. I don't know.
I don't. My schedule gets weird only because of a judicial conference that we lose a day. That's why normally we would be about 2 weeks out.
Okay.
I can go to June 4th, but if that's
great.
Will that work for you?
Yeah.
But one thing that Ms. Londi indicated is that it may go to the final settlement conference. If it goes to June 4th, the next final settlement conference is 2 days later on June 6th, and then jury selection on the 9th. Otherwise, what happens if jury selection won't happen until August?
Okay, I guess we'll play it by ear.
Okay, all right. Just wanted you to be aware of that so you didn't. Nobody was surprised. So June 4th, 2025, 9 a.m. Thank you, sir.
Do we wait for notices now, or do they send those?
They should be sending notices and counsel approach. How you telling? Yeah, it is. I think you're right. All right. So we'll go June 4th, 9 a.m. and bond will continue in this case.
Great. Thank you very much.
Thank you. Sure. And could you make sure he has that? Counsel has that. Case People versus Sarah Orr.
Ashley Lonnie for the people.
Carolyn Foster Tucker on behalf of Sarah Orr. Please state your name. Sarah Orr, Your Honor.
Yeah, there's an offer in this case to plead to the added count. I don't think that it would be added count of failure to report $1,000 accident, the 90-day $100 fine, 0-point offense.
I don't think that the defendant is ready to accept or reject that today, and there's some ongoing conversations between counsel, but that also will remain open until our next date.
All right,
That is correct. We're just requesting an adjournment.
all right. May 21st, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Court calls case People versus, is it Diarrhea PM?
Ashley Lonnie for the people.
We're on. Who's counsel?
Oh, I saw him this morning.
Is he in?
So,
He was physically in the courtroom. Where was his client here? Oh, okay. I thought I saw him. Court does call the case of the People versus Zachary Burlett.
Ashley Lonnie for the people.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Burlett, who is present via Zoom. Sir, can you please unmute and state your name for the court?
Zachary Thomas Burlett.
Thank you, Your Honor. I believe the people and we are very close to a resolution in this case. I have discussed this matter both with them and my client. To that end, we're respectfully requesting an adjournment to tie up a couple of loose ends. I would ask for some time in late May.
She's been sitting in the courtroom. You heard me explain my calendar. And then she's gonna ask like she's clairvoyant. May 21st, 2025, 9 a.m.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you.
Thank you, sir. We'll be in touch.
All right, thank you, Natalie.
Court calls case People versus Nicole Caldwell.
Ashley Lonnie for the people.
Assistant Public Defender Natalie Pate with and on behalf of Ms. Caldwell, who should be present via Zoom. Ms. Caldwell, can you please unmute, turn on your camera and state your name for the court?
Nicole Caldwell.
Thank you.
You're welcome.
Thank you, Your Honor. We wish to set this case for final settlement conference.
Jury final settlement conference will be June 6, 2025, 9 a.m. Jury selection if necessary, June 9th, 2025 at 8:30. Both of those proceedings are in person. Bond will continue. Thank you.
Thank you.
Thank you, Ms. Caldwell.
Court calls case People versus Rebecca Dilworth.
Ashley Lonnie for the people.
On behalf of the defendant. Please introduce yourself to the court.
Rebecca Dilworth.
Aaron, it's an offer excited for the defendant, that you're getting some time to work out some of the conditions of, so I believe it's possible to request an adjournment for work on those things.
That's correct. Probably about a month.
Yes.
About a month if the court can accommodate.
May 21st, 2025, 9 a.m. Bond continue.
Thank you, Judge.
Court calls case People versus Natasha, is it Almost?
Ashley Lonnie for the people.
On behalf of Ms. Olmos. Please introduce yourself to the judge.
Hi, I'm Natasha. Morning.
Good morning. And what's your last name?
Almost.
Thank you. So, Your Honor, I've talked with Ms. Olmos. I've spoken with the prosecutor. Ms. Olmos is interested in participating in sobriety court. And so we are asking for an adjournment to get her screened and to get that process going.
That's correct. The office will plead guilty to count 1, operating while intoxicated after less than 16 or a no contest plea, and discussing child abuse with entry into sobriety.
All right. Adjourn the matter May 21st, 2025, 9 a.m.
And Your Honor, if we may be heard as to bond.
Yes.
So Ms. Olmos is currently on a scram tether. That's getting to be quite costly for her. She is a mother, a recently single mother. We're not asking that she be off tracking entirely. We're asking that be converted to a SoberLink device to give her a little help with the cost.
Response from people. Well,
Looks like to me.
I'm not gonna do that, and I'm gonna indicate why. I'm gonna leave it on at least for another month. I'll certainly hear from the people, but I'm not changing it because of the not only the final result, but the PBT was substantial. So, I mean, usually people don't start out on a scram with me, but I think there were circumstances here that led me to that conclusion. Understood. But certainly in May, raise that issue and take another look at it. Understood. Thank you. Thank you. Court calls case, People versus Issa Awad.
That's a line of people.
Deborah
Good morning,
Geraldine
Ellen.
Bledsoe. Deborah Geraldine Bledsoe Ford on behalf of Issa Ahmad.
Good morning, Ms. Ford. Sir, can you state your name?
Good morning, Your Honor. How are you doing?
I'm doing great, Ms. Ford. All right. As to the arraignment in this case,
Your Honor, I'd ask that this be set for, sorry. My client pleads
all
not
right,
guilty.
defendant having waived formal reading, pleading not guilty to the charge, court will enter that plea. Would you like an adjournment of the pretrial, Ms. Ford?
Yes, yes, please.
I'll adjourn pretrial in this matter to May 21st, 2025, 9 a.m. Go ahead. I'm sorry.
May I come in on Zoom on that day, please?
If you fill out the form, and then I don't have a problem with that.
Thank you. Guess what? My daughter's graduating from law school. That's where I'm going to be in California. But I will fill out the form properly and appear on Zoom.
All right.
Thank you.
Another lawyer? Oh, joy. All right. Oh, hold on one moment. Let me set bond in this case. I'll set bond in the amount of a $10,000 personal recognizance bond. I'll order standard conditions, including no assaultive behavior or possession of any weapons or ammunition. You understand that, sir?
Yes, Your Honor.
There's to be no use of any alcohol, recreational marijuana, or any illegal drugs. I am also going to order no contact with Casey Todd. You understand that, sir?
Yes, Your Honor.
And because of, I'm also going to order no possession of any animals.
Yes, Your Honor.
We do have one additional request. If we
Yes, go ahead.
Do we have a no-go to Blue Pearl Vet?
Okay. Blue Pearl.
Yeah, Blue Pearl Veterinary, I should say, not just vet.
Okay, I'm going to order all of their locations in Michigan.
Thank you, Your Honor.
Because we just happen to have one here, but I think there are others.
I agree, Your Honor. There's a few different ones.
All right. I think that's it. We'll see everybody on the 21st. Ms. Ford,
Thank you.
congratulations to you and your family.
Thank you so much. Bye.
Bye-bye. Court calls the case, People versus Jazan Brooks.
Special luck for the people.
They're not here.
Sounds like she's yelling for people out of the hallway.
Okay, that's not a good thing to say out loud, Miss Perry.
She's here.
Who's here? Hello. Hi. What's your name?
Jazan Brooks.
Brooks, you are here on a misdemeanor complaint that alleges that on or about March 22nd, 2025, location of 3470 Carpenter Road, Pittsfield Township, Washtenaw County, State of Michigan, that you did commit the offense of malicious destruction of a building, $200 or more, but less than $1,000 worth of damage. You understand the nature of that charge, sir?
Yes.
All right. That is a misdemeanor punishable by up to 1 year incarceration and $2,000 fine plus court costs. The fine could be increased at 3 times the value of the property. That is the destruction to the property. 3 times the value of that is greater than $2,000. That becomes the maximum fine. You understand that?
Yes.
All right. First question I have for you is, do you want to be represented by an attorney?
Yes.
The public defender.
Assistant Public Defender Lauren Henry on behalf of Mr. Brooks.
Yeah.
Your Honor, we will waive any further reading, stand mute to the charges, and ask for another pretrial date.
Defendant having waived former reading, pleading, standing mute, pleading not guilty, court will enter that not guilty plea. Pretrial in this matter will be adjourned to May 21st, 2025, 9 a.m. As to bond in this case.
Your Honor, people are not requesting any monetary amount of bond, but are requesting a no go to that address on Carpenter Road, specifically 3470 Carpenter Road, 4197. I think that's Pittsfield Township, but an Ipsy mailing. It's more commonly known as American House Senior Living Facility.
Okay.
What condition you're asking at this time besides standard conditions?
Said is bonded a $5,000 personal recognizance bond on other standard conditions, including no assault behavior or possession of any weapons. You understand that, sir?
Yes.
There is to be no use of alcohol, recreational marijuana, or any illegal drug. You understand that?
Yes.
I'm going to indicate that you are not to go to the 3470 Carpenter Road address. You understand that?
Yes.
That's it. All right. See you next month. Court does recall the case, People versus Lisa Keegan.
Echelon people.
John Shea, Your Honor, again. Showing my age because I forgot to raise something on the record. Which is, and I disclose this to the bench judge, Mr. and Ms. Keebler have a trip to Florida planned, leaving May 1, returning May 10. And we're asking leave of the court to both leave the state for that and to suspend random testing during that period.
And I know Judge here, as long as the defendant remains compliant with the alcohol testing device, that she would take it.
Yes.
So I'll indicate defendant may travel to Florida. That was the first of the 10?
Yes.
Note that includes all the travel days. So
It does. Leaving the first, back on the 10th.
May 1st to May 10th, 2025. And testing is suspended during that time.
Great.
All right. Thank you.
Thank you, Judge.
Thank you.
Court has called the case People versus the M. Recall.
Good morning, Your Honor. Paul Tefelsky, P52844 on behalf of Ms. Thiem.
Good morning. My name is Jared, yeah.
Thank you.
Your we have reached a resolution in this case. The defendant is going to be pleading to an admin penalty of disturbing the peace of the misdemeanor $500 fine contrary to MCL 750170. In exchange for a plea for that, admin penalty will be dismissed. Maybe count 3 action. It is now in count 3, Your Honor, and counts 1 and 2. Excuse me.
That's what I would have. Got a quick statement, counsel? Very good. May I have her sworn?
Go ahead. Do you solemnly swear and affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your name.
Jared, yeah.
All right. Ma'am, it is this court's understanding that you're going to plead guilty to the charge of disturbing the peace.
Yes.
That is a misdemeanor punishable by up to 90 days in jail, $500 fine plus court costs. You understand that?
Okay,
Still wish to plead guilty?
yes,
To that charge, how do you plead?
guilty,
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
yes,
You signed an advice of rights form today, is that correct?
yes.
Any questions regarding those rights?
No.
Look at paragraph 5, you'll see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that. You understand you're giving up those rights?
No. I mean, yes,
You understand you're giving up those rights that you
Yes.
just read?
yes,
As well as all the rights on that?
yes,
All right. You understand you're giving up your right to appeal of right?
yes,
Then I can explain it if you need me to.
yes, please.
Explain it?
Mhm.
Okay. If you don't like the fact after this, that the conviction, that you have a conviction or the sentence, you can't appeal just automatically.
Okay.
You would have to ask permission of the higher court to appeal and to hear any complaint you have.
Okay,
You understand that?
I do.
All right. Are you on probation or parole?
Right now I'm on counseling. I'm taking counseling.
Okay, but are you under the jurisdiction of any other court?
Yes, yes,
You are?
yes,
Okay. You understand that if you are on probation to another court, that this plea could be a violation of that probation.
okay,
Okay, and if that court does consider this to be a violation, that court could sentence you to the maximum allowable under that other charges. You understand that?
yes,
All right. Understanding that, do you still wish to plead to this charge?
yes.
All right. Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No,
Has anybody threatened you or coerced you?
no,
You're doing this voluntarily and of your own free will?
yes,
All right. And also because you believe that you are indeed guilty of this offense? You said a yes?
yes,
All right. July 18, 2020, location of 771 Airport Boulevard, Pittsfield Township, Washington County, State of Michigan. What did you do at the Costco that makes you think that you're guilty?
I opened just a case of crab legs. Cause disturbance.
Okay, so you opened a case of crab legs?
Yes,
Okay. And so that was in the store?
yes,
And that you would admit is someplace that is public,
yes,
correct?
yes,
And so when you did that, and I imagine people from Costco's came over,
yeah,
okay, and that caused a disturbance
yes,
and disturbed the peace and repose in Costco at that time. Is that correct?
yes.
All right. Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
Yes. I'm satisfied, Your Honor.
All right, court will accept the defendant's plea to count 3. Counts 1 and 2 are dismissed.
There is an issue of restitution, Your Honor.
There is?
There is.
Okay.
Fortunately, Costco would not resell the crab legs once they had it open, so they had to be disposed of.
You still had the shell on them? I'm just saying, as a Maryland guy, you just,
I would have eaten them too,
you
Your Honor.
threw them in some hot water with Old Bay and never mind. It's just me. All right. What I will do is defendant is referred to probation for a pre-sentence investigation and report. Sentencing will be May 14th, 2025, 9 a.m. or as your invite indicates. Ma'am, you can stop at probation on your way down the hallway, okay?
Okay.
They'll be on your left-hand side as you're headed out.
Oh, thank you.
All right, thank you.
Thank you.
I appreciate it. That counsel said I would have eaten them too. So it didn't look like it was just me. All right. Okay. We'll get set up for our next block. I'll stand in recess.
All right.
Oh.
Yeah, there's a lot of fire. Okay. Well. This person's good too. Thank you. You're welcome. What is her phone number? 734?
All right. Being a district court for County of Washington, State of Michigan is now back in session. The office of investigation.
Be seated. Court does call the case, People versus Jermaine Nathan. 3 cases.
Ashley Lundy for the people.
Senator Silver on behalf of Pittsfield Township.
Good morning, Assistant Public Defender Lauren Kearney on behalf of Mr. Nathan. Mr. Nathan, can you state your name for the record, please?
Jermaine Nathan.
Your Honor, I think that Ms. Pate and Mr. Nathan were unable to speak prior to today's court date. If I may, I just want to confirm, Mr. Nathan, does your phone number end in 2014?
Yes.
Okay. Well, regardless, Your Honor, it seems like they weren't able to touch base. I'd ask for an adjournment for all of these cases. Mr. Nathan, the reason I'm asking for that is that you and your attorney can speak and then try to resolve the files together.
Okay.
May 21st, 2025, 9 a.m. or as your invite indicates. On these will continue. Thank you.
Thank you, Your Honor.
Court calls the cases of People versus Byron Blair.
For the people.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Blair, who is approaching the podium. State your name for the record, sir.
Byron Giant Blair. Thank you.
Thank you, Your Honor. The people did make an offer this morning that would resolve both of these cases, which I was able to briefly discuss with my client. To that end, I'm asking for a brief adjournment so I can further discuss it with him. Further, Mr. Blair is being held on a felony matter that is scheduled for PCC tomorrow in front of Your Honor. So I can see what happens with both the felony case as well as to have a deeper discussion with my client regarding the offer. I'd request an adjournment into May.
May 21st, 2025, 9 a.m. Bond will continue.
Thank you, Your Honor. I'll be down to see you.
Calls the cases of the People versus Frederick Warden.
Senator Silver on behalf of Pittsfield Township.
Ashley Lundy for the people.
Good morning, Assistant Public Defender Lauren Kearney on behalf of Mr. Warden. Mr. Warden, please state your name for the record.
Frederick James Worden II.
Your Honor, thank you. We have resolutions on both files.
Is this a no contest plea?
Yes.
All right, counsel, you guys are gonna have to get these reports to us faster, because I mean, I'm doing my best to try to keep up with them, but I can't. I'm reading some during the break and I'm doing that. I can't do it that way.
I understand.
They need to be in a whole lot earlier than they are now, so I can go through them. Go ahead.
Well, we have resolutions on both. I'm happy to handle whichever first that Your Honor wants to handle.
Whatever, go ahead.
On the 2011 case, the driving suspended license case, Mr. Warden is going to be admitting to double parking.
That's correct, Your Honor. So in the Pittsfield Township case, I had to add double parking to count 2. If you accept admission, move to dismiss the official charge.
All right, let's take care of that then. Mr. Warden, do you admit responsibility to the fact that on or about August 19, 2011, at the location of West Michigan Avenue near Plum Hollow in Pittsfield Township, Washington County, State of Michigan, that you double parked a motor vehicle?
Yes, sir.
Court will accept that admission to count 2. Count 1 is dismissed, and that's in case for the record 1300, ending in 1300. Fines and cost of $180. When can you get that paid, sir?
Possibly today or tomorrow.
Okay. Pay it by the 28th, this next upcoming Monday.
Yes, sir.
Okay. And any other matter, what have we got?
There is an offer available to the defendant to plead to an count two of operating while intoxicated first offense, 93 misdemeanor, $100 to $500 fine, 6 points other various license sanctions, contrary to MCL 257-6251A as an alpha. In exchange for a plea to that, the originally charged count two operating with the presence of Schedule 1 controlled substance should be dismissed.
So it's operating while intoxicated.
It is.
Your Honor, my client will be accepting that offer today.
And that's a no contest plea.
Please, the reason being lack of recollection.
Let's have him sworn.
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth? God.
Yes, sir.
State your name.
Frederick James Worden II.
All right, sir, it is this court's understanding that you are going to be pleading no contest to a charge of operating while intoxicated. That is a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. The court could also order any rehabilitative services or community service the court deems necessary. You understand that?
Yes, sir.
All right. The court could also order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that?
Yes, sir.
All right. You understand what a no contest plea is?
Yes, sir.
All right, two things about it that you need to understand. First of all, it means that you're not further desirous or wanting to contest this charge. You understand that?
Yes, sir.
Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes, sir.
All right. Basis for the no contest plea.
Lack of recollection.
Sir, to that charge, how do you plead?
No contest.
Now, you understand that by pleading no contest, you'll not have a trial of any kind.
Yes, sir.
You signed an advice of rights form, is that correct?
Yes, sir.
Any questions regarding any of those rights?
No, sir.
Please look at paragraph 5 on that form. Those are your rights which are part of a trial. You understand that by pleading no contest, you're giving up those rights as well as all the rights on that form.
Yes, sir.
You understand you're giving up your right to appeal upright.
Yes, sir.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily
Yes, sir.
and of your own free will.
Yes, sir.
Court has been provided Pittsfield Township Department of Public Safety report for their case number 24-11525. Any objection to the court reviewing that report?
No, Your Honor.
No, Your Honor.
Based upon a review of that report, the court does find that there's sufficient factual basis on which the court to determine the defendant's guilt of the defense counsel. Have I complied with the court rule? Would it be proper to accept this defendant's plea?
The people are satisfied.
Satisfied, Your Honor.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. Defendant is referred to Von Schwartz for an alcohol screening and assessment. And the victim's impact panel. Sentencing in this matter will be
May 14th at 9 a.m.
May 14, 2025, 9 a.m. Bond will continue with its conditions.
Thank
Yes,
you.
sir.
Court does call the case People versus Kyle Burmeister.
Absolutely for the people.
Assistant Public Defender Natalie Pate with it on behalf of Kyle Burmeister, who is approaching. Please state your name for the record, sir.
Kyle Burmeister.
Thank you.
Thank you, Your Honor. Yesterday I did go down to the jail to go visit with Mr. Burmeister, and unfortunately I was told he was not feeling well and I was unable to visit with him. He is being held on 2 felony matters that are up for probable cause conference tomorrow, Your Honor. I'd request an adjournment so I can have a discussion with my client.
May 21st, 2025, 9 a.m. Bond continue.
Thank you, Your Honor.
Court calls the case of the People versus Ashton Ebler.
Absolutely for the people.
Assistant Public Defender Natalie Pate with it on behalf of Mr. Ebler, who should be present via Zoom. Sir, can you please state your name for the record?
Ashton Ebler.
Thank you, Your Honor. Just during the docket this morning, Mr. Ebler did send me the documentation that I was hoping to get to resolve this case. I still do need to review that and provide it to the people. I would respectfully be requesting an adjournment.
May 21st, 2025, 9 a.m. Bond continue.
Thank you, Your Honor.
Case People versus Jessica Fox.
Absolutely for the people.
Good morning, Mr. Public Defender, Ms. Fox. I'm not sure if she's going to be there.
There she is. Ms. Fox, can you state your name, please?
Jessica Fox.
Your Honor, I have not had contact with Ms. Fox. I've called the number we have in our file. I'm not sure if it's a good number. I asked her to contact the public defender's office and she's since changed her number.
Did you hear that,
Okay.
ma'am?
Yeah, I called a couple times.
The number I have for you is 9802, ends in those 4 digits.
No.
Adjourned matter, May 21st, 2025, 9 a.m. bond continued.
I'm so sorry.
Okay.
I'm sorry. On the 4/2 date of arraignment, court ordered the defendant was to provide proof of her sobriety to the public defender and then to the people because she was not placed in any sort of alcohol monitoring. She
Correct.
was sober for 4 years at that point. So I'm just following up on, it looks like they haven't had any communication. I'm requesting that be addressed at the next hearing because we have not received anything I can show.
All right. So when they touch base, I'm sure that will have happened. All right. Thank you. Thank you, ma'am.
Thank you.
Court does call the case People versus Christopher Minor.
Conrad still around behalf of this was
I can actually want it for the people.
Good morning. This is Public Defender Lauren Perry on behalf of Mr. Minor. Mr. Minor, please, you can stand right next to me. State your name for the record, please.
Christopher Charles Minor.
So, Your Honor, the last time we were here, we referred Mr. Minor to mental health treatment court. He was denied from participation. So we're kind of back to square one. I know he's being held on 2 cases up in the circuit court. His attorney there is trying to work something out. And that's, as Ms. Blondie said, you have to kind of driving the bus here. So I'd ask for an adjournment of these hearings to see what happens on those cases as he hasn't been accepted.
Without objection. May 21st, 2020. 9 a.m. Thank you. Court does call the case of the People versus Haley Force.
People.
Assistant Public Defender Natalie Pate with and on behalf of Ms. Force, who should be present via Zoom. Ma'am, can you please unmute and state your name for the record?
Haley Force.
I found one.
Thank you, Your Honor. As to the case ending in 0028, I have discussed this matter with my client and she wishes to set the case for final settlement conference.
Which case?
0028.
What about the other one?
The other matter, Your Honor, is a show cause. It is my understanding that there's $1 balance as to the case.
50.
That is my understanding, Your Honor. I did not double check this morning, but I believe that balance is still owing.
$50. When is she going to pay that?
Ms. Force, how much time did you need to make that $50 payment? Ms. Force, can you hear us?
Miss Force?
Yes.
Okay, that's her. All right. She probably dropped out. There's owing on one of these cases $50. Your counsel asked how long you're gonna need to get that paid.
Just next week. I get paid next week.
And pay it by the 28th.
Okay.
You get paid Friday of next week or what day?
Tuesday.
Tuesday?
Yes.
Pay it by the 30th.
Okay.
On the other case, jury final settlement conference, June 6, 2025 at 9 a.m. Jury selection if necessary, June 9, 2025 at 8:30. Both of those proceedings are in person.
Thank you, Your Honor.
Thank you. On continued.
Thank you, Ms. Force. You're all set for today.
Okay, thank you.
Court calls case People versus Daniel Sims.
That's a lot of good people.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Sims, who is approaching. Please state your name for the record, sir.
Daniel Sims.
Thank you.
Thank you, Your Honor. This pretrial was last adjourned to receive the CCTV footage from the people. We have received that as of yesterday, but I do need to review it with Mr. Sims. I would request another adjournment so we can review it together.
See ya. You know anything else, sir?
Yes, Your Honor, several other matters.
Turn it to May 21st, 2025, 9 a.m.
Thank you, Your Honor.
Court calls case of the People versus Marco Cipina Mororo.
Assistant, oh, sorry.
Conrad Silver on behalf of Pittsfield Township.
Assistant Public Defender Natalie Pate on behalf of Judge Moreno, who gave me permission to accept the offer on his behalf.
Your Honor, I move to add count 2 of double parking. You can accept that amendment.
On behalf of your client, do you take responsibility to the fact that on the date of February 15, 2025, at Washtenaw Avenue in Pittsfield Township, that he double parked a motor vehicle?
Yes, Your Honor.
Court will accept that admission to count 2. Count 1 is dismissed. Fines and cost of $180. When can you pay that?
As a matter of fact, he wanted to pay it yesterday, so I told him I would ask for the end of this week.
All right, pay it by this Friday, the 25th. Right? 25th. 2025.
Thank you, Your Honor.
Thank you. Court calls case People versus Kenneth Neal.
Conrad Silver on behalf of Pittsfield Township.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Tennille. Can you state your name for the record?
Kenneth Tennille.
Your Honor, Mr. Tennille has 2 cases before you today. We have come to a resolution. He's going to be pleading on the disorderly person case ending in 0673 in exchange for dismissal of the other case.
That is correct.
I just need your signature here. This is the my rights form. We went over yesterday. Oh, you're wrong. He's signing in advice of rights form right now.
He's gonna be pleading guilty for no contest.
No contest, if that's okay, Your Honor. I acknowledge that that was also submitted tardy. The reason being lack of recollection.
Having sworn.
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth, so help you God? Name.
Sir, it is this court's understanding that you're gonna be pleading guilty to the charge of disorderly person. And it's a misdemeanor punishable by up to 90 days, $500 fine plus court costs. Do you understand that?
Yes, sir.
Still wish, well, you're gonna be pleading no contest. Do you understand what a no contest plea is?
Yes, sir.
All right, 2 things about it I have to make sure you understand. First of all, means that you're not further desirous or wanting to contest this charge. You understand that?
Yes, sir.
Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty.
Yes, sir.
Still wish to plead, basis for a no contest plea.
Lack of recollection.
So, sir, to that charge, how do you plead?
Guilty. Do you want to plead no contest or guilty?
Guilty. No contest. Guilty. Which one are you pleading?
No contest because you said that you didn't remember. That meant if you're guilty, you have to testify.
Okay, no contest, sir. I'm sorry.
You understand that by pleading no contest, you will not have a trial of any kind.
Yes, sir.
You signed an advice of rights form, is that correct?
Yes, sir.
Any question regarding any of those rights?
No, sir.
Look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of the trial. You understand that by pleading no contest, you're giving up those rights as well as all the rights on that form.
Yes, sir.
You understand you're giving up your right to appeal LBRAC.
Yes, sir.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead no contest?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily
Yes, sir.
and of your own free will.
Yes, sir.
Court has been provided Pittsfield Township Department of Public Safety report for their case number 217170. Any objection to the court reviewing that report?
No, Your Honor.
No.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Counsel, have I complied with the court?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea of no contest to the charge as contained in case ending in 673. Case ending in 674 is dismissed pursuant to the plea agreement. Anything you want to say before I impose sentence, sir?
No, sir.
How long have you been in custody?
About 50 days since March 11th.
You've been in since March 11th?
Yes, sir.
That's how it is. Well, that's 30 plus 44 days. Huh? You got 42, that's fine. Give you fines and costs of 125. I'll send you 40 days. Washtenaw County Jail credit 40 served. And you're all set.
Thank you.
Judge, I saw a license plate last week. I was thinking it said Turk.
Yeah, I tried to get that plate. I couldn't get it.
Oh,
That person,
I saw
Well,
some.
it's local, so you might be able to negotiate for it. Transfer it to you.
There was a big controversy last year about someone had like an MGO blue plate. The guy had it for 25 years. He let it lapse for like 2 days. Someone else swooped in and got it.
Oh, I'm sure.
Yeah, it's distraught.
oh my God.
Yeah.
Court does call the case of People versus Shane Young. 2 cases.
And I so I have Pittsfield Township.
Good morning, Assistant Public Defender Lauren Kearney on behalf of Mr. Young. Mr. Young, please state your name.
Shane Allen Young, 31 of 83.
Sorry, go ahead.
Your Honor, I'm moving to dismiss both cases. Mr. Queenie has provided me with some documentation regarding the program that Mr. Young is involved in. Based on that information, I'm moving to dismiss both cases.
Any objection to that?
No objection.
All right. Sir?
No, sir.
Well, I knew,
Sorry.
I knew you would, but okay, no, you're good.
I'm sorry.
All right, both these cases are dismissed. I don't think you have anything else before me, do you, Mr.?
No, I do not.
All right. Well, I'm gonna tell you something. You came out in a wheelchair and you certainly did not have to stand. And I think I told you that the first time.
Several times.
Every time you came out. And I appreciate you showing the court that respect.
Yes, sir.
I just wanted to acknowledge that.
Thank you.
Take care of yourself.
I will try my best.
Good luck.
Thank you.
It's in custody. Oh. This one?
Yes.
Court does call the case of the People versus Stephen Grisbeck.
Comment Silver on behalf of Pittsfield Township.
Hello, sir.
How you doing?
Your name?
Stephen Griswold.
All right. This. Because of that, you're also giving up certain rights. You're giving up your right to call witnesses to speak for you at trial or to have this court compel their attendance. You're giving up your right to see, hear, and question all witnesses against you at trial. You're also giving up your right to be a witness for yourself or to remain silent, not have that silence used against you. And you're giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt. You understand that?
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily and of your own free will?
Yes, Your Honor.
And because you think that you are indeed guilty of this offense?
Yes, Your Honor.
December 10th, 2024, at the location of the BP gas station located at 4975 Washington Avenue, were you present at that gas station?
Yes, and I did not leave when I was told to.
And they asked you to leave and then you did not leave? Is that correct, sir?
Yes, I was just trying to purchase some cigarettes and pop and things.
But they had asked you to leave and you did not leave the premises. Is that correct?
Yes.
Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
Yes, Your Honor.
Satisfied, Your Honor.
Court will accept the defendant's plea of guilty to this charge. Anything either of you want to say before I do impose sentence?
Yeah, I will say on behalf of Mr. Moore, he does have 17 days credit. He's also staying at Avalon, is engaged in CMH services. His matters in 15th district have been resolved. So he's just hoping to get back to his services, mental health services.
State minimums of $125, 17 days, Washtenaw County Jail, credit 17, sir. And the other matters ending in 1420 and 1065, those matters are dismissed as part of the plea agreement. I didn't say so. All right. Thank you.
Your Honor, am I free to go?
What?
Am I free from custody?
You're not going to be held on the cases I have. I don't know what else you have.
Thank you, Your Honor.
Thank you. All right. We're going to take a brief recess, come back. We're running a little bit behind, but it'll start by 11 o'clock. They'll get me set up and we'll start rolling on that. What's in recess?
All rise. In the district court of the county of Washington, state of Michigan is now back in session. The Honorable Judge Simpson presides.
You may be seated. Court does call the case of People versus Christopher Holt.
Special Lobby for the People.
Good afternoon, Assistant Public Defender Lauren Kearney on behalf of Mr. Holt. Mr. Holt, please state your name for the record.
Christopher Holt. Oh, there he is. Okay.
Your Honor, Mr. Holt and I have not had contact prior to today. He said he's been up north without service. There has been an offer made. I'm requesting an adjournment so I can relay that to him and speak further about his options.
Matters adjourned May 21st, 2025, 9 a.m.
Thank you.
On continue. Thank you, Mr. Holt.
Thank you, sir.
Court calls case People versus Destin Hopkins.
Special Lobby for the People.
Sorry. Assistant Public Defender Natalie Pate on behalf of Mr. Hopkins, who is present via Zoom. Sir, can you please state your name for the record?
Destin Hopkins.
Thank you, Your Honor. Ultimately, I'm respectfully requesting an adjournment. Mr. Hopkins does have a pending BOP in circuit court, which he just texted me a brief update about this morning that I do need to have a longer conversation with him about. I'm asking if the court would consider an adjournment into possibly early June. If not, late May would also work. I believe I would be able to get the information needed by that time.
May 21st, 2025.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you. Court does call the case People versus Jared Roberson.
Special Lobby for the People.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Roberson, who should also be present via Zoom. Sir, can you please unmute and state your name for the record if you're there?
Jared Roberson.
You should dial in.
Yeah.
All right, what are we doing?
Thank you, Your Honor. Mr. Robertson is trying to get his license valid. He states to me that he is eligible in June. We're asking for an adjournment sometime into June if possible.
For correction,
No, this isn't a
not-
license case.
Registration. Sorry.
He's trying to get the registration.
Did I say license? I apologize, Your Honor.
So you want an adjournment too?
Yes.
I'll adjourn the matter to June 4th, 2025, 9 a.m.
Thanks, Your Honor.
All right, thank you, sir.
Thank you, Your Honor. Thank you, Mr. Robertson.
Thank you.
And thank you for that. I'm sorry.
Court calls the case, People versus Derek Simpson, no relation.
Good afternoon, Assistant Public Defender Lauren Perry on behalf of Mr. Simpson. Not sure if he was on Zoom, Your Honor. I did provide him with the link, but.
Derek Simpson. The Simpsons can't follow rules.
Sir, I have no explanation for his failure to appear. For the record, I would have.
Already got a warrant, Your Honor, in another case.
In another case?
Middle name Allen, correct, Your Honor?
Yes.
24 F5 5214. He appears by warrant for receiving his unstolen property felony.
Bench warrant in this case will issue bond is set in the amount of $7,500. I'll give a 10% privilege on this. This warrant will issue immediately.
Like a misdemeanor, but it still has a warrant.
Got it. Court calls the case People versus Alicia Stewart.
Hi.
iPhone 2.
Assistant Public Defender Natalie Pate with and on behalf of Ms. Stewart, who should be present via Zoom and or dial-in. Ma'am,
Ms. Stewart,
Yes.
I'll need you to turn the camera on.
Oh, I'm sorry.
Oh, there you are.
I'm
Okay.
sorry. I'm
All
just
right,
sick
what are we-
this morning.
Okay, it's okay. We'll get through this. All right, what are we doing?
Thank you, Your Honor. Ms. Stewart has a Secretary of State administrative hearing date set for May 1st. We're respectfully requesting an adjournment past that date.
All right. May 21st, 2025, 9 a.m. or as your invite indicates. Okay, Ms. Stewart?
Okay, thank you so much.
Thank you. Be well.
Thank
Thank you,
you.
Your Honor. Thank you, ma'am.
Court calls the case People versus Kevin Stickler.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Stichler, who should be present via Zoom. Sir, can you please unmute and state your name for the court?
Kevin Stichler.
Not available to the defendant in this case to plead guilty or contest with count 2 of retail fraud in the 3rd degree. 93 misdemeanor $500 fine or trouble amount contrary to Tax Code 750356D as in dog 4, with the dismissal of count 1 retail fraud in the 2nd degree, the 1-year misdemeanor.
And I have discussed that with my client, Your Honor, and he does wish to accept that offer today, pleading no contest to the added count 2.
Sir, please raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your name again for the record.
Kevin Stichler.
All right, you can put your hand down. Sir, it is this court's understanding that you're going to plead no contest to the charge retail fraud in the 3rd degree. That is a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. Fine could be increased to 3 times the value of the property taken. If that's greater than $500, that would become the maximum fine. You understand that, sir?
I do, Your Honor.
All right. Do you understand what a no contest plea is?
Yes.
2 things about it. I have to make sure you understand it. First of all, means that you're not desirous or wanting to contest this charge. You understand that?
Yes, Your Honor.
Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes, Your Honor.
All right. Basis of the no contest plea.
Potential civil liability, Your Honor.
Sir, to the charge of retail fraud 3rd degree, how do you plead?
No contest.
Now, you understand that by pleading no contest, you will not have a trial of any kind.
Correct.
Because of that, you're giving up certain rights. You're giving up your right to call witnesses to speak for you at trial or to have this court compel their attendance. You're giving up your right to see, hear, and question all witnesses against you at trial. You're also giving up your right to be a witness for yourself or to remain silent, not have that silence used against you. And you're giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt. You understand that, sir?
I do, Your Honor, yes.
You understand you're giving up your right to appeal upright.
Yes,
Are you on probation or parole?
I am on probation.
Are you on probation at the time of this offense, sir?
No,
All right. Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
no,
Has anybody threatened you or coerced you?
no,
You're doing this voluntarily and of your own free will?
I am, Your Honor.
All right. Court has been provided Pittsfield Township Department of Public Safety report for their case 21-13877. Any objection to the court having reviewed that report?
No, Your Honor.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Counsel, have I complied with the court?
You are satisfied.
Yes, Your Honor.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. Defendant is referred to probation for a pre-sentence investigation and report. Sentencing in this matter will be May 14th.
Yes.
May 14th, 2025, 9 a.m. Bond will continue. Sir, I'll have you wait on the line. We're going to put you in with our probation intake so we can get the sentencing process started, okay?
Yes, thank you very much, Your Honor.
All right, thank you, sir.
Thank you, Your Honor. Thank you, sir.
Thank you, Daniel.
Okay, all right. They're not right there, sir. However, I think they took a brief lunch break. If you do want to stay on the line, otherwise you'll have to call down. But if you do want to stay on the line, the moment they get back, we'll put you in.
Do you want me to, Natalie said she'd text me the number. If that's okay, I can call.
That's fine too also, sir.
Okay, I will do that. I got to go to work anyway, but I'll call as soon as I can.
All right, thank you.
Thank you, Your Honor. I appreciate it very much.
All right. Court does call the case, People versus Jada Taylor.
After long as the people.
Good afternoon, Mr. Public Defender Lauren Perry on behalf of Ms. Taylor. Who should be on Zoom. Ms. Taylor, please state your name for the record.
Hi, Jada Taylor. I'll turn on my camera.
All right, thank you.
We're asking for an adjournment. There's some video that we're working out with the prosecutor's office.
All right. Adjourn this May 21st, 2025, 9 a.m. Bond continued. All right. Thank you, Ms. Taylor.
Yep, thank you. Bye-bye. You have a nice day.
You do the same. Court calls the case, People versus Jason Williams.
Good afternoon, Assistant Public Defender Lauren Perry on behalf of Mr. Williams. Mr. Williams, please state your name for the record.
Jason Williams.
We're here for a pre-trial. There's also a pending bond violation.
There is.
I have spoken about the violation with my client. I believe today he's going to admit to the violation, and he would like to make a statement on his own behalf.
Yes, so that being said is, I admit to the violation and, I know I wasn't supposed to have alcohol in my system. No excuse, but the last few weeks, sir, I had so much going on in my life, money issues, the car issues, whatnot, family issues, and no, there's no excuse because you said what you said, and I wasn't trying to get in trouble or anything, and I've still been going to my program, and that's still been helping me. So, going to my program weekly by weekly and dropping with them and whatnot, and just still trying to grow as an individual and whatnot. So, that's all I have to really say right now, sir.
If I may, Your Honor, add to that. So Mr. Williams is attending substance abuse treatment in Detroit. I believe it's called Community Care First.
Yes.
He goes there weekly, for group therapy and is also attending AA meetings.
Do I have any documentation regarding any of that?
I believe I have provided to Ms. Londy. I'm happy to give it to the court. He gave me his schedule and,
But,
his
yeah, but how do I know that he's actually going to that?
Is that what?
I have his enrollment paperwork. I'm happy to get an updated progress report from that program and get that to the court.
And we sign in every week, so.
Every
We
week.
sign in every week. I think you said, I start also. Talk down.
How long has he been doing that?
I've been doing this, going on, 3 months. Oh, well, it's January, February, March. Almost going on 3 months.
Nothing, well, I was gonna say nothing, but I did want the court to know he is fully employed at U-Haul. He works full-time there. He is hoping to stay out of custody, and continue working, continue going to his treatment program, and just, get things back under control.
Yes. I'm sorry, oh.
Ms. Lundy.
Yeah, in anticipation of the court accepting the admission to the bond violation, people would request enough change in bond conditions. First and foremost, there was a prior bond violation in March that the court accepted the admission to allow the defendant to continue testing with where he's testing now. Unfortunately, this is an OWI case, and it does have a prior from 2012, and now this is the second time that we got an alcohol violation. So I am requesting that he be placed on a scram tether. I do believe that community safety and the public safety risk of having this person not be on 24-hour testing supervision is too great to ignore at this time. So I am requesting the court order that and have it placed on the scram tether.
My problem is that and this is why I don't like to do it this way. I gave you a chance, Mr. Allen. I gave you a chance with the last violation.
What? Just for me to speak, I wasn't informed that, about so I didn't know anything about the last violation. Like, this would have all been like, this wouldn't happen again. It wouldn't never happen again. Like it wouldn't never happen again. Like I said, I'm still just I'm working on it, sir. I definitely apologize. I'm just hoping like you could please work with me just one more chance, and you won't hear about it.
Here's the thing. I don't mind giving people chances, but I gave you an opportunity to test in Novi with results to community correction. I did that back, I think it looks like on March 5th. And I get these negative tests. Well, first of all, there were like numerous miss samples.
No, sorry.
I'm going by their report.
Okay.
Then I get negative results. Then on March 27th, that's when the ETG comes through. I get a positive alcohol result. Here's part of my problem. I don't know how much you're drinking. And so that comes through, you know you've been drinking. And then on the 2nd, we get a negative result from your ETG. Right. Then by the 9th, you're drinking again.
And the 2nd. And that's like,
what?
I'm just up here thinking, sir. Like, 2nd, like, 9th should have came back negative also.
It came back negative?
Yeah, negative. On the 2nd?
On the 2nd, it's negative. Because
right,
I'm only going to pick it up for whatever period in time, but then by the 9th, you're drinking again. Or sometime shortly before that or before that, you're drinking again. And I don't have any reason to doubt anything, but I don't know what treatment you're in. I don't have that in front of me, first of all, right now. I understand why I may not. But also, I don't even understand or nor can I trust what you're indicating is your participation with it.
So, like at the meetings, sir, there are 2-hour meetings every week. Like they're NAA, talk to a counselor and whatnot. And like once again.
Did you tell the counselor you're drinking?
So, did I tell the counselor I'm drinking? No, I'm not drinking.
Pardon?
I'm not drinking. Like I'm confused right now. Usually that's
pardon?
Did you tell your counselor that you had the positive?
Oh, no, because I just got informed. I just got informed on Monday, so I was going to tell him this.
Well, hold it. Whether you got informed or not, you knew you were drinking.
No, I just got informed on Monday that I violated. That's what I'm telling you on Monday.
Okay, listen real close to what I'm saying. Whether you were violated or not, right?
Right.
You knew you were drinking. And so my question is, you knowing that, did you tell your counselor you were drinking?
No, I haven't spoke with her yet. I was going to speak with her on Friday about that and tell her like.
I thought you went every week.
I go every week.
Okay.
Every week.
So today is the 23rd, right?
Right.
No, just listen to me.
Okay.
Today's the 23rd, which means presumably from the time of the results, you had at least 2 of those meetings. And you haven't told your counselor that you were drinking. That's from the last instance.
All right. Last week, sir, we was off due to Easter on Friday. So we
Here's the
didn't.
problem, young man. You're going to have to get your addiction under control. You've got an excuse for everything. If you didn't get caught, you would say nothing, either to your treatment, certainly not to the court, it seems to me. And then you would go about continuing to drink. I'll adjourn the matter to May 21st, 2025, 9 a.m. At this point, given his violation, his admission to the violation, defendant's bond is hereby ordered revoked. I will reconsider giving him a bond and maybe releasing him with certain conditions once I see the information or progress report.
I was gonna ask, Your Honor, do you think that, we could get him assessed by the jail, and see if there's any treatment programs that, this county can offer him, maybe a higher level of treatment than he's already engaged in?
Well, I don't know what he's engaged in. I mean, I can't, because what he's telling me doesn't make a whole lot of sense.
Well, I'll get that to the court and whatever other information I can obtain.
All right. Thank you. Court does call the case, People versus Lamar Hampton.
That's a lot of good people.
Lamar Hampton. You're not checked in. It's a bench warrant when he sent it for. She warranted him, so I'll just warrant him again. Must have been set aside, I would imagine. Bench warrant will issue for defendant's failure to appear. Bond $5,000. I'll give a 10% privilege. That warrant will issue immediately. Court calls case People versus Kalea Williams. Kalea Williams. Not check in. Issue an order to show cause on this. Court calls case People versus Shamia Foster.
Echelon of good people.
She has another warrant. City. I don't see her here. She already has an outstanding warrant. Bench warrant will issue for defendant's failure to appear. In this case, bond is set in amount of $5,000. I'll give a 10% privilege on that. That warrant will issue immediately. Court calls case People versus Trayvon G.
Echelon of good people.
Trayvon G. Here. Bench warrant will issue for defendant's failure to appear. Bond 5,000, 10% privilege on it. Warrant will issue immediately. Court calls case of the People versus Kalea Green.
Echelon of good people.
Kalea Green. No response. You have a show.
Yes, so failing to respond to this week.
Got it. Well, this is set version.
Yes, it is.
Bench warrant will issue for defendant's failure to appear. On 5,000, 10%. Warrant will issue immediately. Court calls case People versus Anton James.
Echelon of good people. She'll cross.
Anton James. They have not checked in. Bench warrant. Issue bond will be set in amount of 5,000. Give a 10% privilege. That warrant will issue immediately. Court calls case People versus Quincy Jones.
Echelon of good people.
Quincy Jones. There is also another warrant. This individual has another warrant. Out of this court. On DWLS. Surprise. Bench warrant will issue for defendant's failure to appear. Bond set in the amount of 5,000. Give a 10% privilege on that. That warrant will issue immediately. Court calls case of the People versus Sean Kennedy.
Echelon of good people.
Sean Kennedy. No response. Bench warrant. 5,000. Give a 10% privilege on that. That warrant will issue immediately. Court calls case People versus Torrance Wood.
Echelon of good people.
Torrance Woods. No response. Bench warrant. Bond 5,000. I'll give a 10% privilege on that. That warrant will issue immediately. Court calls case of the People versus Yusuf Jama.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Yama, who is present via Zoom. Sir, can you please state your name for the record?
Yes, Yusuf Jama.
Thank you, Your Honor. I was unsuccessful in reaching Mr. Yama prior to today's court date, so I would be requesting from the court an adjournment, and also Mr. Yama, please give me a call back whenever you can get the chance as soon as possible, please, sir. Thank you.
All right, yes, ma'am. Sorry, I got a new phone. I'll be calling the prosecutor.
Carried out this one last time. I'll adjourn the matter May 21st, 2025, 9 a.m.
Thank you very much, Your Honor.
Thank you, Your Honor.
Court calls case People versus Ellie Bankhead.
Assistant Public Defender Natalie Pate with and on behalf of Ms. Bankhead, who is present via Zoom. Can you please state your name for the record, ma'am?
My name is Elle Bankhead.
Thank you, Your Honor. I did discuss this matter with the township and I believe they were going to be dismissing this case.
That's correct, Your Honor. I'm moving to dismiss.
You don't have a problem with that, Ms. Bankhead, do you?
Absolutely not.
All right. Case is dismissed. You take care. Have a great day.
Thank you as well. Bye-bye.
Thank you, Ms. Bankhead.
Court calls the case, People versus Del Marcel Bass.
I'm Red Silver, on behalf of Pittsfield Township.
Good afternoon, Assistant Public Defender Lauren Kearney on behalf of Mr. Bass. Mr. Bass, can you please state your name for the record?
Del Marcel Bass.
Yeah, Mr. Bass is going to plead to 257.326. I do not have a signed advice of rights form for him. I can get that signed and submit to the court after the hearing if you'd like that. I did review it with him.
Is that the?
Yes, Your Honor, we had count 2 of MCL 257.326.
All right. Sir, please raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
State your name again for the record.
Del Marcel Bass.
Sir, it is this court's understanding you're going to plead guilty to the charge of allowing an ineligible driver to operate a motor vehicle. That's a misdemeanor punishable by up to 90 days, $100 fine plus court costs. Do you understand that?
Yes, sir.
Understanding that, you still wish to plead guilty?
Yes, sir.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, sir.
Because of that, you're giving up certain rights. You're giving up your right to call witnesses to speak for you at trial or to have this court compel their attendance. You're giving up your right to see, hear, and question all witnesses against you at trial. You're also giving up your right to be a witness for yourself or to remain silent, not have that silence used against you. And you're giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt. You understand that, sir?
Yes, sir.
You understand you're giving up your right to appeal of right?
Yes.
Are you on probation or parole?
I'm on probation.
All right. Were you on probation at the time of this offense in July of 24?
I believe so. I can't. I want to say yes.
Okay. If you were on that probation at that time, you understand that your plea in this case could be a violation of that probation.
Yes, and I talked to my probation officer.
Okay. All right, but I have to advise you of this, that if the court, if that court does consider this a violation of that probation, you could be sentenced to the maximum allowable under that other charge. You understand that, sir?
Yes.
Understanding that, you still wish to plead to this charge?
Yes.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily and of your own free will?
Yes.
And because you believe that you're guilty of this offense?
Yes.
On September 24, July 9th, 2024, at the location of Washington near Gulf site in Pittsfield Township, Washington County, state of Michigan, did you have custody or control of a motor vehicle?
Yes, sir.
Did you allow someone who was otherwise ineligible to operate that motor vehicle that may have indeed been yourself?
Yes, sir.
Counsel, have I complied with the court?
Yes, sir.
Yes, sir.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. Sir, anything you want to say before I impose sentence?
I apologize for driving. I'm actually trying to work on getting my license back through Secretary of State, which I have to have a hearing and all of that, which means I got to go through all the paperwork before I can get a hearing set.
Got it. Okay. Fines and costs of $250. I'll suspend 90 days in jail. When do you think you can get this paid?
Can I get at least a month?
I guess so. Pay it by May 31st, 2025.
Yes,
okay?
sir. I appreciate it.
All right. Take care. Don't forget about that.
Oh, I won't.
All right.
Thank you.
Court calls the case, People versus Audrey Beatty.
Conrad Soto on behalf of Pittsfield Township.
Hello,
Hi,
what's your name?
Audrey Janine Beatty.
Is she here? She in pre-trial? Have pre-trial on both, but. Oh, these, oh, okay. All right. You know why you're here?
Yes.
Good charges? Okay, you had been arraigned on this, but you didn't have, and it was some time ago.
Yes.
18, so you're not represented by an attorney.
May I? Is it okay to speak?
Pardon?
May I have an attorney? May I have an attorney, Your Honor?
So she raised her, I don't know why she was raising her hand at me. I thought, no, she was, I thought she was gonna give me the hand like, be quiet. Look, that's what I thought.
You got it.
And I'm like, what?
No, not at all. Not at all.
All right.
I'm nervous.
You nervous?
Yes.
Me too. She said that wasn't funny. No reason. Yes, ma'am. What I actually was gonna ask you before you said something is, do you want to be represented by an attorney?
Yes, Your Honor.
All right, these are public defender cases.
Thank you.
You're welcome.
Good afternoon, Assistant Public Defender Lauren Perny on behalf of Miss Beatty. We were able to speak prior to the hearing being called. I think we're gonna be able to figure this out. We're just asking for a brief adjournment. Miss Beatty is gonna go to Secretary of State pretty soon here. Yes.
Okay. Is she knows what she has to do, or?
Yes, she paid the reinstatement fee yesterday. I think she just has to apply for a new license.
Okay.
She's been paying off her tickets, taking care of old cases, and she's been working.
Trying to get it done, but.
Yeah.
All right. So I'll indicate this is now a PD case. I'll adjourn this out to May 21st, 2025, 9 a.m.
Okay. 9 a.m.?
Well, I set it at 9 a.m. Make sure you're in contact with your attorneys. They'll send you the actual time block that you're on that day.
Thank you, Your Honor.
Are you less nervous now?
I'm still nervous. I'm still gonna be nervous.
Okay, you got good attorneys, so now you can relax a little bit.
Okay.
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 All right, you take care.
You too. Thank you.
So I'll be in touch with you before the 21st.
Okay. No problem.
All right. I tried to stay.
Court calls case, People versus James Church.
Conrad Soto on behalf of Pittsfield Township.
Oh, good afternoon, Assistant Public Defender Lauren Perny on behalf of Mr. Church. Your Honor, Mr. Church has given me permission to admit responsibility for double parking on his behalf.
Your Honor, move to add count 2 double parking. If you accept that admission, dismiss the original charge.
On behalf of your client, you admit responsibility to the fact that on January 8, 2025, Michigan Avenue, Pittsfield Township, that he double parked a motor vehicle.
I do.
All right, court will accept that admission. Count 1 is dismissed. Fines and cost of $180. When can that be paid?
Asking for 4 weeks.
Pay it by May 30th. 2025. Court does call the case of the People versus Deshaun Clifton.
Conrad Soto on behalf of Pittsfield Township.
Good afternoon, Assistant Public Defender Lauren Perny on behalf of Mr. Clifton.
Your Honor, we worked out an agreement. Defendant has made restitution in this matter, so I'm moving to dismiss.
No objection.
No objection.
Case is just, is he present? Mr. Clifton?
Yeah, yes, I'm here.
Okay. You have any problem with them dismissing this?
No, sir.
I didn't think you would. Okay. Case is dismissed. You have a great day.
Thank you, Your Honor. You as well.
Calls the case of the people versus Quintez Harris.
Still on behalf of this township.
Good afternoon, Assistant Public Defender Lauren Perry on behalf of Mr. Harris. Thing is on Zoom.
I hope screen's eternal, but no.
Well, given that I don't have an explanation for the to figure out, ask for an adjournment for the record.
Bench warrant will issue bond 10%. That warrant will issue immediately. Court does call the case of the people versus Bruce Hesterly.
Henry, still on behalf of Pittsfield Township.
Good afternoon, Assistant Public Defender Lauren Penny on behalf of Mr. Hesterly. We have come to a resolution that involves both cases. He's ending in 1582. He has given me permission to admit to double parking on his behalf, and in exchange, the interference case will be dismissed, which is the case ending in 1581.
That is correct, Your Honor. So I move that count to double parking in 1582. If you accept the admission, I will dismiss the original charge as well as case 1581.
And on behalf of your client, you admit responsibility to the fact that on December 6, 2024, location of Carpenter Road, Pittsfield Township, that they double parked a motor vehicle.
Yes.
Court will accept that admission to count 2. Count 1 is dismissed, as well as the case ending in 1581 is also dismissed. Fines and costs of $180. When can that be paid?
I think he requested 2 weeks, Your Honor.
May 16, 2025. Let's call the case people versus Neil Hines.
Henry, still on behalf of Pittsfield Township.
Public Defender Lauren Perry on behalf of Mr. Hines. Mr. Hines, please state your name for the record.
Neil Hines.
Thank you, sir. What are we doing?
We're ultimately requesting adjournment again. The court may remember Mr. Hines has been waiting to get his birth certificate. He even paid for like express shipping, and he still hasn't received it. And he
From where?
I guess it's state.
California?
Yesterday, I got it yesterday. My appointment's on Monday at 12:10.
Okay.
Oh, good. Okay.
So he at least has it. All right,
Yeah.
Well, why don't we just do this, because he's got to do something with that. June 4th, 2025, 9 a.m.
Sure.
All right, thank you. It does call the case, people versus Chelsea Hogan.
Henry, still on behalf of Pittsfield Township.
Assistant Public Defender Natalie Pate with and on behalf of Ms. Hogan, who should be present via Zoom.
I have a Motorola. Chelsea Hogan. Here it is. Well, there's somebody who's a Motorola Moto.
That's me, sir. I'm Daniel Noggle.
You got it? Yeah. Okay. So Ms. Hogan is not here.
So, Your Honor, I do not have an explanation for her failure to appear. I did speak with her, and we did have a resolution in place in which she was going to be accepting the offer by the people, or by the township, which was for a civil infraction. She did state she would be here today via Zoom. I would request an adjournment then, for the record.
Bench warrant 5,000, 10%. Warrant will issue immediately.
Thank you, Your Honor.
Court calls the case, people versus Carolyn Hoskins.
Henry, still on behalf of Pittsfield Township.
Assistant Public Defender Natalie Pate on behalf of Ms. Hoskins, who I do not believe is present, Your Honor. She did text me during the docket this morning stating that she was in the hospital and had pancreatitis. That is my explanation for her failure to appear. For the record, I would request an adjournment. or if the court would consider issuing the warrant in a few days so I can try to get documentation from her.
Bench warrant will issue bond 5,000, 10%. Warrant will issue this Friday, the 25th.
Thank you, Your Honor.
That's called the case People versus Maurice Keeley. Or Keeley.
Good afternoon, Assistant Public Defender Lauren Perry on behalf of Mr. Key. Ms. Key, please state your name. I'm requesting an adjournment. This case was just arraigned, I think, last week. I've not received, well, when I checked yesterday, I hadn't received the police report. So I just.
June 4th, 2025, 9 a.m. Where's your invited to case? Thank you, Mr. Key. Court calls case People versus Terrence Leonard.
On behalf of Pittsfield Township.
Assistant Public Defender Natalie Tate on behalf of Mr. Leonard, who gave me permission to accept the offer on his behalf.
Your Honor, I move to add count 2 of double parking, accepted admission, and dismiss the original charge.
Do you admit on behalf of your client to the fact that on February 21st, 2025, at Carpenter Road in Pittsfield Township, Washtenaw County, that they double parked a motor vehicle?
Yes, Your Honor.
Court will accept that admission to count 2. Count 1 is dismissed. Fines and costs of $180. When can they get that paid?
He's asking for 2 months, Your Honor.
May 30th, 2025.
Thank you.
Court calls case People versus Juan Mercado.
On behalf of Pittsfield Township.
Good afternoon, Assistant Public Defender Lauren Perry on behalf of Mr. Mercado has also given me permission to admit to double parking on his behalf.
Your Honor, I move to add count 2 double parking to accepted admission, and dismiss the original charge.
And on behalf of your client, do you admit responsibility to the fact that on July 9th, 2021, location of State Street, Pittsfield Township, Washtenaw County, State of Michigan, that they double parked a motor vehicle?
Yes.
Court will accept that admission to count 2. Count 1 is dismissed. Fines and costs of $180. When can they get that paid?
I think he can pay this week, I guess, for next Friday, just in case.
Paid by May 9th, 2025. Court calls case of the People versus Demarius Unos.
On behalf of Pittsfield Township.
Assistant Public Defender Natalie Tate with him on behalf of Demarius Munoz, who should be present via Zoom.
Mr. Munoz?
1 second.
Okay, yeah, we'll wait. All right.
Yeah.
You there?
Yeah.
Yes, hello.
Can you please state your name for the record?
State your name.
Damaris
Morgan.
Munez.
Thank you. All right.
Thank you, Your Honor. So unfortunately, Mrs. Munoz's brother did call our office downtown this morning, so I do now have good contact information for her. I was not able to have a good or any conversation with her prior to today. I'd request an adjournment.
All right. Manuel, adjourn your matter out to May 21st, 2025, 9 a.m. or as your invite indicates, okay?
Okay, thank you.
All right, thank you.
Thank you so much. We'll be in touch. Thank you.
Court calls case People versus Christina Evans.
On behalf of Pittsfield Township.
Good afternoon, Assistant Public Defender Lauren Perry on behalf of Ms. Evans in the case ending in 0387.
All right. Yeah, the other one's set for arraignment. All right, Ms. Evans, can you unmute for me?
Yes,
All right, state your name.
Christina Evans.
All right, Miss Evans, On one of your cases, you're before the court on a misdemeanor citation that alleges that on or about December 11, 2024, the location of Gulfside Road in Pittsfield Township, Washington County, State of Michigan, that you drove while being unlicensed or obtaining a license within the last 3 years. You understand that charge, ma'am?
Yes.
That's a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. You understand that?
Yes.
All right. First question I have for you is, do you want to be represented by an attorney?
Yes.
Okay, this is a public defender case.
The public defender Lauren Kearney on behalf of Ms. Evans, we waive any further reading standards to the charges. And Your Honor, I'm asking for an adjournment of both pre-trials.
All right. Then, defendant having waived formal reading, standing mute, court will enter a not guilty plea. I'll adjourn both of these cases to June 4th, 2025, 9 a.m. In the new case, the 1609, I'll set her bond at a $5,000 personal recognizance bond. All right, with standard conditions, including no assault behavior or possession of any weapons. All right? Okay, thank you, ma'am.
Thank you.
I said June 4th, right?
Yes.
Court does call the case of the People versus Chad Jones.
All right, so, township.
Arraignment pre-trial, Your Honor.
Arraignment pretrial. Chad Jones, not here. I'll issue an order to show cause.
Thank you.
All right. The next block is not for 1. All right, court stand in recess.
The District Court for County of Washington, State of Michigan is now back in session.
You may be seated. Court does call the case of the People versus Daniel Noggle.
Conrad Siller on behalf of the township.
And good afternoon, Your Honor. Brendan Bolsky appearing on behalf of Daniel Noggle. Mr. Noggle, please state your name for the record, sir.
Daniel Noggle.
You got a camera? Thank you. All right.
Got me now?
State your name for the record, sir.
Daniel Noggle.
Okay.
Your
All right,
Honor,
this is
today's the date.
arraignment and go ahead.
I was going to say today's date and time set for an arraignment and also a pretrial. As to the arraignment, wait formal reading and stand mute.
And in every way, formal reading, standing mute, court will enter a not guilty plea.
Thank you.
All right.
As it relates to the pretrial, Your Honor, Mr. Siller had sent me the discovery, and I received a link yesterday for the digital discovery. I haven't been able to review that yet, so we're just going to ask for an adjournment for me to review the discovery.
The next available date is May 21st.
Okay.
So I'll adjourn the matter to May 21st, 2025. 9 a.m. or your invite indicates, as to bond.
Your Honor, Mr. Noggle is 45 years old. He resides in Clinton, Michigan. He's gainfully employed at R&R Vehicle Sales. He's been there for over 3 years. He has no prior criminal history. He spent 1 day in jail on this. Right after he got charged, he retained counsel, and he voluntarily appeared for today's court date. I would ask for a personal bond.
It's a blood draw, Your Honor.
Yes.
121.
121.
No crash, traffic stop for failing to maintain lane integrity. No priors.
All right. Defendant's bond is set at a $15,000 personal recognizance bond. I'll order standard conditions, including no assaultive behavior or any possession of weapons or ammunition. You understand that, sir?
I believe I understand it.
What do you not understand?
Do I have to pay a bond or?
No.
Oh, okay.
I mean, I can make it so you do, but
No, I just don't understand, sir.
All right. Well, no, I'm releasing you on a $15,000 personal recognizance with standard conditions, no assaultive behavior or possession of weapons and ammunition. You understand that, sir?
Yes, sir.
There should be no possession of any alcohol, recreational marijuana, or any illegal drugs.
Okay.
All right? And I'll leave it there. I'm not gonna put a testing at this time.
Thank you, Judge.
All right, thank you. Let's call the case, People versus Jalen Powell.
Henry Score on behalf of.
Good afternoon, Assistant Public Defender Lauren Perry on behalf of Mr. Powell. Mr. Powell, please state your name for the record.
Jalen Powell. There he is. Okay, got it. Okay, what are we doing?
You and I haven't had contact with Mr. Powell. I would ask him to provide us with an update with his license if he can.
Our last report as of the 17th, he's still suspended.
Well, given that, I asked for an adjournment on Mr. Powell's behalf so he can try to get his license valid.
Are you still working on that, sir?
Yes, I'm currently working. I'm now employed, and I couldn't text her back because my other phone is broke. So I wish I could let her know what's going on, but I can definitely make a payment within this week, Friday.
All right, I'll let you guys figure it out. June 4th, 2025, 9 a.m. Fine, continue. Thank you. Court calls the case, People versus India Robinson.
Henry Score on behalf of the township.
Assistant Public Defender Natalie Pate with and on behalf of Ms. Robinson, who should be present via Zoom.
Yes, ma'am. Good morning. Or afternoon.
All right, state your name.
India Robinson.
Thank you.
Thank you, Your Honor. There is a resolution in this matter to which my client will be accepting the offer extended of pleading to added count 2 of allowing an ineligible person to drive, and in exchange, count 1 will be dismissed.
That's correct, Your Honor. So I moved to add MCL 257.326. You accept that guilty plea and move to dismiss the original charge.
Ma'am, please raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth so help you God?
Yes, sir.
State your name again for the record, please.
India Robinson.
All right, ma'am, it is this court's understanding that you're going to plead guilty to the charge of allowing an ineligible driver to operate a motor vehicle. That is a misdemeanor punishable by up to 90 days, $100 fine plus court cost. Do you understand that?
Yes, sir.
Understanding that, you still wish to plead guilty?
Yes, sir.
And to that charge, how do you plead?
Guilty.
And you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, sir.
Because of that, you're giving up certain rights. You're giving up your right to call witnesses to speak to you at trial or to have this court compel their attendance. You're giving up your right to see, hear, and question all witnesses against you at trial. You're also giving up your right to be a witness for yourself or to remain silent, not have that silence used against you. And you're giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt. Do you understand that?
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily and of your own free will?
Yes, sir.
And also because you believe that you're guilty of this offense?
Yes, sir.
On the date of March 18th, 2024, at the location of Lower Road in Pittsfield Township, Washtenaw County, State of Michigan, did you have custody or control of a motor vehicle?
Yes, sir.
Did you allow someone who was otherwise ineligible, inclusive of yourself, to operate that motor vehicle?
Yes, sir.
All right, counsel, have I complied with the court rule?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. Ma'am, anything you want to say before I impose sentence?
No, sir.
Fines and costs of $250. I'll suspend 90 days in jail. When can you get that paid, ma'am?
I actually spoke to my attorney and asked if it was an alternative for us.
Yes, Miss Robinson did ask me, Your Honor, to make a request that if she would be allowed to do community service. I did advise her that typically this court orders the fine, but I'm asking if the court would consider allowing her to do possibly even 40 hours of community service instead of the $250 fine. But we do understand that would be imposed and would ask for 2 to 3 months for her to pay it if that is what the sentence of the court would be.
Court is going to order the $250. I'll order at this time that be paid by May 31st or May 30th, 2025.
Thank you.
90 days in jail is suspended. Thank you.
Thank you.
Thank you, Your Honor. Thank you, Ms. Robinson.
Court calls the case, People versus James Shaw. The
Conrad
floor.
Silva on behalf of Pittsfield Township.
Good afternoon, spokesman Lauren Perry on behalf of Mr. Shaw. Your Honor, Mr. Shaw has given me permission to admit to double parking on his.
Your Honor, I move that count to double parking. If you accept the admission, dismiss the original charge.
On behalf of your client, you admit responsibility to the fact that on June 20th, 2023, at the location of Ellsworth Road, Pittsfield Township, Washtenaw County, State of Michigan, that he double parked a motor vehicle.
Yes.
Court will accept that admission to count 2. Count 1 is dismissed. Fines and costs of $180. When can that be paid?
I would ask for 4 weeks, Your Honor.
May 30th, 2025. Court calls the case People versus Kerry Vickerson.
Conrad Silva on behalf of Pittsfield Township.
Good afternoon, Assistant Public Defender Lauren Perry on behalf of Mr. Vickerson. You should be on Zoom, Your Honor.
Yes, I am.
You got him?
Yeah.
All right, what are we doing?
Your Honor, we are asking for the adjournment of this case. Mr. Vickerson has a key, a ticket out in 14B that he suspended. I did send him that information and he's working on getting that, resolved.
Adjourn it June 4th, 2025, 9 a.m. Whereas you're invited to case. All right, thank you, Mr. Vickerson.
Yes, Your Honor, thank you.
Court does call the cases of the People versus Juwan Wilson.
Conrad Silva on behalf of Pittsfield Township.
All four
cases.
Yes, sir.
Good afternoon, Assistant Public Defender Lauren Perry on behalf of Mr. Wilson. Please state your name.
Juwan Wilson.
Yeah, we have a resolution that involves all 4 cases. Do you want to put on the record? Mr.
I will, Your Honor. In case 0893.
Okay.
With the guilty. It's approved for the tax.
Deferred.
Okay. In case 0570. Count 2 of double parking.
0570.
Parking. You accept the admission and dismiss original charge. In addition, the 2 remaining cases will also be dismissed, 0569 and 2479.
And that is our understanding of the agreement.
Raise your right hand. Do you solemnly affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your name.
Juwan Wilson. All right. Sir, it is this court's understanding that you are going to be pleading guilty to the charge of retail fraud under the Pittsfield Township ordinance. Is that correct? Yes. Now, that's a misdemeanor punishable by up to 90 days, $500 fine plus court cost. Do you understand that? Yes. All right. Understanding that, you still wish to plead guilty? Yes. And to that charge, how do you plead? Guilty. Now, you understand that by pleading guilty, you will not have a trial of any kind? Yes. You signed an advice of rights form, is that correct? Yes. Any question regarding any of those rights? No, sir. Please look at paragraph 5 on that form. Those are your rights which are a part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form. Yes. You understand you're giving up your right to appeal of right? Yes. Are you on probation or parole? No. Has anybody promised you anything other than what's been stated here today on the record to get you to plead? No. Anybody threaten you or coerce you? No. You're doing this voluntarily? Yes, sir. Of your own free will? Yeah. And because you believe that you're indeed guilty of this offense? Yes. On the date of April 19, 2019, location of 7,000 East Michigan Avenue, that being the Walmart store, what'd you do?
Put items in my cart, walked out without paying.
Okay, you just tried to walk directly out without paying?
I mean, I paid for some of them, but I didn't pay for all of them.
Okay, tell me what you did. You put stuff in your car.
Yeah.
You went through, was it self-checkout?
Self-checkout, yeah.
And
I didn't pay
what,
for
you
everything.
scanned some items, didn't scan others, and then tried to, so you skip scan.
Yeah, I skipped scan.
And you tried to walk out without paying?
Yep.
Store was open to the public at the time?
Yes, sir.
You didn't have anybody's permission to do that, did you?
No.
And these items you didn't pay for and tried to walk out, these were items that were offered for sale by Walmart?
Yes.
Counsel, have I complied with the court rule?
Yes, Your Honor.
Satisfied, Judge.
Court will accept the defendant's plea of guilty to that charge. In that case, and that being 0893. In the other case being 0570, sir. On the date of March 25th, 2019, location of southbound State Street in Pittsfield Township, Washington County, State of Michigan. Dealer met responsibility to double park your motor vehicle.
Yes, sir.
All right, court will accept that admission in that case. Cases ending in 569 and 2478, those are dismissed.
479, Your Honor.
24, what did I say, 8? Okay, 2479.
Thank you.
All right, so on the double parking, fines and costs of $180, when can you get that paid?
I could pay half of it today.
You can pay 90 today?
Yeah.
He's got 100. He doesn't want to give me the other 10. I'm just saying. No, don't say none. Just, all right, so you're gonna pay 90 today, then when can you pay the balance?
2 weeks.
2 weeks. Pay it by May, then I'll just indicate balance by May 16th.
Okay.
Okay. On that one, that'll take care of that case. Then on this case, is there restitution issues involved in this? No, but he's deferred, so we're trying to get the deferred on it. So defendant is referred on that case to probation for a pre-sentence investigation and report and consideration of deferred sentencing. Sentence in this matter will be May 14th? May 14th, 2025, 9 a.m. or you're invited to continue.
Thank you.
Thank you. Court does call the case of People versus James Raggett.
Conrad Silver on behalf of the township.
On arraignment. Your name, sir?
James Patrick Raggett III.
All right. Mr. Raggett, you are before the court on a misdemeanor complaint that alleges that on or about January 5th, 2025 at the location of Carpenter Road, Pittsfield Township, Washington County, State of Michigan, that you did operate a motor vehicle with a high blood alcohol content. You understand that charge, sir?
Yes.
That is a misdemeanor. It's punishable by up to 180 days incarceration, a $200 to $700 fine plus court costs. The court could order rehabilitative services or any community service the court deems necessary. Court could order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that, sir?
Yes, sir.
All right, my first question for you, sir, is do you wish to be represented by an attorney? Seriously?
Yes, sir.
So you heard me, you heard through that?
Yes.
You do wish to be represented by the attorney? It's the public defender.
Good afternoon, Assistant Public Defender Lauren Kearney, on behalf of Mr. Raggett. Is
Yes.
that correct? We waive any further reading, stand mute to the charges, and ask for another pretrial date, Your Honor.
And then having waived formal reading, further formal reading, standing mute, court will enter not guilty, present his behalf. I'll adjourn the pretrial in this matter to May 21st, 2025, 9 a.m. or as your invite indicate. As to bond.
Your Honor, the blood alcohol content was very elevated in this case, 0.317.
0.317?
Correct. Had to do with the operation of the vehicle at the movie theater on Carpenter Road. Center Mark.
Got it.
This child was present at the theater, but not in the vehicle.
Got it.
I'd request a personal bond and, standard conditions. Is the court inclined to give him a scram tether or?
I am inclined to.
He says he does have a scram tether. He's on probation out of what?
Black out of Washtenaw County.
Black.
Black. That's circuit
Who's the
court.
judge?
Perry.
Oh, on 15th District Court.
Yes.
It says he's on probation in front of Judge Perry. For, OWI.
That was
In their
destruction of property.
sobriety court?
No, I'm currently enrolled in Accountable Choices, as well as the Accountable Choices program as a result of the original sentence. And I'm currently on a scram tether that was a result of the incident January 5th.
It's not a drunk driving case. It's a MDO
Yeah, it was related to
building.
Yeah.
So you're on the scram as a result of what?
Violation of probation, because I'm on probation and they were notified of the case.
Of this case?
Yes.
So they put you on a scram tether?
Yes.
Oh, I see.
Did they say how long?
No, I have to go back June 19th.
Still gonna need an order, I think. All right. So I'm gonna set was there anything else on that, Mr.?
Nothing else, Your Honor.
I'm gonna set his bond at a $35,000 personal recognizance bond at this time. I'm gonna order standard conditions, including no assault behavior or possession of any weapons or ammunition. You understand that, sir?
Yes, Your Honor.
There's to be no use of any alcohol, recreational marijuana, or any illegal drugs. You understand that, sir?
Yes, Your Honor.
If I gave you a drug test, would you pass?
Yes.
You would?
Yes.
All right. I'm gonna have urine test one time random per month in this case. I'm gonna also order a scram, tether after 15th District Court tether ceases. So, sir, what I'm indicating is that if you come off of the current scram that you're on, you have to get a new scram. Yes, for this case.
I understand.
All right. 21st.
Thank you.
Thank you. Court does call the case People versus Todd Reberg.
Conrad Solar on behalf of the Township.
An arraignment. Todd Reberg. No response. I'll issue an order to show cause. Court calls case of the People versus Amy Schaffler.
Conrad Solar on behalf of the Township.
Schaffler. No response. I'll issue an order to show cause. Mallory Tyfel. Tyfel.
Conrad Solar on behalf of the Township.
I'll issue an order to show cause. Christopher Akron.
Conrad Solar on behalf of the Township.
It's an arraignment.
This is the show cause.
To show cause. For failure to appear.
Yes.
Okay. Your name, sir? Christopher Akron. Sir, you are before the court on a charge that alleges that on or about April 28, 2024, at the location of Platte Road in Pittsfield Township, Washtenaw County, State of Michigan, that you operated an unregistered motor vehicle.
Yes,
You
sir.
understand that? That's a misdemeanor punishable by up to 90 days and a $500 fine plus court costs. You understand that?
Yes, sir.
All right. First question I have for you, sir, is do you want to be represented by an attorney?
Yes.
Yes, sir.
All right, this is public defender.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Ecker, we would waive any formal reading, stand mute, and ask for an adjourned pretrial date, please.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea on his behalf. Pretrial in this matter will be adjourned to, I'm gonna go June 4th, 2025, 9 a.m. Going to set his bond at a $5,000 personal recognizance bond when under standard conditions, including no assault behavior, possession of any weapons. You understand that, sir? Sir. I'm going to order no alcohol, recreational marijuana, or any illegal drug. All right. We'll see you then. All right. Thank you, sir. Court does call the cases of the people versus Stephen Daniels.
All right, so on behalf of Pittsburgh Township.
These are show causes. They are. Stephen Daniels. No response. Bench warrants. Bench warrants will issue for defendant's failure to appear in each of these cases. Bond $5,000. I'll give a 10% privilege on it. Those warrants will issue immediately. Court does call the case of the people versus Vincent Lambert.
All right, so on behalf of Pittsburgh Township.
Vincent Lambert. No response. Bench warrant will issue for defendant's failure to appear. Bond $5,000. Give a 10% privilege on that. That warrant will issue immediately.
We have a second case, the same charge coming soon.
Coming soon. Got it. Maybe we'll get him in here on one of those. Huh? Court does call the case of the people versus the Lair person.
Henry Silver on behalf of Pittsburgh Township.
Lair person. This is a show cause you have?
Yes.
Oh, on the failure to pay. Bench warrant will issue for defendant's failure to appear. Bond $3,500, 10%. That warrant will issue immediately. Court calls case people versus Trey Roberson.
Henry Silver on behalf of Pittsburgh Township.
Trey Roberson. No response. Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of $3,500. I'll do a 10% privilege. That warrant will issue immediately.
All right. 14A District Court for County of Washington, State of Michigan is now in session. On the road side of this, for the court draw near, the Honorable Judge Simpson.
You may be seated. Oh, Miss Linda or Miss Light, who's? Okay.
Ellie says on behalf of the people, the people with any potential conflict between this honorable court and the public defender's office, but the people do not believe that there is such a conflict. Make this waiver and avoid it.
Thank you. Okay, Mr. Brown. Good morning.
Lauren Brown, Deputy Chief Public Defender. Your Honor, likewise, we do not believe that conflict exists. Honorable court hearing these matters. If conflict were to arise, our office would waive such conflict so that this honorable court could hear these matters.
Thank you. And the court for its part also does not believe there's conflict either in the court rules or the cases decided thereunder. To the extent a conflict does exist, the waivers, court will consent to hear the matters. Court does call the case of the people state of Michigan versus Willie Eugene Collins.
We're ready in that matter.
Good morning, Your Honor, Shalani to the people.
Lauren Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. Willie Collins. Mr. Collins, please state your name for the record.
Willie Eugene Collins.
Thank you. Your Honor, today is the date and time set for the probable cause conference. I've discussed with my client and misdemeanor offer which has been offered in this case. I have, with his consent, signed a device of rights plea form, and we also have the plea form here.
Okay, I need that. Plea form indicates that the defendant would be pleading guilty to the charge of use of methamphetamine in 1 year offense. Upon his successful plea, the felony charge count 1 would be dismissed. Looking at the form, that's the court's full understanding of the agreement.
As I understand, Your Honor, my client is ready to be sworn.
All right. Sir, please raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right. State your name again for the record.
Willie Eugene Collins.
All right. Sir, it is this court's understanding that you're going to be pleading guilty to the charge of use of methamphetamine. That is a misdemeanor punishable by up to 1 year incarceration and $2,000 fine plus court costs. Do you understand that?
Yes, sir.
All right. You understand also, sir, that while I'm taking your plea, I would not be your sentencing judge in this case, and you would be sentenced before Judge Barr in the 1482 District Court.
Yes, sir.
All right. Understanding all of that, do you still wish to plead guilty?
Yes, sir.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes, sir.
You had an advice of rights form explained to you?
Yes, sir.
And gave permission for your counsel to sign it?
Yes, sir.
All right. Do you have any questions regarding any of those rights?
No, sir.
You understand that by entering this plea that you're giving up your rights as contained in paragraph 5, your trial rights?
Yes, sir.
All right. You understand also you're giving up your right to appeal of right?
Yes, sir.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead to this charge?
No, sir.
Has anybody threatened you or coerced you?
No, sir.
You're doing this voluntarily and of your own free will?
Yes, sir.
And also because you believe that you're guilty?
Yes, sir.
July 26, 2023, at the location of 501 East Michigan Avenue in the city of Ypsilanti, Washtenaw County, state of Michigan, did you have methamphetamine in your possession?
Yes, sir.
Had you used it?
Yes, sir.
Did you know what you were using was methamphetamine?
Yes, sir.
Counsel, have I complied with the court rule? Would it be proper to accept this defendant?
People satisfied.
The defense is satisfied, Your Honor. Thank you.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 1482 probation. Sentencing in this case will be
10 a.m. before Judge Barr.
May 14, 2025. I'm sorry, 10 a.m. before Judge Barr.
Thank you very much.
Bond will continue. Thank you. Thank you, Mr. Collins.
I'll be in touch, Mr. Collins, okay?
Court calls the case of the people versus Chalice McLaughlin.
Andrew Children's appearing on behalf of
And Assistant Public Defender Tanaza Carey, Your Honor, on behalf of Mr. Chalice McLaughlin.
Sir, can you please state your name?
Chalice McLaughlin.
Thank you.
Judge, we respectfully request that this matter be set for preliminary examination, please.
All discovery is complete.
To our knowledge, Judge.
What the it makes sense. What? I don't know that they have to do a writ. You're not gonna have to do a writ on this. Bill will come get him or go get him, right?
So he's being housed there.
I think he's being housed in Saginaw, but not by Saginaw. We're housing.
I would, we could maybe just have an extra week, just in case.
We don't have a problem with that, Your Honor.
On the 13th, all right. Discovery is complete. I will set preliminary examination will then be set May 13th, 2025, 9 a.m. before me. That'll be in person. Bond will continue.
Thank you.
Thank you. It's 13th. No, it's the 6th at noon.
Correct.
All right. Thank you. Thank you, sir. Court calls the case, People versus Seth Priester.
If you ever to me,
This
Good
is
morning, Your Honor. Wendy Barnwell, P42505, on behalf of Mr. Seth Priester.
Priester, can you state your name, please?
Seth Priester.
Thank you. All right, what are we doing in this case?
Then I'll set it for an exam.
All discovery is complete?
Yes. I believe so. I have both electronic and paper.
There now, you have it.
I don't know. Just accepted the case 2 days ago. They just sent me the discovery yesterday evening. But I believe we have enough because I have,
Is all the discovery complete?
As far as the people know, Your Honor, there's a co-defendant in this case, just so the court is clear.
Co-defendant.
Also on today's docket, I have that as Devassier Henning.
Who's representing? You're representing him?
Yes, there's a conflict in the case, so.
So you're not representing him?
We're still the attorney, right?
Ms. Constantino did ask me about it earlier. She's in the court.
Where is she?
She's on today's docket. She might be with the client during the hallway.
Might be next year.
Where is she? She's so small. We were so, is she in the room or no?
No.
Okay. In speaking with her, were you under the impression she was also going to be asking for an exam?
She was not. She just got appointed, I think, like this morning, and she hasn't even gotten discovery or anything yet.
All right. Ms. Barnwell, you want an exam?
yes, Judge.
People have their witnesses available to 6?
We'll certainly try our best, Your Honor.
Preliminary examination in person, May 6, 2025, 9 a.m. before Judge Harry.
One split second, Judge. I'm not available on that day, Judge. I'm available on the,
Why don't we do this? Let me pass this matter briefly. Why don't you go talk to Ms. Constantino, since these are co-defendants? I would rather, if we can, through some judicial efficiency, get a date that this can be heard where both defendants can be heard.
okay, Judge.
All right. Mr. Priester, hang in there. And I'm going to pass your case for a moment. All right?
Yes, sir.
Thank you. Court calls the case, People versus Stephen Smith.
Richmond, Deputy People on all.
Assistant Public Defender Jay Bellinger, on behalf of Mr. Smith.
James Feifels, appearing on behalf of Mr. Smith in file ending with 5506.
No, I apologize, Your Honor. I'm on the rest.
Yes, sir.
Just in case you didn't know.
What are we doing?
Your Honor, I believe all discovery is in and we are asking the court to set these files for preliminary examination.
That is correct, Your Honor.
People have their witnesses available on the 6th.
We will try our best, Your Honor.
Preliminary examination in person, May 6, 2025, 9 a.m. before. Oh, joy. Okay, 12 p.m. That's before me. That's at 12 noon.
Thank you.
Found in these matters.
Thank you very much, Your Honor.
Court calls the case, People versus Arthur Herndon.
Apparently said on behalf of the people, Your Honor.
Folks, on the PD side, you're gonna have to make sure that that aisle is relatively clear so they can get through.
Good morning, I'm Rob Jekyll on behalf of Arthur Herndon. Arthur, state your name for the record.
Arthur Herndon.
Thank you.
You already said that? I'm sorry. Judge, today's a PCC. I met with Arthur last night. We had a long conversation. We want to set this matter for exam, please.
All discovery is complete.
Yes, Your Honor.
People have their witnesses available the 6th. Preliminary examination in person, May 6th, 2025.
Judge, briefly address bond.
As soon as I'm done.
Okay.
9 a.m. That is before Judge Perry. As to bond.
Judge, just very briefly, it's my understanding the bond's $50,000. This incident is between he and his significant other. I understand the situation. She came to where he was staying and an argument started. There was a no contact order between the two. He tried to get away saying there's no contact order. I'm not excusing some of his conduct, but the bottom line is, Your Honor, I just think this whole incident was provoked by the victim in this matter, who both of these parties are in juvenile court on another matter. And it escalated. And I'm just asking if the court would consider a 10% bond, Your Honor.
Response.
People have a strong objection. In this case, the victim wants to the residence, which her name is the only name on the receipt from her belongings. She was letting the defendant stay there. When she got there, he repeatedly punched her in the face with a closed fist. He then put her on the ground and kicked her. Then put one hand on her neck with blood pressure. She had trouble breathing. He also took her phone, which she believed was to stop people calling 911. The phone was then found on him when he was arrested. The victim was eventually able to get away from him, run to her car, where he followed her, punched the windshield, and also into the car. When officers arrived, he ran from them and had to be taken to the ground to be arrested. I just had extreme concern. She was transported to the hospital for a possible concussion. She had abrasions to her chest, her forehead, her shoulder, her lip, redness all over her neck, and then bruises days later from follow-up photos. This is an extreme act of domestic violence, and I'm great concern. And then he also has the child abuse case up in 22nd Circuit Court.
Judge, just very briefly, this whole incident happened over this child abuse case, Judge. And the fact of it is, she accused him when she found out, never mind, it's a long story. She took his phone. That's why he followed her, asking for his phone back. I know you've heard a lot of stuff. I'm just continuing to ask for a 10% bond. Before this had happened, before she had found out that she came to him, Judge, and the whole thing started when she argued with him. She would not leave. Granted, she was letting him leave in her apartment. She was able to live somewhere else. But again, it's not anything that he initiated, Judge.
The punching wasn't?
Judge, he was defending herself when she came at him with a knife.
Okay.
Your Honor, I also have concerns because in that child abuse case, she did report that there was past events of domestic violence that she did not report because she was scared of the defendant. So I have great concerns of their history and this.
Motion for bond reduction is denied.
Thank you.
Court calls case, People versus Danielle Hinton.
And is that on behalf of the people, Your Honor?
Okay. Ms. Burnwell? Really? Hinton?
Okay. Hinton.
Oh, there's no long lost Constantino. No, I'm telling you, Feaster said you were so short, I just wasn't seeing you. I'm just telling you what he told me. I'm telling you what he told me. Anyway. All right, that's right, Feaster, you deal with that. Okay. Hey, I'm just saying I'm just letting her know what happened. All right,
Just a record of this.
go ahead.
Should we
Go
put my
ahead.
appearance
I
now?
called the case.
Good morning, Judge Wendy Burnwell, P42505, on behalf of Miss Danielle Hinton, who's standing to my right.
Ma'am, can you state your name, please?
Danielle here.
Thank you. What are we doing on this case?
Your Honor, I don't have electronic discovery on this one. I have paper discovery.
We can get the discovery over to her probably by next week.
All right. Do you want an adjournment of this?
Yes, Judge.
All right, I'll need a green sheet. Probable cause conference in this matter will be adjourned.
I'm sorry.
You're not available May 6th?
Only in the afternoon, Judge. And she's out on bond.
So I'll adjourn this to May 15th. 2025, 9 a.m. bond continues. Thank you.
Thank you, Judge.
Thank you, Ms. Henry.
That's for the PCC, correct?
That is.
All right.
I'll need a green sheet. Form that matches your code. Court call the case, People versus Jacob, is it Brooks? Probably be mispronouncing that, but might be Brio.
That's a lot of people.
Sherilyn Foster Tucker on behalf of Jacob Bro.
Recognize the name with the spelling. Rachel McDuffie for the people on this matter.
Your name, sir?
Jacob Allen, bro.
It's pronounced Bro?
Bro, like B-R-O.
Yeah, that's what I thought you said. That sounds, okay, thank you.
And Your Honor, we're requesting a preliminary exam in this matter,
All right, and all discovery is complete?
to my knowledge.
People have their witnesses available on the 6th?
Your Honor, can I get the following week, actually? Sorry, I'm not
13th.
available on the 6th.
People have their witnesses available the 13th?
We'll try our best. Vincent?
Preliminary examination in person, May 13th, 2025, 9 a.m. That's before Judge Valvo. Bond in this case will continue. All right.
Thank you, Your Honor.
Thank you. Let's call the case of the People versus Jenny Lou. Oh, there she is.
Michael Getty, Assistant Public Defender on behalf of Ms. Lou, Your Honor.
Lou, can you state your name, please?
Yes, sir, Jenny Lou.
Thank you.
Your Honor, I have had a chance to speak with Ms. Blondie. There is a global resolution that I think, that I haven't been able to confirm that Ms. Lou's aware of, that would resolve this and, the other matter that both matters that are pending here. And I think there's already been a plea in a matter, in a misdemeanor matter. To the extent that I haven't had a chance to talk to Ms. Lou about it, I'd ask the court for a brief adjournment. I know there might be writ issues. I would be willing to do a week. I'll make sure I keep.
I can't do.
I understand, Judge. But I would, I'll make sure I keep this case so I can go visit her, at the correctional facility and go over this with her.
I don't even, it's gonna have to go to May 15th with the adjournment. I'll need green sheets.
Oh, I'm sorry. Yes, I'll do a green sheet, Your Honor. But I'll make sure I keep this case so I go see her.
So probable cause conference, May 15th, 2025, 9 a.m. Bond will continue.
Thank you. And I'll come visit you, next week, Ms. Lou, okay?
Are you already like on your way? Because it's gonna take a while for the visitation to go through.
Yeah.
So have you got the process?
Yeah, I know the process. I'll come visit you in person, okay?
You've already started the process though, sir?
Nope, but I will be able to get there very quickly.
Okay, so you won't be here next week. You'll be here in like 2 months. All right. Okay. Thank you, sir.
All right. Okay.
Thank you, Ms. Lou.
Thank you.
I'll go visit her. That's it. And I'll go through.
Court does call the cases of the People versus Kyle Burmeister.
People, Your Honor.
James Feifels appearing on behalf of Mr. Burmeister on the file ending in 5028.
And Assistant Public Defender Jade Bellinger on behalf of Mr. Burmeister on the remaining files, Your Honor.
Can you state your name, please?
Kyle Berman.
Your Honor, I believe we have an agreement of sorts with Ms. Zenda. We're asking the court to, one, adjourn for 3 weeks, two, modify bond to allow him to be released to inpatient treatment with a tether.
All you have to do is prepare an order. I'll sign that if it's agreed to by the parties.
Okay. So in that case, then we're asking, I believe 3 weeks would give us some time to hopefully negotiate a resolution.
Probable cause conference, May 15th, 2025, 9 a.m. Bond will continue.
Gotta give him a call. You can have somebody help you call them.
I did. So all the other. Pretty good. Thank you, Your Honor.
We'll get it
Thank you.
here in the next day or so
Constantino, have you talked to
on these two files.
the one that was for, the last finish my sentences, no longer around.
Yeah, well,
Okay, so you guys are ready on that? If I call, okay. Thank you. Court calls case, People versus Brendan Chrysler.
Your Honor, can we pass that a moment? I'm still waiting for him. He had some car troubles. Thank you, Your Honor.
Court calls case, People versus Eddie Gardner.
Richard McGuffin for the people.
What's her other case?
Good morning, Your Honor. Christina Costantino, appearing with and on behalf of Mr. Gardner, who is present and standing to my right. Mr. Gardner, please state your name for the record.
Eddie Gardner.
Thank you.
Judge, this is a date and time set for PCC. It's my understanding that discovery is complete to my knowledge, so we would be asking for a preliminary exam.
People have their witnesses available to 6. Preliminary examination in person, May 6, 2025 at 9 a.m. before Judge Perry.
Thank you very much, Judge.
Thank you. Bond continues. Court calls the case of the People versus Michael Hill.
That was for the P727, right?
James Fifelski on behalf of Michael Hill, who is approaching.
Hello, Your Honor.
Hello. State your name, please.
Michael Wayne Hill.
Your Honor, this is a first PCC. I'm still awaiting discovery, so I'm asking for an adjournment to May 15th so I can obtain that and review with my client.
You need all the way to May 15th?
It'd be helpful, just since I haven't received anything yet, so if the court can.
May 15th, 2025, 9 a.m. Bond continue.
Thank you very much, Your Honor.
Court does call the case, People versus Julia Sosinski.
That's the one for the people.
And James Fifelski on behalf of Ms. Szynski, can you state your name, please?
Julia Szynski.
Judge, we're still trying to get to the bottom of some discovery, whether it exists or not, but I've been asking, and I know the prosecutor's office has been trying to get it from MSP, but we don't have it yet. So if we can do one last adjournment for 3 weeks, I'm hoping they produce or they tell us that it doesn't exist, and then we can move forward.
Just so you're aware, Mr. Ivesky, and I know you're aware of this, I don't set it for attorney's convenience these dates. May 15th, 2025, 9 a.m. Bound continue.
Thank you very much, Your Honor. Talk to you soon. I'll give you a call and say or something.
Court does call the case, People versus Devin Gibson.
That's Your Honor, please, Brandon Bird on behalf of Devin Gibson, PA 3734.
Good afternoon, or good morning.
Good morning.
Your name, sir?
Devin Gibson.
Thank you. All right, what are we doing?
We'd like to set this matter for exam, Your Honor.
All right, you have all the, all right, you have all the discovery, sir?
Yes, Your Honor.
All right. People have their witnesses available to 6. All right. Preliminary examination in these matters will be set in person May 6, 2025 9 AM, that's before. At 12 noon, that's before me. Thank you. Ask around.
It's come to my attention that the defendant has made 80 calls to the victim since the arraignment using his pin and other pins. In these calls, no victim, but at first they talked about the crime that occurred here and he apologized. Also in these calls telling her what to do and say in court. So I have great concerns, given that he's contacting the victim from jail. Would ask his phone privileges be revoked.
Anything you'd like to say in that regard, Counsel?
No comment, yeah.
All right. Given that his monetary bond will continue, his phone privileges are hereby ordered revoked. Thank you.
Thank you, man.
Court calls case People versus James Balfour.
Good morning, Your Honor. Laura Willenberg on behalf of people.
Good morning again, Your Honor. Christina Costantino appearing on behalf of James Vackelpour, who is present via Zoom. He is coming from the KPEP facility. Mr. Vackelpour, if you're on Zoom, could you ask them to unmute you and state your name?
Pardon?
We have a dial.
There's an individual who's dialed in. Last four digits or last three digits are 465. Can you hit *6 and state your name?
James Vackelpour.
All right, that's it.
So just as date and time set for PCC, at this time, we would be asking to have this matter set for a preliminary examination. And given the nature of how discussions with the people and I have been going, we would ask if the court would consider setting this out a ways, perhaps to the end of May.
That's correct. No, second.
Like the very end of May, like May 27th would that be good?
That would work for the defense.
And discovery is complete, so set preliminary examination in person. That would be May 27th, 2025, 9 AM before Judge Fresh Hour.
Thank you very much, Judge.
Found continued. Thank you. Have they figured out what they're doing on their co-defendants? I can get Mr. Brewster.
I believe they're ready. I can give you, they have one other, then I should give them headings, which is how defendants.
Court does call the case People versus Kim Perkins.
Good morning, Your Honor. Tim Saxon on behalf of Kim Perkins.
Your name, ma'am?
Kim Renee Perkins.
Thank you.
Your Honor, this is a date and time for a PCC. We're asking for a preliminary exam date. I do have written and video discovery.
You have all the discovery, okay. People have their witnesses available the 6th.
I believe so. Well, we'll try our best.
Preliminary examination in person, May 6th, 2025 at 9 AM before Judge Perry.
And Your Honor, if I may make a bond reduction motion.
Go ahead.
Your Honor, I'm asking for the bond to be reduced to a PR bond. Ms. Perkins is here on an allegation of assault and battery with Bridget Williams, her daughter. What I've seen so far in this, at worst, this was a mutual combatant. Ms. Perkins' top was torn off. She actually called 911 first, and then she wound up being arrested. The alleged victim also called 911. So this is not a foregone conclusion that she was the aggressor or would be a further problem. She has secured housing with her other daughter in Port Huron, so she does not need to go back, except for one time with a police escort to get her wallet and a couple of clothes. And she assures that she will be able to attend all future hearings.
Response?
Your Honor, I want to be clear, this is not a matter of assault and battery. This is a case of alleged felonious assault where the victim, Ms. Perkins' daughter, alleged that Ms. Perkins argued with her, fought with her, and tried to stab her with a knife, as well as scratching her face in the course of that incident. I appreciate that she has somewhere else to live. I would,
Hold on a second. Do they live together?
The victim in this case was apparently allowing Ms. Perkins to stay with her at that residence. And Ms. Secretary.
Okay, so they live together. All right, go ahead.
I would ask that bond continue. If the court sees fit to release her, I will request that she have a top zone taken to this location. Additionally, I believe that arraignment, there was a request made, I don't know if it's on this file, Ms. Perkins has a very long history of drug and substance abuse related offenses and convictions. At the time of this incident, she was highly intoxicated and incoherent as well. So I would be requesting that she was tested with all substances possible with some sort of overlink or other device as well, if she would be.
Ms. Sachs?
Yeah.
What I'm gonna do is I'm gonna grant the motion for a bond reduction. I'm gonna reduce her bond to a $2,500 personal cognizance bond. I will also indicate that the defendant is to report to community corrections upon her release for placement on a GPS hot zone tether. Since she's gonna be set for exam, I'm not gonna order testing at this time.
Thank you, Your Honor.
Court does call the case, People versus Cadavian White.
Amir.
Christina Costantino appearing on behalf of Mr. White. Mr. White, can you please state your name for the record?
Good evening, White.
Have a camera, sir? Thank you. All right, what are we doing on this case?
Judge, this is a date and time set for PCC. We would be asking for a preliminary exam in this matter. Discovery is complete as to my knowledge.
People would have their witnesses available the 6th. Preliminary examination in person, May 6, 2025 at 12 p.m. That's before me. Bond will continue.
Thank you, Judge.
Thank you. Court does call the case of People versus Diversier Hennings. If I'm saying that correctly. And I will also call the case of Seth Priester.
Christina Costantino on behalf of Mr. Henning. Mr. Henning, can you state your name for the record?
Devasier Henning.
Hello again. Oh, that took a lot longer than expected. Hope you're having fun. Yeah. I saw the X stream just randomly decided to knock it off, so I fixed that. Yeah, the youth and criminal docket. Fun times. And I've been listening in the background. And sorry for not being on the stream for a couple of hours, but I will probably be able to spend the next hour or so. But it's almost 7 p.m. here. I can go grab a beer.
Morning, Your Honor. Wendy Barnwell, once again, P42505 on behalf of Mr. Priester. I don't see him on the screen. I know he's in.
Right.
Now.
Could you unmute and then state your name, Mr. Priester? Seth Priester.
Oh, there.
Thank you. All right. What are we doing?
Judge, I was just appointed on this matter either late last night or this morning. Given that I do not have any discovery, at all, actually.
So you're ready to go.
I'm ready to go. Hey, you know what? I always ready. But given that, to ensure I'm representing my client to the best of my ability, I would be asking for an adjournment of the PCC so I can obtain discovery and review it with my client.
Counsel?
Yes, Your Honor, I will go along with Sister Counsel and I believe we'll return on May 15th is our proposed date.
I would say picking date.
Just only because I got it from you for the other case.
Yeah, I know, but again. Make it 30 out there, but.
Thank you, I will.
Ms. Constantino, will the 15th work for you?
Yes, Judge, I can make that work.
Probable cause conference, May 15th, 2025, 9 a.m. Bond will continue. I need green sheets on these, please.
Oh, I'm sorry, Judge, I do have it right here. Judge, would the court consider hearing a bond request, a bond reduction request?
I will always hear it.
Thank you, Judge. I'm told my client's bond is currently set at $250,000. We would be asking if the court would consider a lower bond, perhaps $100,000, 10%, with a 10% provision. He is 18 years old. He would be, prior to his incarceration, he had employment lined up at JMB Temp Agency. We are hopeful that he would be able to return or start that employment. He was also enrolled in an adult education GED course that he could continue. Should he be released, he would reside with his mother in Ypsilanti. She's very supportive of him. He has a significant other and a 2-year-old child that he does provide support for. It's my understanding that he does not have any prior adult criminal history, and he would be able to follow any and all no contact orders.
Prior adult.
Sounds from the people.
I believe it's correct that he doesn't have any adult prior history. This is the case with Mr. Christopher. He is currently charged as an adult. The history that I do see is that he apparently.
Mr. Henning.
This is your
Mr. Henning.
I apologize. Sorry about that. They're called together. I didn't. As far as Mr. Henning is concerned, Your Honor, obviously the circumstances of this matter, which would be a co-defendant in the armed robbery case, are concerning on their own. I will leave it to the court's discretion. I did want to ensure that if there's a no contact order on this case, that it does include Mr. Priester. I apologize for misspeaking earlier because the cases were called together, but Mr. Hennings does not have any adult history as was stated. His juvenile history does obviously include, not obviously, but includes some counts that were adjudicated in that manner, and he has had some felony charges that were pretty serious, I think, resolved with misdemeanors, unlawful breaking, and unlawful use of an automobile, breaking and entering, tampering with the tether. There's quite a bit here. So Ms. Constantino is correct that there's no adult history, but there's quite a bit of juvenile history here as well. That's concerning. Leading consistently going from 2020. Looks like roughly 5 or 6 cases up through 2025, which is dismissed in terms of activity.
Anything else?
Nothing, Judge. I would just suggest that $100,000 bond would, I believe, would account for even the juvenile history that's been mentioned.
I will, on Mr. Henning's case, I will reduce his bond to 100,000. I will not do 10%. It'll be 100,000 cash surety.
Anna, may I address one for Mr. Priester?
Apparently, yes.
So, Judge, I am pretty sure that, well, I'll rephrase it. I was about to say something. But my client's mother is present in the courtroom. He has been living with her. I know that he was attending a program, I believe, several days in the week over here at Community Corrections, Judge. I do believe that the bond is excessive. And I'm pretty sure that this court understands the concept of a presumption of innocence if the bond is excessive. Thank you.
Response?
So returning to the argument that I was beginning to make earlier, Mr. Brewster, in terms of the juvenile history that we have, obviously still juvenile state charges in the Belcher armed robbery case. It looks like there were 5 previous petition requests in the past year and a half. Unfortunately, those were denied due to some evidentiary issues, I believe. It looks like on the most recent case we have with him, which is the 2024 matter, he did have a plea for home invasion first, UBAA, receiving and concealing a motor vehicle, and financial transaction device theft. So I think we have a plea after that on a separate case for another receiving and concealing stolen property.
Are you saying those were all juvenile adjudications?
It appears to be so, yes. I think this is the first one where he's been charged in adult, if I'm not mistaken. The allegations in this case are not only armed robbery, apparently, that between the individuals involved in this, the victim was pistol in the face of the threat. So I understand that this is a juvenile situation, but obviously these allegations and offenses are very concerning. So I would request that.
Anything else?
Your Honor, as to cases that don't meet in the evidentiary threshold, so we still have a constitution that's very active now, and so I would ask, and this court knows, there's a presumption of innocence to this. I don't believe that counsel has brought up anything that's violent or anything of that nature. I respectfully ask that this court lower the bond significantly.
In this case, all those previous juvenile adjudications in this case, which I think are a distinction between his co-defendant, I am going to decline to reduce the bond in this case. Motion for bond reduction regarding Mr. Priestley is denied. Bond will continue.
Thank you, Judge.
Thank you.
Thank you, Your Honor.
Court calls case People versus Julian Ward.
Yeah, I can't stop thinking about my client is age 18 and he has no prior adult criminal history. Yeah, he might just haven't had the time. Has he been in jail since he turned 18? That could explain it all. I don't know. Well, he lowered the bond to 100,000. Still a hefty bond.
Ward. Yeah.
Christina Costantino appearing on behalf of Mr. Word. Sorry, Drew.
Julia Ward, present.
Judge, this is a date and time set for PCC. At this time, we would be asking to have this matter set for preliminary exam.
Okay, that's not. This coming.
So this is, the bonders, you wrote 2 emails, one asking for her bond back, a second one saying that she did try to respond back. So
That she did not.
correct, yeah, I think that's on the flip side. Yeah. So I don't think.
So you're looking for a preliminary examination in this case?
Yes, Judge.
And you said discovery is complete.
To my knowledge, it is.
People have their witnesses available to 6.
That is fine.
Preliminary examination in person, May 6, 2025. 9 a.m. before Judge Perry. And we'll continue.
Thank you, Judge.
Thank you.
Thank you.
Thank you, sir. Court does call the case of the People versus Stefan Scott.
Morning, Your Honor. Sam Bernstein with on behalf of Mr. Scott.
Your name, sir?
Stefan Scott. You're asking for a brief adjournment to review discovery.
Probable cause conference, May 6, 2025. That's a Tuesday, 9 a.m. Bond continued.
You can't move forward without all discovery. Thank you, Your Honor. Appreciate it.
Court does call the case People versus Marika Philpott.
Mike Gaddy, Assistant Public Defender on behalf of Ms. Philpott.
Philpott, can you state your name?
Who, me?
Yes, ma'am.
My real name is Teresa, but I do go by Marika.
Okay.
Oh,
We'll work with that. Okay, what do we do?
Your Honor, I have to ask the court to adjourn this matter. I do have a green sheet. I did seek to visit Ms. Philpott yesterday. She wasn't up for company.
Okay.
If I could approach.
Yes.
But I will go visit her again for the next hearing.
All right. I'll adjourn this matter to May 6, 2025, 9 a.m. That's a Tuesday. On continue.
And Ms. Philpott, I'll come visit you, but make sure you come up and see me, okay?
Okay.
Thank you.
All right. Thank you, Ms. Philpott.
Yeah. What the hell?
That's not the case.
Hold on, let me with you.
Clerk calls the case, People versus Anthony Taylor.
Yeah, sheriff personnel, beep. Yeah, you might want to be ready for your non-compliance. Yeah, welcome to Judge Simpson's court.
Morning, Your Honor. People.
Morning, Your Honor. James Fifelski on behalf of Mr. Taylor, who's to my right. Please state your name.
Anthony Taylor. Thank you.
Judge, I believe all discovery is in. We are asking the court to set this for preliminary examination.
Your Honor, may we approach briefly?
Why? Well, who's coming up?
Myself and Ms. Willenberg.
Okay, Ms. Willenbring's coming, then yes.
I do.
You may come up. All counsel has indicated all discovery is complete in this matter. And we were discussing dates. I'll set preliminary examination in person, June 3rd, 2025, 9 a.m. That's before me.
Thank you, Your Honor.
Round will continue.
Thank you, Your Honor.
Thank you.
I'll chat with you. I'm requesting to put it out. I'm trying to stop by and talk to you.
Huh? So cool. He's like, no, it's one of the ones with the big flat. It's no, it's gonna be, because you like those, so. You don't know? Oh, so if it shows up, you might like run out. Never mind. We'll talk later. Let's call the case. People of the state of Michigan versus Todd Emmerman. That would be fun.
I love this job.
Good morning, Your Honor. Jennifer Douglas for the people, P72748.
And good morning, Lord Yagi, Assistant Public Defender, sort of with, but mainly on behalf of Mr. Ammerman. Your Honor, Mr. Ammerman is on Zoom. I was just trying to be in a breakout room with him. My understanding is he's not in Your Honor Zoom. He's in Judge Freshour's Zoom.
Oh, that works.
It does not.
I know.
I don't know what's going on. I was,
Okay, all right, it's okay. Hang on. So what do you need to have happen? You need him to get to my Zoom.
So, Your Honor, I was going to ask for an adjournment anyways. I did fill out a green sheet. I would ask for an adjournment and to allow us time to get him in the right place and to get him here.
Not be able to communicate well with him to get out of their Zoom.
What's that? He won't get out of there.
They tried to send him but
So have you talked to him about signing into this Zoom?
I have not. I have attempted, but I have not been successful in
Okay, because Judge Fresh, our staff, I was just informed, are trying to communicate with him to get him to sign into the right Zoom. It's not going well. Yeah.
That does not surprise me.
Oh, okay. Appreciate your candor.
I really don't know what is going on, but,
Shaggy, I'll let you out the hook.
Thank you.
Is there any objection from the people to the brief adjournment?
Your Honor, there's no objection. I don't have any information that suggests that we're doing anything.
All right. I mean, he theoretically, I guess, is next door, so he. All right. It's when we go. Can you explain this to him in a week?
I will do my very best.
All right. Probable cause conference, May 1st, 2025.
Thank you, Your Honor.
You're welcome, Ms. Aggie.
Oh, that was funny.
Court calls case People versus Quentin Williams.
Alexander, on behalf of the people, Your Honor.
Morning, Your Honor. Wendy Burnwell, P42-505, on behalf of Mr. Quentin Williams.
Your name, sir? Quinn Williams. Thank you.
Good.
Okay, what are we doing?
I'm requesting an exam, Judge,
All discovery is complete?
upon information and belief. I believe so.
What's that mean?
I have electronic as well as paper discovery, Judge.
That's a decent effort.
You're not available the week of the 6th, right?
One split second, Judge.
Well, you just looked it up before and said.
Yeah, I have to look at the actual thing.
Go for it. I was trying to be nice.
I'm available on the 5th.
Okay. But we won't be here on the 5th.
Oh,
Well, I'll be here, but we won't be holding exams on the 5th.
okay.
It's the 6th or the 13th?
One split second, Judge.
I know the answer. It's gonna be the 13th. Because you're not available the 6th because we've already gone through this. But that's okay, I'll wait.
Donna, can you guys do it on a Friday?
Can I do what?
I'm available on the 9th of May.
Okay, good.
I'm in jury trial on the 13th,
Okay.
so I don't want to call that.
We do exams every Tuesday.
Okay. The 20th. Come on now.
People have no objection to that.
When I'm available, guys, I'm in trials.
Preliminary examination, May 20th, 2025, 9 a.m. That's before, please. Judge Barr.
Available there.
We'll continue. Thank you.
Okay.
Thank you.
All right.
Court calls the case, People versus Cody Jolly. Zoom.
Mayor Childers appearing on behalf.
Here's Cody Jolly from inside the cell, it seems. Or if the guard is in the cell and the inmate is outside. Nah.
Yes. Did you ever have any luck? Oh. No. I'm sorry, no.
Mr. Jolly?
Yeah.
He's unmuted. Well, he's muted, so I can't. Mr. Jolly, can you hear me?
Jolly.
No, he hasn't been up. Is he responding at all to us?
No, Your Honor, he's just sitting there.
Okay. What are we gonna do on this?
What I can tell the court, there was discussions between myself, Mr. Jolly also has cases pending in 15th District Court. Prosecutor there had spoken with jail staff about possibly getting a petition if the CNH worker in the jail. That does not appear to be something done. What we then tried to do, or are in the process of trying to do, is work out a plea with Mr. Jolly. Mr. Chabalowski, who's the 15th District Court prosecutor, and Mr. Gaddy Mr. Gaddy just kind of going as scanned by counsel, attempted to go to the jail and speak with Mr. Jolly, I believe last week or the week before, but there was an issue with actually getting him to come up and speak with them, so they weren't able to facilitate any conversation about any sort of resolution.
Actually, yeah, Your Honor, Mr. Chablowski and I, Mike Getty from the Public Defender's Office, Judge Perry had, he has not asked for standby counsel, but just in case he changes his mind while he's talking to the prosecutor, she asked if I would go, and I agreed. And we tried to go down, it was not a good time for the jail, so we're planning on doing it later this week, and we haven't had a chance, we're hoping to go tomorrow.
Okay.
So we did attempt to see him, but he didn't refuse us, but, I mean, to be candid, he's refused everything else.
So what do you wish for me to do?
I'm merely a reporter in this.
Yeah, I know, I got you. Well, until we can figure something out, I mean, this is sort of at a standstill. I mean,
I guess at this point, we'll give them another chance to see if we can have some sort of conversation.
That's fine. So what I will do, I think, haven't we sent him for comp already?
Found competent, although the thing that struck me about that is that CFP relied on their earlier finding of competency, having not seen him for all.
Correct. So, all right, I'll adjourn the probable cause conference in this case to May 22nd, 2025, 9 a.m.
Thank you.
Bond continued. All right, thank you. All right, we're all set. Thank you, Lee.
Thank you.
Court calls the case People versus Byron Blair.
National Law for the People.
Honor, Alexis Pluma appearing with and on behalf of.
Hey, Brain Socks over at Rumble. $5 in Rumble Rant saying just arrived. Thanks for streaming. A little support. Thank you so much, Brain Socks. That is so nice of you. Thank you so much.
Mr. Blair, who is approaching. And Mr. Blair, could you state your full name?
Byron Blair. All right. I have before me a plea form. Indicates he would be pleading guilty to the charge of retail fraud, second degree, the 1-year offense. Upon a successful plea to that charge, count 1, retail fraud, and the first would be dismissed.
Yes, that is correct, Your Honor. I have gone over that offer with him as well as an advice of rights, which should be in the file as well.
All right, very good. May I have him sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your name.
Byron Blair. All right. Sir, it is this court's understanding that you're going to plead guilty to the charge of retail fraud in the second degree.
Yes.
That is a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. The fine could be increased to 3 times the value of the property taken. If that's greater than $2,000, that would become the maximum fine. You understand that?
Yes, sir.
All right. You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Valvo in the 15th District Court. You understand that, sir?
Okay.
Okay. Understanding all of that, do you still wish to plead guilty?
Yes.
Are you sure that's what you want to do?
Yeah. You scared me like, who was Valvo? I'm sorry. You like, are you sure?
Like, who is Valvo?
Talked about the
Oh, she's the
judge
chief
in
judge of the 15th
15th
District Court.
in downtown Ann Arbor. So remember, Judge Simpson is not going to sentence you.
Oh, I got you.
Okay, where you got me for? Where are you telling me?
No, I understand what she was saying.
the way you said it was like I was just imagining the executioner or something like. Oh, I'm scared for a minute, like, who is Valvo?
Oh, so you
Like-
thought Judge Valvo was an executioner?
Yeah, like you know it's not gonna be me.
No, I'll call her today and let her know.
No,
No, I mean, I just to share that information.
No, sir, I'm sorry. Okay, I'm sorry.
Wow, and of all the judges. say that. Okay, you're clear now. I'm just taking your plea. You would have the right to have me sentence you, but I need you to understand that this case is set not to be sentenced, that I would not do the sentencing.
Okay, I got you.
You got it?
I got
you. You okay with that?
Yes, I'm cool.
Okay, so understanding all of that now. Do you still wish to plead guilty to
Yes,
the
sir, I
charge?
do.
You do?
Yes,
All right,
yes,
and
sir.
to the charge of retail fraud second, how do you plead?
Guilty, sir.
All right, now you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, yeah.
All right, you signed an advice of rights form, is that correct?
Yes, I did.
Any question regarding any of those rights?
No, sir.
Look at paragraph 5, you'll see a copy on the podium there. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, yes.
You understand you're giving up your right to appeal of right.
Yes, I did.
Are you on probation or parole?
I just got on probation on the 11th in Detroit. Yeah.
So you're off, you're not under the jurisdiction of any court at this time?
I'm on probation. No.
He's on
No,
probation
I
out
just
of
took
Wayne
probation.
County.
I'm trying to get all of my stuff together. I've been on.
I don't know what that meant. Counsel?
He was not on probation or parole at the time of the
No.
offense. He has now recently been sentenced to
Thank you.
probation.
Yeah, for old case, 2020 or something.
All right. Has anybody promised you anything other than what's been stated here today to get you to plead to this charge?
Nope.
Threaten you or coerce you?
No, sir.
You're doing this voluntarily?
Yes, I am.
Of your own free will? And because you believe that you're guilty of this offense?
Yes, I do.
June 1st, 2024, at the location of 303 South State Street, City of Ann Arbor, Washtenaw County, State of Michigan. Tell this court what you did on that date involving the M-Den store that makes you believe that you're guilty of this.
I exited with some items, but they got returned back, some Jordan shirts, a couple hats or something like that.
Okay, so you went into the store.
Yeah, I exited. Yeah, I didn't pay for it.
Okay, I got it. So you went into the store, you took property that
that
the store had for sale.
Yes.
They were open to the public.
Yes, yes.
And you tried to walk out of the store
Yes, I
without
did.
paying for that.
Yes, I did.
Is that correct?
So,
all right. And you didn't have anybody's permission to do that?
No, I didn't have nobody.
All right. Was the value, is this on value or prior?
Value.
All right. So was the value total of the property that you tried to take out of the store, was that in excess of $200?
Yes, it was.
All right, counsel, have I complied with the court rule, and would it be proper to accept this defendant's plea?
People are satisfied.
Defense is also satisfied.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. The pre-sentence investigation and report is ordered through 15th District Court probation. Sentencing will be May 20th, 2025, 9 a.m. before Judge Valvo.
Okay.
Judge Valvo. Not execution.
I know.
All right.
And Your Honor,
I'm going to call her though.
may I briefly address bond?
Yeah, go ahead.
Okay. Your Honor, we're asking the court to consider a personal bond for Mr. Blair. The reason that bond is set high on this file is because there were a couple of failures to appear in the past. Mr. Blair has explained that those failures to appear were due both to him being in and out of the hospital. He does suffer with congestive heart failure, and that's one of the reasons he would like to be out of custody to continue his medical treatment, as well as going back and forth between this county and the Wayne County Jail. He has now resolved all of his cases in Wayne County. I don't see that he has any out-of-county holds. He was recently placed on probation in Wayne County, so he's a little worried about picking up violations and not getting the programming aspects of his probation completed because of being in custody here. If he was released, he would be going back to the Delanis Center to live for right now. He is participating in their Pathways program. He has a caseworker there as well as a CMH caseworker that he's been seeing in the jail. He did provide me with their contact information. And he does have a phone, so we'll be able to reach him. He just wants the court to know that he did not mean to miss his court dates, and would like the court to consider allowing a personal bond. His other cases in this county are retail frauds. They all have very low bonds set right now, just so that he was getting credit while this case was holding him. I do believe his other cases in 15th, he would get a.
Please go on.
I'm sorry. I do believe his other cases in 15th would revert to personal bond if he was given a personal bond on this case.
Any response?
Your Honor, this is one of 5 pending cases, only the defendant right now. They're all retail fraud. Yeah, I'm concerned with, I understand he's saying he was sick, but he did have, I think, at least 3 bench warrants in this case. So I'm gonna request that bond continue at least until the time of the TSIR.
I tried it. I was in the hospital. And then one time y'all pulled it back because y'all had me mistaken. Oh, can I talk?
You were in the hospital. You were going back and forth between Wayne County and here.
I called your office up here, and I was known that it was a mistake because y'all had me down as being in custody.
Y'all, that's me?
Not y'all. Okay.
Go ahead, bro. I'm listening.
The Washtenaw County court system, right?
Oh, that big y'all.
Okay, yeah. The big
Okay,
y'all.
yeah. Okay, go ahead.
Okay. It was a mix. Okay. One incident. I left here. I wasn't released from custody because I was picked up by Wayne County. I was held there, didn't Zoom. So when I get out of Wayne County on tether, I had a warrant for you instantly there.
Acting really, why are you nodding like, no, this is, no, go ahead.
Like this is crazy. I just been ping-ponging back and forth between Wayne County and Washington. So while I was in Wayne County, they never Zoomed me to come here. So when they kicked me out on tether, when I paid bond, I get out on tether, right? They say you have a warrant in Washtenaw County. For what? For not going to court. I said, okay. I come out here to Washtenaw County. I ended up in custody trying to figure out how to turn myself in. I come back up in here. Y'all set me another court date. Now guess what?
Y'all, that's it. Y'all.
The Washtenaw County court system.
Okay, go ahead.
Okay, now this is what happens the next time. I'm on tether. They cut my tether off because I was in here so long waiting to see you that my tether went dead. Now I got to go back to the new Wayne County jail, which is like backed up 2 to 3 weeks just to get out on tether. So by the time I get back out on tether, they had me another paper again to say you would now have another warrant in Washtenaw County for missing court. I'm ping-ponging back and forth. When I just got my tether off on the 11th, they called y'all Washtenaw County.
Y'all, all of us?
They called the courts up.
Okay.
They let y'all know.
I'm just trying to
because you gotta have a lien. You gotta have a lien when you get sentenced to probation. So I went in prepared to come in, right? And this and that. They told me, advisor release, take care of it when you get up here. So I got up here. I got with my caseworker. This, that. I'm supposed to be going to this transitional housing stuff set up. This and that. I made sure I had my house stuff set up here first. And then now I'm trying to see.
If I give you a PR, will you stop?
If you don't send me back to Detroit and ping pong me, yes. Whoever said that, yes. That's the first time I ever been able to talk.
No, I don't believe that for a minute. You are too good at talking. That to be your first time.
All right, sir.
Well, he's got other holds that are going to hold him in, but If you're asking me to reduce this bond, right now it's at 1,000 cash or surety. No, they said that the bonds that gave me, that it will convert into.
Oh, no.
So he wants a personal bond on this case because that would make it a lot easier to get personal bonds on his other Washtenaw County.
Oh, I got it. I was just ready to rule and he started talking again.
I think he did a great job.
He did a fantastic
Better than me.
job for the last hour.
Yes, Your Honor.
That's what?
He asked me if there were other holds, and I said yes.
And
4 other cases that.
four other cases, that's what you were saying.
Yeah.
Before we.
And I'll just put the course of information to you. I see a 2019 case, a 2022 case, a 2023 case, and a 2024 case.
Always somebody else's fault but his. But yeah.
Grant the request to reduce his bond. They'll set his bond at $1,000 personal recognizance bond. Thank you. You're welcome. Thank you.
All right.
Take care. And I've already sent a message to Judge Valvo. She's waiting for you. All right. Take care. Bye bye. All right. We got it.
Oh.
Court calls the case People versus Deshaun Clifton.
Your Honor. Assistant Representative Dr. on behalf of Mr. Clifton.
That was for the people?
And Your Honor, we're going to be requesting an adjournment. Mr. Clifton, can you state your name?
Deshaun Clifton. Thank you.
And Your Honor, we're going to be requesting adjournment of the PCC in order to receive some outstanding media discovery of the dash cam and body camera. I have prepared a green sheet.
Okay, you have a green sheet?
I do.
Objection. Public cause conference will be adjourned May 15th, 2025, 9 a.m. Bound continued.
Your Honor.
Thank you. Case People versus Zachary Bruno.
Richard McDuffie for the people. Assistant Public Defender Hannah Apple appearing on behalf of Mr. Bruno. Mr. Bruno, will you state your name for the record?
Zachary Bruno. Thank you.
Your Honor, we're asking that this matter be set for a preliminary exam.
All discoveries complete.
To our knowledge, yes.
People have their witnesses available to 6. Pardon?
You will try it.
Preliminary examination in person, May 6th, 2025 at 9 a.m. before Judge Perry. Bond will continue.
Thank you.
Oh, did I pass it? I thought he was on his way. Court, let's call the case. People versus Antonio Cornelius.
And good morning, again, Laura Yagi, Simpson Public Defender, with and on behalf of Mr. Cornelius, who's approaching. Can you say your name for the court?
Antonio Cornelius.
And Your Honor, we would respectfully ask for this to be set for exam.
You seem to be doing better than your last case. Okay. Discovery's complete.
To our knowledge, Your Honor.
All right. People have their witnesses available on the 6th. Preliminary examination in person, May 6th, 2025. 9 a.m. Sorry. 12 p.m. 12 noon. Before me. Bond will continue.
Thank you, Your Honor.
Thank you. Calls case People versus Gregory Davis.
Richard McDuffie for the people.
And that is me again, Laura Yagi, Simpson Public Defender, with and on behalf of Mr. Davis, who is approaching. Mr. Davis, could you say your name for the court?
Gregory Davis. Thank you.
Your Honor, this has been postponed a couple times, and we were trying to see if we could consolidate it with a case that we were told is upcoming. That case
has not been charged or authorized. So we are asking for an exam date at this time. In terms of discovery, I did request a 911 call back in March. We don't have it, but I don't want to keep waiting. Mr. Davis is held in jail on this, and so I can't keep adjourning it just for that.
People have their witnesses available to 6.
We will try our best, and Michelle, yeah, that was sent that 911 call to you a few weeks ago, so I will check on that again.
Thank you.
Preliminary examination, May 6, 2025. 9 a.m. before Judge Perry.
Your Honor, may I briefly just address bond?
Briefly.
Okay, this is one of two cases that are holding him, or he has 1 or 2 cases out of 14B. One is just traffic, one is DV. He has done over 50 some days on the DV 14B case. He was set for final settlement tomorrow, but then he was removed from the docket because they didn't know he was in jail. And somehow he had just been sitting with that outstanding warrant without being arraigned on it. He is now set to go to 14B on Monday. And obviously, I don't know what they're going to do, but I would ask if the court would consider lowering his bond. It's a $5,000 cash surety right now. I would ask for a 10% provision to be on there, because just in case they do give him a personal bond in 14B, which I'm very optimistic that they will, because he's done so much time on that case as it is. He has a job at Cracker Barrel waiting for him. And just to be candid, Your Honor, I've been representing him. This is, I think, our 3rd PCC together. I've met with him several times. He's met with CMH in the interim. Personally, I've noticed a difference. When I first met with him, he was very loud, he was agitated. We had a really great conversation, and he actually thanked me for pointing out to him that he was so loud. He's met with CMH. He's been so genuinely reflective since. And I really mean that. I don't say that, as Your Honor knows, I don't say that about all clients. So I think he's really done a lot of reflection. And so I would ask if the court would consider a 10% provision.
Response from the people?
Your Honor, I can't speak to what 14B is going to do. Obviously, Mr. Davis's case, the issue that we have with Mr. Davis, I think, is primarily the fact that he had a case pending for exam. That case did end up being dismissed at this point because we had a witness that was not available, an officer that was going to be going for quite some time. One of Mr. Davis's cases was pending. We had a new incident where he showed up to that victim whose mother's house, was trying to get in and said, we have NDOB on that case. We have some bond concern, obviously, there. The domestic violence case, I don't believe is related to some of these other incidents. The new warrant, I've heard, we do not have a response back on that further yet, but that is a completely unrelated UDAA allegation as well. Mr. Davis, should he be released? I'll leave that to the court's discretion. I do know that Mr. Davis has, I can appreciate that Mr. Davis has been improving. I think that maybe because he's had a chance to essentially detox. I know that he was under the influence of apparently narcotics at the time of this incident. And Mr. Davis has a warrant out of the 35th District Court for controlled substance possession. I don't know if he is aware that that is out there. He was arraigned on that on November 10th of 2024. And that bench warrant, was issued a few weeks after that, so November of 2024. So if he were to be released, I don't know if there's a testing work on this file. We'll be requesting that, obviously, in this history. And hopefully he'll be able to get that one as well.
Your Honor, may I respond very briefly? I just have to clarify something.
Okay.
Ms. McDuffie stated he went to the victim's address. He was on house arrest there. He was supposed to be there. So this is not a case where he returned to the victim's address against the court order. He was literally on house arrest there at the address with his mom, who they're saying is the victim. But he was supposed to be there. So I just have to clarify that for the record.
Are we done?
Yes, Your Honor.
Okay, I'm going to grant your request.
Thank you.
If mine will be set at 5,000, I'll give a 10% privilege on that. Thank you.
Thank you.
There's already no contact orders on this matter. I'm not sure what Ms. Jackson was referring to. We have a contact order with it. So
that is not true. He had a consensual contact order. We have to be clear for the record. It is not true that he had a no contact order. He was on house arrest there at his mother's address. He was allowed to have contact with her. He was supposed.
Is that Ms. Freeman?
It is Martha Freeman, yes.
Okay, what I have is, I have a no contact with her at this time.
With this case, not with the other case. Thank you.
Thank you for your
Thank you.
Okay. Thanks. Court calls the case, People versus London Dottery.
Very good.
Oh, boy.
Portia Feast, the first assistant public defender on behalf of Mr. London Dottery, who's approaching the podium.
Did you apologize to Ms. Constantine?
I did, Judge.
Did you?
Graciously forget.
Did she accept your apology?
She said she did. I
She
pray
said
she
she
did.
did?
Yeah, she said she did.
Okay.
So I hope she really did. She said she did.
Okay.
Thank you. State your name, sir.
London Battery.
Thank you, Judge. I have submitted the green sheet. We're requesting a 3 or 4th adjournment. We are undergoing mitigation, and I believe we're also investigating a potential motion.
How much time?
3 to 4 weeks, please.
Wow.
Whichever one is better for the court.
No.
I see how you snuck. Not picking my date. Just.
I know. I saw how you did that. May 20th.
Thank you, Judge.
2025. 9 a.m. bond will continue. All right. Oh, May 20th is 22nd.
The 22nd?
Yes.
Thank you, Judge.
Thank you, Miss. Court calls the case of the people versus Brian Gerard.
Michael Gaddy, Assistant Public Defender, on behalf of Mr. Gerard, Your Honor. He's approaching.
Your name, sir?
Brian Gerard.
Thank you. What are we doing?
Your Honor, I've had a chance to speak with the prosecutor and speak with Mr. Gerard. He'll be waiving his exam this morning. It's 24th. I have explained to him he has an absolute right to that exam. I believe that the people have agreed not to habitualize this matter. 24th.
Sir, you're waiving your right to preliminary examination? Gerard, you're waiving your right to a preliminary examination? Yeah. You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it?
Yes.
You understand that you'll not have that hearing, you'll proceed to circuit court for further resolution?
Yes, Your Honor.
People also waive their right?
Yes, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on count 1 with 2 following.
Your Honor, we'd waive reading, stand mute, ask court to enter not guilty plea.
Defendant having waived formal reading, standing mute to both counts, court will enter a not guilty plea. Pre-trial will be set for May 5th, 2025, 1:30, Judge Hammoud.
Your Honor, I believe he has other matters set with Judge Hammoud on the 12th. I don't know. Well, they'll just move him if he does. Thank you.
You're informing me of that because of why? You want me to give you the 12th?
I hate dead air.
What?
I hate dead air. No, the 5th is fine.
Okay, good. Thank you. Fine, continue. I cannot figure everything out. Court does call the case, people versus Gervais Drake.
And then I have people.
Assistant Public Defender Jay Volunteer on behalf of Mr. Drake, who approaches, Your Honor.
Your name? Gervais Drake.
Your Honor, we're just asking to set for exam at this time.
Discovery is complete.
To my knowledge, yes.
People have their witnesses available to 6. Preliminary examination in person, May 6, 2025. 12 noon, that's before me.
Thank you, Your Honor.
Thank you. Continue. Court does call the case, people versus Haley Gregg. Oh, she was still here.
I'm back. I couldn't get rid of me that easy. Christina Costantino appearing on behalf of Haley Gregg.
Your name?
Haley Gregg.
Judge, this is the date and time set for PCC. I was just appointed quite literally about 10 minutes ago. So given that, I would be asking for an adjournment of the PCC.
This is the only thing holding her?
No, Your
Honor.
Judge, it was my understanding that her only other hold was a Melvindale misdemeanor warrant, and Melvindale has indicated that they would not pick up on that warrant.
Well, I'm just looking, do you want 12 days out or you want 1 week? Because she's in custody. So I can do the 1st or the 6th.
Unfortunately, Judge, I'm in trial next Thursday, so I can't do next.
Can't do the 1st, so I'll set it for the 6th for PCC. It's a Tuesday.
I haven't looked at the 2,000 cash of surety bond on an RIO A and B cases.
That's what he told me.
I'm just trying to get her, I'm just trying to give her the quickest date I can.
Understood, Judge.
So if you're not available the 1st, I'll do the 6th.
That would be great, Judge. Thank you.
May 6th, 2025. That's at 9 a.m. All right, for a probable custody. All right.
Thank you, Judge.
Thank you.
Would also like to address bond. I know we've touched on it a bit. It's my understanding her bond in this matter is $5,000 with a 10% bond. It's my understanding of the circuit court matter that I think that people were mentioning a second ago. My client tells me she received a personal bond on that file at her last court date. She is 34 years old. She does have employment lined up should she be released. She would be working at a medicinal cannabis retail store. She would.
Okay.
She does.
Like she has a job at a liquor store. Go ahead. No, I'm kidding.
very important jobs, very important sector of our economy. She does have housing lined up as well.
Wow.
She would be
vouching for that.
she would be able to reside in the city of Ypsilanti with a friend. She also is on the housing list through Avalon Housing. She would be working with CMH. She, previous to her incarceration, was working with CMH and attended therapy at least 2 times a month. It's my understanding that the other holds out of Wayne, as mentioned, they would not pick up on. We'd ask the court to consider a personal bond. If the court is unwilling to do so, we would also ask if the court would consider release to treatment. She has indicated that she does think treatment would be appropriate for her at this time.
Kind of treatment.
Substance abuse treatment.
Cannabis store. No, I'm kidding. Go ahead.
Your Honor, at this time, we believe that her bond is appropriate. She does have multiple other matters pending. We would point out that the date of offense in this case is the day after she was on another case. I don't know if you remember Ms. Gregg from last time she was here. Your Honor, given that she picked up this case.
Because she had to drive, because she had to get away from here after she was released. So she just grabbed the car. Whose car did she grab? Allegedly.
Allegedly, Judge.
Allegedly, did she, it was the police car? No, what? Okay, never mind. My bad. No. She just took a car because she had to go. Allegedly.
Allegedly, Judge.
And she's already had a failure to appear on the RNO case back in February, so we don't think that a reduction of bonds.
If I may, Judge.
Go ahead.
Judge, my only response to that would be treatment, I think would be perhaps a great middle ground for her. She's indicated a willingness and a desire to obtain treatment. Certainly, I think with treatment there, the risk of failure to appear is significantly diminished.
If you prepare an order, I'll release her on a PR to treatment.
Thank you very much, Judge.
Your Honor, could there be a tether for to keep her in inpatient treatment at that case?
I don't know if she's going to need a tether. I mean, if she goes into treatment, no, I'm not going to do a tether on her. I'll just indicate that she can be released from treatment on a PR.
Thank you, Judge.
At this point, however, her bond will continue.
Thank you.
Court does call the case of the People versus Muhammad Farr.
Hey, Judge. Court shall fix the first assistant public defender on behalf of Mr. Muhammad Farr. Please state your name for the record, sir.
Muhammad Farr.
Thank you, Judge. We are still in the process of trying to get this matter resolved. We are requesting a brief adjournment so he can provide proof of his treatment to the prosecutor's office, and we can hopefully find a resolution, Your Honor. He is in compliance, as far as I can tell now. Last time we were here, you had him go drop, and he dropped and came back clean, Your Honor.
I have proof of treatment with me right now.
Okay, well, he's going to need time to review it.
Okay.
So you're looking for how much time?
Just a couple weeks, Judge.
Probable cause conference in this case will be adjourned May 6, 2025, 9 a.m.
Thank you, Judge. I'll provide that proof to Mr. Childers and try to get this matter resolved in that time.
All right. Thank you, Mr. Clark.
Yes, everything is still in place.
Okay.
Keep doing it. Thank you, Judge.
Court calls the case People versus Antonio Jackson.
As on behalf of people, Your Honor.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Jackson. Please state your name for the record.
Antonio Jackson Jr. Thank you.
Your Honor, we're asking that this matter be set for a preliminary exam.
All right. Discovery is complete.
To our knowledge, yes, Judge.
People have their witnesses available to set. Set preliminary examination in person, May 6, 2025, 9 a.m. before Judge Perry. Yes, Esteban.
Your Honor, I do want to make the court aware, in checking the defendant's jail calls, he has tried to contact the victim 33 times since arraignment. She's not picked up the phone, but he has been trying to call her 30 times.
Any response?
No, Judge.
Defendant's phone privileges at this time are revoked. Otherwise, we'll continue. Thank you. Yes, to these, and it's true. After the second time, why are you calling back? Never. Court calls the case. People versus Durantu Francis. That's who's on.
That's the line for people.
Good morning, Your Honor. Assistant Public Defender Tanazi Carey accurately on behalf of Mr. Durantu Francis. Ms. Francis, state your name for the record, please.
Mr. Francis.
Thank you.
Should the court should have a green sheet?
I do.
I think we did receive an offer today. We just need to relay it to Ms. Francis, and I think 2 weeks should be fine, Judge.
Public cause conference, May 22nd, 2025, 9 a.m.
Thank you, Your Honor.
Continue. All right, thank you, ma'am. Case People versus Sean Johnson.
And then we have you, Your Honor.
But Danny, Assistant Public Defender, Mr. Johnson, is in lockup too. He's making his way to the front.
Sorry. You're there. Johnson.
Your Honor,
state your name, sir.
Sean Michael Johnson.
Thank you. What are we doing?
Your Honor, we're asking you to set this for a preliminary exam.
Discovery is complete.
Your Honor, I have spoken with Ms. Zenda. There was some video. She says it's on her way to our office, so I'm confident.
And that's correct, right? There's a meeting, so it should be here by Monday. And if people did guess file appropriate.
Preliminary examination in person will be set May 6, 2025. Huh?
Yeah.
It's at 12 noon before me. That's the bound.
Your Honor, this defendant has tried to contact the victim 29 times since arraignment with one completed call, and this call he talks to their child, who then passes the phone to the victim. And in that call, he asks the victim for money from his account, and also tells her, you know, I'm going to prison, right? So I concern passing his phone privileges your vote. We'll be passing the jail to block that number.
Your Honor, I was made aware of this earlier this morning. I haven't had a chance to look into it. I guess I'd ask the court as an interim provision to block that number, the alleged the number of the alleged contacts, and not revoke the privileges. I believe the bond is currently set at 25,000, if I'm not mistaken.
If bond will continue, defendant's phone privileges are revoked. You can raise it if you find out something different at the time of this preliminary examination, but at this time they're revoked.
Thank you.
Court does call the case, People versus Lena Harbali.
For people.
Your Honor.
Mike Getty, Assistant Public Defender for Mr. Harbali, who's here to my right. State your name, ma'am.
Lena Harbali.
Thank you. Your Honor, we are requesting an adjournment to this matter. I have, we actually did submit a Zoom request, but Mr. Harbali was released from the hospital in time to be here today. So we are endeavoring to go to mental health treatment court. I have reached out to Mr. Graveline. I haven't heard back. Oh,
no, God.
Whenever someone does something, I always think it's me.
No.
We are trying to get screened for mental health court. There was a delay based on.
Okay, no, that's fine. Public cause conference, May 22nd, 2025, 9 a.m. All right, bond will continue.
Thank you, Judge.
Your Honor.
Thank you. Court calls the case, People versus Anderson Keller.
Good morning, Assistant Public Defender Dante Lebo, on behalf of Mr. Keller, who's approaching from my right. Mr. Keller, could you please state your name, sir?
Anderson Christopher Keller.
Okay, what are we doing?
We're here today for a competency hearing as well as a probable cause conference. I have received the competency report from the Center for Forensic Psychiatry and would be prepared to stipulate the results finding Mr. Keller competent.
Are you talking about the March 13th report?
Your Honor, I can double check the date on it, but I believe so. Actually, yes.
Are the people who received that report?
Yes, Your Honor.
All right.
We also stipulate the no further evidence.
Based on that report, the court would find that the defendant is competent.
Your Honor, with regard to the
court specifically would indicate that the defendant can understand the nature and object against him and can rationally assist in his defense. Therefore, the defendant is deemed competent. Do you have an order?
No, Your Honor, I can prepare one.
Okay. All right, what are we doing?
Your Honor, with regard to the PCC, we'd like to set this matter for preliminary examination, please.
You have all the discovery?
Yes, Your Honor.
You'll be able to have their witnesses available to 6?
I don't know, Your Honor. I'll try for that date.
All right. Preliminary examination will be set May 6, 2025, 9 a.m. before Judge Perry.
Thank you, Your Honor.
Courthouse case, people versus Brian Howell.
Testimony for people.
Your Honor, Constable Bass on behalf of Mr. Brian Howell, who is present to my right. Mr. Howell, can you state your full name for the record, please?
Good morning, I'm Brian Howell. I had before me a plea form. Is that what we're doing?
Yes, Your Honor.
Plea form indicates that he's going to plead to use of a controlled substance, the 1 year misdemeanor. Upon a successful guilty plea to that charge, count 1 would be dismissed. Well, hold on a second. He's also going to plead to counts 2 and 3 as charged.
That's correct, Your Honor.
So he's pleading to counts 2, 3, and 4.
Yes, Your Honor.
Correct, Your Honor.
And then, okay, and then count 1 is dismissed. That's the court's full understanding.
Yes, that's correct, Your Honor. And my client is looking to get into the drug treatment court over in Oakland County. He has spoken with them over there, but it's pending this plea so that we have to get this done.
So with this plea, he'll be able to get in?
Correct.
All right. I know we've been trying to do that. I have him sworn.
Right. Do you solemnly swear in affirm the testimony you're about to give? Do you solemnly swear in affirm the testimony you're about to give with the truth, the whole truth, and nothing but the truth? So help you God.
Yes, sir.
State your name.
Brian Howell. All right. Sir, it is this court's understanding that you're going to plead guilty to 3 misdemeanors. Is that correct? Yes, Your Honor. All right. First of all, that you're going to plead guilty to the stated count 2 of operating with your license suspended, denied, and/or revoked. That's a misdemeanor punishable by up to 93 days, $500 fine plus court cost. Vehicle could be subject to mobilization. Understand that? Yes, Your Honor. Count 3 also that you're going to be pleading guilty to is the charge of open intoxicants in a motor vehicle. That's a misdemeanor punishable by up to 90 days, $100 fine plus court cost, community service, and any substance abuse treatment. You understand that? Yes, Your Honor. And then also that you'd be pleading to the charge of use of a controlled substance. That's a misdemeanor punishable by up to 1 year incarceration and a $1,000 fine plus court cost. You understand all of that? Yes, Your Honor. All right. And you understand also, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Freshour in the 14A4 District Court. Yes, Your Honor. Understanding that you still wish to plead guilty to these charges. Yes, Your Honor. To the charge of driving while license suspended, denied, and/or revoked, how do you plead? Guilty. To the charge of open intoxicants in a motor vehicle, how do you plead? Guilty. To the charge of use of a controlled substance, how do you plead? Guilty. Now you understand that by pleading guilty, you'll not have a trial of any kind. Yes, Your Honor. You signed an advice of rights form?
Yes, Your Honor.
You signed an advice of rights form? Yes, Your Honor. Any question regarding any of those rights? No, Your Honor. Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights of that form. Yes, Your Honor. You understand you're giving up your right to appeal of rights? Yes, Your Honor. Are you on probation or parole? Yes, Your Honor. Were you on probation or parole at this time of these offenses? Yes, Your Honor. All right. Then I need you to understand your plea in this case could be a violation of that probation. And you need to understand that as such, that other court could sentence you to the maximum allowable under those other charges. You understand that? Yes, Your Honor. And understanding that, do you still wish to plead guilty to these charges? Yes, Your Honor. Has anybody promised you anything other than what's been stated here today on the record to get you to plead? No, Your Honor. Anybody threaten you or coerce you? No, Your Honor. You're doing this voluntarily? Yes, Your Honor. And of your own free will? Yes, Your Honor. And because you believe that you're guilty of these offenses? Yes, Your Honor. All right. March 17, 2024, at the location of M52 near Newkirk Road, Manchester Township, Washington County, State of Michigan. Were you operating a motor vehicle? Yes, Your Honor. At the time, was your driver's license suspended, denied, and/or revoked? Yes, Your Honor. And did you know that it was? Yes, Your Honor. All right. And while you were operating that motor vehicle, did you have open intoxicants in the motor vehicle? Yes, Your Honor. What'd you have? I had open Cowboy, which is open beer. Really? Like I didn't know, because I just crawled from under a rock. I get you. You had an open beer in the vehicle, right? Yes, Your Honor. Okay. And you knew it was there? Yes, Your Honor. All right. And it was yours? Yes, Your Honor. All right. And had you used a controlled substance on that day? Yes, Your Honor. What? Adderall. All right. Did you have a prescription for it? No, Your Honor. All right. And you knew what you were using was Adderall? Yes, Your Honor. All right. Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
Defense is also satisfied, Your Honor. Thank you.
Court will accept the defendant's pleas of guilty to counts 2, 3, and 4. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14 and 4 probation. Sentencing will be June 10th, 2025, 9 a.m. before Judge Freshour. Bond on this will continue. Mr. Howell, good luck to you, sir. Thank you, Your Honor. It's a pleasure. Thank you. Court does call the case of People versus Michael McLean.
And then we got the people, Your Honor.
Basically, on behalf of Mr. Michael McLean, who is present to my right. Can you say your full name for the record, Michael?
Michael James McLean. Thank you.
Mayor, today is the date and time set for probable cause conference. At this time, we'd be respectfully requesting to set this for a final setup. I'm sorry, not final summit, preliminary set.
Of course. The people have their witnesses available on the 6th. Preliminary examination in person, May 6th, 2025. 9 a.m. Is it 12? 12 noon. That's before me. Yes, that's the bond.
When I come to my attention, he has made 127 attempted calls to the victim since arraignment was 2 completed on 4/16 and 4/8.
How many?
127 attempted calls, 2 were completed. So I'd be asking that his phone privilege be revoked.
Oh. Response?
No comment at this time, Your Honor.
His bond will continue. His phone privileges are hereby revoked.
Thank you, Your Honor.
That was me. It's all set. Pause the case, people versus Zakaria Haruska Dennis.
Rich McDuffie for the people.
What?
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Haruska Dennis.
No, no. Doesn't matter, he's not here.
Just for the record, I'd ask for an adjournment. He did reach out earlier this week and left a voicemail. I attempted to reach out and follow back up. We are missing some outstanding discovery, but I don't have an answer for his non-appearance today.
Bench warrant will issue. Bond 10,000. Cash surety, that warrant will issue immediately for Mr. No. I'm telling you. Clerk calls the case, people versus Robert Mitchell.
Here with him on behalf of Robert Mitchell. Robert Mitchell.
Robert Mitchell. Thank you, sir.
To our knowledge, discovery is complete and we request the earliest possible exam date that the people can accommodate.
People have their witnesses available to 6.
We'll try, Your Honor.
Preliminary examination in person, May 6th, 2025. 9 a.m. Is it 9?
Yes.
Before Judge Perry.
Thank you.
Thank you, Don. Thank you. Thank you. Court calls case, people versus Anthony Johnson.
And on behalf of the people, Your Honor.
And Assistant Public Defender Jay Bellinger on behalf of Mr. Johnson, who appears to my right. Mr. Johnson, can you keep your name for record? Anthony Johnson. Your Honor, we submitted a waiver request on this.
So you're waiving your right to a preliminary examination?
Yes, sir.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes, sir.
You understand that you won't have that proceeding and to proceed to circuit court for further resolution.
Yes, sir.
People also waive the right.
Yes, sir.
Preliminary examination having been waived, defendants found over circuit court on counts 1 and 2 with 3 follow.
Acknowledge receipt of information, Your Honor. Wait formal reading, stand mute at this time.
Defendant have a waive formal reading, standing mute to all counts. Court will enter not guilty plea. Pre-trial will be set for
June 17th, 1:30 before Judge Compete.
June 17, 2025, 1:30 Judge Company.
And you're going to address bond briefly.
Okay.
It has come to my attention from the victim, she sent us a screenshot that the defendant has sent her a Facebook request, friend request. So that concerns he's trying to reach out and contact her.
Your Honor, in talking to my client, we have decided to address this issue head on. My client has an explanation for this that he would like to offer to the court.
Go ahead. Is he admitting to that? Is it Mr. Allen?
He is admitting to that, Your Honor. The explanation is, go ahead, if you want me to.
I can say it.
Okay.
It was a mistake. I pushed and remove and push add frame. That was simple. That's what I did.
Your Honor, he tried to eliminate the possibility of any contact. He saw that she popped up. He wanted to remove any possibility that he could have contact with her. That was his intentions. And
how did that even happen?
Just okay.
Big thumbs, Your Honor.
That was a mistake, sir. I admitted that.
He didn't intend to contact her. There's no allegation that he actually made contact with her. Like I said, he wanted to eliminate the possibility of that. He made a mistake.
In reporting the violation to us, I believe she told us that she had made an entirely new Facebook account, not using her name, and that was the account that sent a friend request to. She wasn't sure how he found that account, but he added her as a friend and she needed to report it.
Your Honor, the only thing I can provide is that when new accounts pop up, the suggested friends that pop up, he likely noticed that it was probably hers. He intended to remove it to eliminate any possibility of contact. He immediately, when he clicked that, he immediately went back and clicked remove, realizing the mistake, he blocked her. Again, there's no allegation that he actually had contact with her. He doesn't want contact with her. He understands that he's on bond, and he doesn't want to do anything to lose that. And
do not have or attempt to have direct or indirect contact with the above individual in person or through others by electronic communication, including but not limited to phone, email, texting, internet, or social media.
Your Honor, if it was not under her name, I don't know how he could possibly have also known that it was her definitively.
Then why would he have attempted to remove it?
Because the possibility that it could have been, I imagine. He advises that it was her face. So he wanted to.
He knew.
Well, Your Honor, he is just providing an explanation as to why he wanted to eliminate the possibility of contact. It did pop up. He did remove it. He's asking that the court. He didn't even block her. He is asking that the court take that into consideration. He's asking, we are pleading with the court to allow him to remain out on bond at this time. And he was, for what it's worth, honest with the court about that. He is taking accountability for it.
Anything else? Tell you not to have contact. He sees her face. He attempts to make contact with her. He can't violate the bond that way. Just plain and simple. Defendant's bonds revoked. Defendant's remain. Court case, People versus Bruce Pickens.
Hello, she nemesis. Get rated.
Stephanie Cannon on behalf of Mr. Pickens, who is appearing to my right. Mr. Pickens, could you please state your name for the record?
Bruce Pickens.
Your Honor, you should have a green sheet in your possession. I'm simply asking for a 2-week adjournment. A name request has been done for my client to see if we can get some mitigation.
Said 2 weeks?
Yes, sir.
I need 12 days. So I'll set probable cause conference in these matters will be May 6, 2025, 9 a.m.
Also see you before then, and you'll hear from our staff to try and get you some mental health and also start working on home.
Bond will continue. Thank you.
Thank you.
For you who are wondering what's going on here, we are watching Judge Simpson. I have recorded his entire week. I edited out all the breaks, the pauses, the silent moments, and now we are into hour 6 of watching it, and it is roughly 10 hours of. So we have 5 hours to go.
Case, People versus Marcus Jones.
Hey, Judge.
Hey, how you doing?
I'm good.
What's your feature first assistant public defender on behalf of Mr. Marcus Jones? Mr. Jones, please take your name for the record.
Marcus Jones.
Thank you, sir.
Thank you, Judge. I think we were here a couple weeks ago, which time Mr. Jones was in treatment. He is now out of inpatient treatment, out of the hospital, but he's going to be going back into a outpatient program. So my understanding is once he completes that, that might have an impact on the resolution in this case. So I'd ask for 3 or 4 weeks or more adjournment so we can get him going.
If I may, Your Honor, I did attempt to do I'm sorry. I did set an appointment for myself, but I missed it, so I had to reschedule another appointment. So I was planning on scheduling another appointment after court today.
Today. Okay. All right. Let's do this then. Let's see how you're doing through the program and everything. I'll adjourn it out to May 29th.
Okay. Thank you.
Okay. You're welcome. 2025, 9 a.m. Okay. You take care of yourself, young man.
Yeah, I'm making a call out. Okay. Thank you, Judge.
Court calls case, People versus Scott Reese.
People. Assistant Public Defender Hannah Apple appearing on behalf of Mr. Reese. Please state your name for the record.
Scott Reese.
Your Honor, people are going to file an early cross in this case.
Objection?
No objection.
Case is dismissed.
Ms. Dr. Johnson.
Okay, thank you.
You're welcome.
Thank you, sir. And then why were you like giving him the fist like you did something? You didn't know you did nothing. You did nothing. You did nothing.
That was Miss Apple's victory. You know what? Just don't even try it.
That's all what you're.
Court calls case, People versus Maurice Kihei. Or Kihei.
And then now we have the people, Your Honor.
And Assistant Public Defender Jay Bellinger on behalf of Mr. Cahey. Mr. Cahey, can you please state your name for the record? That's how you pronounce it, right?
Yeah.
Okay.
Maurice Cahey.
Cahey.
Your Honor, can you briefly approach?
Oh, boy. Bellinger, really? It's like every week. This is a problem.
Every week?
Yeah.
When's the last time I was at this bench?
Last week. Yeah. It was. GPS location. All right. Record, we had a brief lunch conference. You want to just put out a couple weeks?
We are asking for a couple week adjournment, Your Honor.
All right. I'll adjourn probable cause conference to May 15th, 2025, 9 a.m. I would indicate also that in reviewing the bond, and given some concerns, that defendant is to be placed on a GPS tether with a hot zone for the victim's address.
No, I believe the
Address.
Okay.
Otherwise, his bond will continue. So, sir, I need you before you leave the facility here to go over to community corrections to.
Yes, sir.
That all right?
Okay.
Right across the street.
Okay.
Okay.
Thank you.
When you leave here, it's gonna be the first field.
Okay.
Okay. Thank you, Your Honor.
All right, thank you. All right. Court does call the case, People versus Alan Reinhackle.
Thank you, Your Honor. Possible base on behalf of Mr. Alan Reinhackle, who is approaching to my right. Mr. Reinhackle, can you state your full name for the record, please?
Alan Gordon Reinhackle. Thank you.
Thank you, Your Honor. Today's the date and time set for a probable cause conference. At this time, we'll be requesting to set for the early state of preliminary exam.
All discoveries complete.
To my knowledge.
People have their witnesses available to 6. Preliminary examination in person, May 6, 2025 at 12 noon. That's before me. Thank you. Court calls case of the People versus Brianna Kingsley.
Andrew Choice, Brianna, on behalf of the people. Assistant Public Defender Jay Bellinger on behalf of Ms. Kingsley, who appears via Zoom, Your Honor.
Yes. Kingsley, can you state your name? I'm frozen up here. Let's look there. Frozen.
Looking good.
Brianna
No,
Kingsley.
hold on, Ms. Kingsley. We got to get the video set in the courtroom. What? My iPad?
Yeah.
My iPad's operating fine. Ms. Kingsley, can you say something?
Brianna Kingsley, hello?
Okay, yeah, she's, okay. I just need you to come to my screen, okay, but we're good.
Everything looks good.
Thank you. What?
Just turned your video off.
Something happened, okay, all right. I have before me a plea form, is that what we're doing today?
Yes, Your Honor, it's gonna be a no contest plea.
All right. I have a no contest plea to attempted unlawful use of a motor vehicle to 1-year offense, that being the count 2. And that count 1 would be dismissed. That's the court's full understanding of the agreement.
That's my understanding as well, Your Honor.
All right. Ms. Kingsley, can you raise your right hand, please? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes,
All right. State your name again for the record.
Brianna Kingsley.
All right, Ms. Kingsley, it's this court's understanding that you're going to plead no contest to the charge of attempted unlawful use of a motor vehicle. That's a misdemeanor punishable by up to 1 year incarceration, a $750 fine plus court costs. You understand that?
Yes,
Also, do you understand what a no contest plea is? Let me ask you that.
I'm not contesting the charges, but it's treated as a guilty.
Well, okay, you can look at it that way. 2 things I need you to understand about it, and that is that it means that you're not further desirous or wanting to contest this charge. Do you understand that?
Yes,
Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
yes,
All right. You also understand that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Perry in the 15th District Court. You understand that?
yes,
All right. Understanding all of that, do you still wish to plead no contest?
Yes.
Basis for the no contest plea?
Pure civil liability, Your Honor.
All right. So to that charge, how do you plead, Ms. Dixon?
No contest.
You understand that by pleading no contest, you will not have a trial of any kind?
Yes.
All right. You signed an advice of rights form or gave authority to sign the advice of rights form to counsel?
Yes, I gave authority.
All right. Do you have any questions regarding any of those rights?
No.
All right. Paragraph 5 are your rights which are part of a trial. You understand that you're giving up those rights specifically,
Yes.
as well as all the rights that are contained on that form. You understand that?
Yes.
You understand you're giving up your right to appeal of right?
Yes.
Are you on probation or parole?
I am, but I was not at the time of the offense.
Thank you. All right. Has anybody promised you anything other than what's been stated here today to get you to plead no contest to this charge?
So there was, no, not for this case.
She said no, not in this. No.
Not in this case. All right. Has anybody threatened you or coerced you in any way to get you to plead no contest?
No.
You're doing this voluntarily
Yes.
and of your own free will?
Yes.
Has been handed and has reviewed University of Michigan Public Safety and Security Department report for their case number 2490304894. Any objection to the court having reviewed that report?
No, Your Honor.
Okay. On a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Counsel, have I complied with the court?
Yes, Your Honor.
Court will accept the defendant's plea of no contest to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing in this case will be
May 23rd, 8:30 for Judge Perry.
May 23rd, 2025, 8:30?
Yes.
8:30 before Judge Perry. Bond in this case will continue.
Thank you, Your Honor.
Thank you. Take care, Mr. Simpson.
Thank you. You too.
Court does call the case of the people versus Jason Burkett.
Or
Burkett.
And good afternoon or good morning, Judge. I'm Amir Macklin on behalf of Mr. Burkett.
Good afternoon. Morning. Good afternoon. What's your name?
Jason Matthew Burkett.
All right. Okay, what are we doing on this case?
Your Honor, I'm asking to be withdraw as counsel for Mr. Burkett. I haven't spoken to him. He was KPS last time we were there, and we were never retained. So I'd ask the court to allow me to.
You were never retained. Say again.
He was supposed to retain us, or a family member, or his employer was supposed to retain us, but nobody ever did.
Wow. Okay.
And the last time we were in court, he KPS, so I haven't had any contact with him since then.
Okay, so, well, we got a problem then. Constantino's not still here, is she? Is she coming back?
She was in the hall.
She was in the hall?
She was in this room.
All right, so we may be able to, because the PD initially withdrew on his case. Part of that withdrawal appointed Constantino, but then I think you were going to step in. So that's kind of what.
Yeah, if you want a lawyer and you retain a lawyer, you have to.
I had an RS, PD got out, Mr. Mockley got hired, but I'm not sure that could be incorrect.
No, no, because I have the withdrawal, the motion to withdraw that I signed, the order of withdrawal, and then Ms. Constantino was appointed to represent you. She's not here. All right. So sir, do you have any objection to Mr. Macklin withdrawing?
I have no idea what's going on here. I thought, no, if he's withdrawing, then I don't.
Okay, so here's what I'm going to do. I don't think I need a new order, but what I'm going to indicate is that.
I don't know how things got confused around. I'm sorry.
I'm going to permit him to withdraw.
Thank you, Your Honor.
And then I'm going to indicate that the PD previously withdrew.
Due to a conflict, yeah.
I know. Why are you tripping in? Why are you saying sit down? Well, I'm going to need it. Yes, I'm going to need an order from you, counsel, permitting withdrawal. The court isn't appointing, but the court, I'm going to have this case go back to Ms. Constantino, and we'll Do it that way.
I'll email the court, within a few minutes.
Alrighty, thank you, sir. All right, and here's what I'm gonna do. She's coming back. What, she here next week? He wasn't available on the first. So here's what I'm gonna do, sir. I'm gonna set the next available date so that council can get to you, talk to you, and see what we can do.
Is there anything, I wanted to ask, is there any way I can release on the PR bond? Like I said, this got confused. I thought he said we getting dismissed and we got crossed up. I would have never missed. I talked to Officer Stanky actually on
All right,
Friday.
let me do this. Hold on.
Okay.
Probable cause conference, May 6th, 2025, 9 a.m. Do people have a position on his bond?
Just one moment, I just have to do one request.
And can I say one more thing? I'm sorry, sir. I was trying to get in with the,
So, sir, why didn't you show up the last time?
the last time, like you said, we were confused. I thought he said he was gonna call me back and tell me a court date. I never got received a court date. I would have reported. And like I said, I spoke.
How'd you come back into custody?
Well, I talked to Officer Stanky on Friday and he told me, he said it was a forgery charge I had out for me. I seen him down by the Delana Center and then Delana said that I was threatening to commit suicide. So they called the police on me and then they ended up picking me up that way. But, I kind of still have like an interview I could get tomorrow. I was wondering if I could, any way I can make it out to make that. I really need this job.
Your Honor, also in the court's discretion, I see one hold near 1 night for traffic for driving suspended, so I don't know if we can get him on that or not. I really don't know. But, I don't see a big history of fires with the speed at one time.
Yes, like I said, it was a complete mix up.
I'm going to set your bond at a $5,000 personal recognizance. All the conditions that we previously set will apply.
Okay, thank you very much.
Setting your new date for May 6th, 2025 at 9 a.m. here.
Well, sir.
If you don't show up, you won't see the light of day.
I'll probably be early.
You hear me?
I'll be early, sir. I appreciate
Thank you.
it. Thank you.
And Ms. Constantino will be getting in touch with you.
Thank you.
Court does call the case people first.
I'm sorry, Greg. My phone is broken on Sunday. Is there any way I can get like a business card for her? So I can call her tomorrow? I mean, I might have a new phone tomorrow. I just want to make sure.
Judge, I have her number. I can write it down.
Thank you.
Pass it to the guard.
Thank you, Mr. Getty. As I watched everybody just stare off like sheep cut in my head. Yeah, so Ekin, when that happened, you couldn't stand up and like interject, could you? Huh? You said absolutely nothing. Court calls the case people versus Eric Coons.
Stephanie Cannon, on behalf of Mr. Coles, who is
Oh,
appearing tomorrow.
you're actually going to do something today besides take credit for Miss Apple's victories.
Your Honor, it's all for one here, all for one.
Yeah,
Please
they
state your
don't
name.
think that way when you're what you do. All right, I'm just saying. Your name, sir? Eric Coons. Thank you.
Your Honor, I do believe you should have a green sheet for
I
Mr. Coles.
do.
We're just asking for a 2-week adjournment in this matter. There's no need to have a sheet, so sorry.
May 15th. Turn out a little bit longer than that, okay?
Okay.
Preliminary or probable cause conference, May 15th, 2025, 9 a.m.
No problem.
All right. Bond will continue, sir. Thank you.
Thank you so much, Your Honor.
Court calls case people versus James Richmond.
Alexander, on behalf of the people.
Appearing on behalf of Mr. Richmond. No. Mr. Richmond, will you state your name for the record?
My name is James Richmond.
Thank you.
Your Honor, we're asking that this matter be set for a preliminary exam.
You have all discovery.
Yes, Judge.
People have their witnesses available to 6. Preliminary examination in person, May 6th, 2025, 9 a.m. That before Judge Perry. Bond will continue. Thank you.
Thank you.
Yeah, he is running through the docket like a maniac.
Court does call the case of people versus Sanders. Bernard.
Defender on behalf of Mr. Sanders. Your Honor, state your name, Mr. Sanders.
Bernard Sanders. Thank you.
Your Honor, we're going to ask the court to set this matter for an exam.
Discovery is complete.
Yes, Judge, as far as I know.
People have their witnesses available to 6. Preliminary examination in person, May 6th, 2025. 12 noon. That's before me.
If I can be heard on bond, Judge.
Sure.
Your Honor, Mr. Sanders is here. He's He has an exam schedule, obviously. He is a local resident. He's not a flight risk in any way. He has missed some court. It was some of us due to a medical situation that is ongoing here in the jail. He reports that he hasn't been able to get the kind of care he was getting on when he was outside. He has a issue with his lungs. There's certain medications that he does take that are not available to him here. Now,
what do you mean they're not available?
well, the jail has not made them available. I don't know if they're prohibited from being in the jail or if they just haven't gotten them yet or are able to get them. He's missed medical appointments. He has, I've instructed him to kite those, to kite this. I don't know if he's received any responses. Also, I'm not going to gild the lily. He does have a MDOC hold. I have reached out to his parole officer. She was not the most forthcoming about what would happen. It's my understanding they have 4 days after he's not being held here to submit a report, and then it goes to the supervisor there who makes a decision as to what they are going to do. But I don't have any knowledge as to that. I've reached out to the supervisor as well and have not. I talked to him yesterday, but he didn't have any information for me. But he is local. He's not a flight risk. He has a place to stay.
I don't need a response. Motion for bond reduction is denied. Bond will continue.
Thank you, Your Honor.
And then you seem to take credit there. It's ready. You got Ronald Sims? Got it. Got it. Court has called the case, People versus Ronald Sims.
Assistant Public Defender Davia Lebo on behalf of Mr. Sims, who stands to my right. Mr. Sims, can you state your name, sir?
Ronald Sims. Thank you.
And Your Honor, we'd like to set this matter for preliminary examination, please. We do have complete discovery.
No other witnesses available to 6. Preliminary examination in person, May 6th, 2025, 9 a.m. Is that right?
Yes.
9 a.m. before Judge Fair.
Thank you, Your Honor.
Bond continued. Thank you. Court recalls case, People versus Brendan Chrysler.
That's a lot of people.
James Swetfelski on behalf of Mr. Chrysler. Fortunately, he has not been able to get here. I did talk to him on the phone a couple of times. He's stuck in Flint and he has not been able to get transportation. So I'm asking for a 1-week adjournment, and that's all I have to say.
Your Honor, the court received the community corrections report.
Yes.
He's missed his last 2 tests. People are requesting bench warrant.
Bench warrant will issue for defendant's failure to appear. Bond will be set at $25,000 cash surety. That warrant will issue immediately. Thank you.
Thank you, Your Honor. Have a good day.
Court calls case, People versus Dominique White.
And then on behalf of people, second on behalf of Mr. White.
Mr. White, your presentation into the record.
Dominique White, Your Honor.
Your Honor, we're just simply asking for a preliminary exam in this matter at court's earliest convenience.
You have all discovered.
Your Honor, I do believe that we have everything.
People other witnesses available to 6. Preliminary examination in person, May 6, 2025, 12 noon before me.
Thank you.
Thank you. Court calls case, People versus Danielle Lamadin.
And then on behalf of people.
Admitted.
Carolyn Foster Tucker on behalf of Danielle Lanesman.
That's what I said. Okay.
Your Honor, I was informed this morning that she is in the hospital and is not here today. I would just request a 2-week adjournment.
Without objection, I'll grant the adjournment in this case. She'll be adjourned to, sure, make it May 15, 2025. 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you. That's everything? We come back at 12:30. Wow, almost have an hour. Yeah, after everything's done, then Brown ships up. Court's considered in recess.
I'm sorry, Your Honor, maybe approach briefly before you go.
Yeah, you're gonna have to clear that aisle because they're bringing somebody out. Court does recalls case of the people state of Michigan versus Quinard Sanders.
Anderson, on behalf of the people. Michael Gaddy, Assistant Public Defender, on behalf of Mr. Sanders, who's here to my right. State your name, Mr. Sanders.
Quinard Sanders.
Your Honor, thank you for calling this case. I wanted to clarify something that when arguing bond, I had said Mr. Sanders had not appeared in court because of his not being well. I'd like to point out he was in the hospital. In fact, I think the February PCC was adjourned based on that. I do have a letter to that effect. He was a victim of a stabbing, and then later his lung collapsed, and he went back to St. Joe's. I don't have any clarification as to that right now, but we can certainly endeavor to get it if the court would like to see it. But he does report that he did contact our office about that. In terms of the medication he's not able to get, it's a pain patch, which kind of makes sense, which explains it. Again, I have contacted parole about this matter a couple times, and I was able to speak to the supervisor once who instructed me to call him back again at 8 a.m, and I did, and it didn't work out. But it's Mr. Sanders' understanding that if he is released, he will get put on a tether by MDOC and reinstated on parole with his discharge date being backed out to February 26th, but I'm not able to verify that. But that's his understanding as well, and
That's his understanding, but they haven't verified that's what they're intending.
I have not been able to verify that. He reports that his family member, his mother, has spoken to the parole supervisor, Chase Dazelle. I believe is how you pronounce his name, and that's his understanding. And he does have a place to reside, Your Honor, which is here in town on Gulfside. I just want to make sure the court had all that information.
Yeah, some of that is a bit different than court perception, but overall, it would not change the court's view of whether or not to reinstate the defendant's bond or to do something different. I appreciate the clarification. It's the court's decision that the defendant's bond will remain the same, so that the motion is denied.
Your Honor, one thing came to my attention since we passed the matter. I had sent an email to the Slang police officer who's involved in this case. Has already responded that he is out of town on vacation. That we set this exam, we set it for May 6th.
Yes.
I don't know if the court would entertain right now my request to bump that 1 week in light of that information, but it doesn't appear that we will be able to proceed to exam on May 6th due to his own availability. And this is a single witness exam.
Okay. Well, he's got the parole hold anyway, so I'm going to put it to May 13th.
Your Honor,
1 week out over the objection of 13th at 9. That still would be before me.
And we would object to the move, Your Honor. But in terms of his bond or his exam dates moving out, if we are able to ascertain some more or obtain some more information from St. Joe's about his hospitalization, I'd ask the court to consider a motion to.
Yeah, I mean, and it could be done one of two ways. You can either send the information to me for my consideration, or if you contact my office and would like it scheduled when on a PCC day. So for me, that's going to be the 1st to 6th prior to the 13th date. Certainly, I would entertain hearing it depending on what the docket does.
Thank you, Your Honor.
Thank you. Court calls case People versus David Lee Furman. Madam Attorney General, if you could take your appearance, please.
Yes, good afternoon. Assistant Attorney General Clarissa Williams on behalf of the people.
Good afternoon, Your Honor. Edward Lucas on behalf of David Furman.
Mr. Furman, can you state your name, please?
David Lee Furman.
Thank you. He shut off his camera, but I stopped. All right, what are we doing?
Your Honor, there might be an alley press in the file.
Is there? He did tell me that there was. Okay. So this case is being dismissed. All right. Case is dismissed. That's by Nally Pross. Court has signed that. Thank you, folks.
Thank you, Your Honor.
Thank you, Mr. Furman.
Thank you, Your Honor.
Thank you. Court does call the case of People versus Jacob Jackson. It's also an Attorney General case.
Good afternoon, Laura Yagi, Assistant Public Defender, with and on behalf of Mr. Jackson. Mr. Jackson, could you unmute yourself and state your name for the court?
Jacob Jackson. All right, what are we doing?
Your Honor, Mr. Jackson and I discussed waiving his preliminary examination. Unfortunately, because he's on Zoom, I don't have a signed waiver. I'm wondering if the court
is he going to waive? He wants to waive?
Yes, sir.
Mr. Jackson, is that correct? You want to waive your right to a preliminary examination?
Yes.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes.
You understand that you'll not have that hearing and you'll proceed to circuit court for further resolution.
Yes.
All right. People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendant is bound over to circuit court on a single count. Ms. Yagi.
We would waive formal reading and stand mute.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial in this matter will be set for
June 17th at 1:30 PM.
Judge who? June 17, 2025, 1:30, Judge Conkey. Bond continued. Thank you.
Thank you.
And I think I have one more for you, Madam AG. Court does call the case of the People versus Joseph Wynn.
I'm Lori Yagi, Assistant Public Defender with and on behalf of Mr. Wynn. Mr. Wynn, can you state your name for the court?
Joseph Wynn. Yes, Ms. Yagi.
Your Honor, I am asking for adjournment in this matter. Mr. Wynn and I have been in communication, but we are asking for a little bit more time for me to look into a couple things and for him to get set up online with the payments.
All right. That objection, I'll adjourn probable cause May 15, 2025, 9 a.m. or as your invite indicates. Bond will continue. All right, thank you.
Thank you, Your Honor.
Thank you.
All right, thank you. I think that's it. Madam Attorney General. Court does call the case, People versus Armani Taylor.
Good afternoon, Your Honor. Sydney Rushing appearing on behalf of Ms. Taylor. Ms. Taylor, can you please state your name for the record? Hello, Taylor. Thank you.
All right, what are we doing?
Your Honor, we're asking for a brief adjournment so that way we can receive discovery.
Say that again. I don't know what's happening with my speaker.
Your Honor, we're seeking an adjournment so that way we can receive discovery and review it.
Probable cause conference, May 15, 2025, 9 a.m. or as your invite indicates, bond continued.
Thank you so much, Judge. Have a great day.
Thank you. You too. Court does call the case of the People versus Harold Martin. Ms. Plumai.
Your Honor, Alexis Plumai appearing on behalf of Mr. Martin. And there's no Mr. Martin in the courtroom. Your Honor, I have not been able to get in touch with Mr. Martin. Unfortunately, I don't have an explanation for his absence. I don't believe he's here today. Harold? No, Harold Martin. So Your Honor, I would.
This be your case? That's my middle name. You know, if you want to be your case, let me see what you're charged with. I don't know if you want all this, but I don't know.
I would ask for an adjournment. It looks like our office had contact with him just a couple weeks ago, but I haven't been able to reach him this week.
The defendant doesn't appear over a year ago. The warrant was recalled recently, but it's not here today, so my special warrant issue.
Bench warrant will issue for defendant's failure to appear, bond 10,000, cash surety. Warrant will issue immediately. Court does call the case, People versus Larry McCullough Hawkins.
And on behalf of the people.
Lori Yagi, Assistant Public Defender with and on behalf of Mr. McCall Hawkins, who is approaching. Did you state your name for the court?
Thank you.
In this matter, Your Honor, I do believe we have discovery. There's a 911 call that's en route to our office, so I would respectfully ask that this matter be set for preliminary examination.
911 call.
That's correct. It was uploaded yesterday, so it should be here by Monday.
People, other witnesses available to 6.
We'll try our best.
Preliminary examination in person, May 6, 2025 at 9 a.m. with Judge Perry. Bond continued. Thank you.
Thank you, Your Honor.
False case, People versus Charles Meade. Mr. Feaster.
Yes, Assistant Public Defender Shannon Carey, I can rule, Your Honor, on behalf of Mr. Charles Meade.
This time people will be moving to dismiss this case without prejudice, file an hour process based on good and not for the exception.
Any objection?
No objection at all, Your Honor.
Case is dismissed.
Thank you, Judge.
Thank you, Mr. Mead.
You're welcome, Your Honor.
Charles Case, People versus Jeffrey Moore.
The people vote matters.
Assistant Public Defender Dottie Lee on behalf of Jeffrey Moore, stands to my right.
Jeffrey Moore. Thank you. What are we doing?
And Your Honor, we'd like to be setting the 0206 matter for exam and adjourning the 0707 matter to track along with it.
You want me to do what?
Your Honor, I'd like to set the 206 matter for exam and adjourn the 0707 matter to track that other matter.
To track what other matter?
The 0206 matter.
So you want an adjournment on
on 707, Your Honor.
You've lost me. I'm just trying to figure out what you want done with these cases. Do you want one of them set for exam?
Yes, Your Honor.
Which one?
206.
Is all discovery on that complete? People have their witnesses available to 6?
We'll try, Your Honor.
In this case, preliminary examination will be set for May 6, 2025 at 12 p.m. noon. That's before me. That's in person, bound, continued. Now, what do you want done with this other one?
And the other matter, I want to adjourn to a date approximately around the same date as the exam. As how we're proceeding in that case may depend on how the
It'll
exam.
be the same date. It's in the morning now.
Thank you, Your Honor.
Probable cause conference, May 6, 2025, 9 a.m. Bound, continued.
Thank you.
Thank you.
Thank you. Court calls case, People versus Victor Morris Gerard.
Okay, I can read on behalf of Mr. Mr. I'll take your name for the record.
Victor Morishara.
Your Honor, in regards to the probable cause conference, we're requesting an adjournment. There was still some outstanding discovery that we requested.
You have a green sheet? No.
That's it. I got it right here.
I don't mind it now, but we do have a problem. Conference, 2025. As to the bond violation.
As to the bond violation, and I did have an opportunity to speak with Mr. Gerard. He takes full accountability. He's indicated to me that he has been struggling with depression, and obviously, now knowing that this issue is much bigger than we talked about treatment opportunities in the report from they did indicate that they have made a referral for CCOP on his behalf as well. He has not spoken with Mr. Brown to see where they are with that program, but I just asked the court to at least give us the opportunity to explore that option and see if we can get him into outpatient treatment.
No, you might be able to get him into outpatient treatment, but he's clearly in violation because they have had 4 successive tests where he's positive for cocaine, amphetamines, and then his last test positive for cocaine and alcohol, but before the confirmation test on the alcohol, he left the building.
And I did ask him about that, Your Honor. I think that was just a misunderstanding. He stated that he did not know that they needed him to stay in the building to do any other follow-up tests, but I've explained to him that once there is a positive alcohol test, that they require the confirmation test.
All right. Anything else?
Nothing else.
So I set it for May 6, 9 a.m. At this point, defendant's bond is revoked. Court calls case, People versus Justin Robinson.
And then on behalf of people.
Good afternoon, Your Honor. Assistant Public Defender Constable Basin on behalf of Mr. Justin Robinson, who's present to my right. Mr. Robinson, can you state your full name for the record, please?
Justin Robinson. Thank you. What are we doing?
Today's the date and time set for a PCC. We'd be respectfully requesting to set this for a preliminary exam at this time.
Well, discovery complete.
To my knowledge, yes. We would ask for the earliest date available.
People have their witnesses available to 6.
We'll do our best.
Preliminary examination in person will be set May 6, 2025,
9 a.m. before Judge Perry.
9 a.m. before Judge Perry. I will consider. Thank you.
Thank you, Your Honor.
Court does call the case, People versus Mountain Rucker.
Chairman Adish, on behalf of Mr. Rucker, Assistant Public Defender, Chairman Adish now, officially. Can you say your name for the record?
No record. All right, sir, you need to take your hand out of your pocket, please.
You can take your hand out of your pocket.
Are you having problems hearing me at all?
I'm deaf in this ear.
All right, hold on, we'll get you.
They're gonna give you those. Thank you.
See, we're a team.
Together.
That's not a team thing. That's you being in everybody's business. That's all that is. That doesn't make a team.
You know, whatever the outcome, you can get all credit.
She's just in everybody's stuff. Does that help you, sir?
Yes, sir.
Okay. Your Honor, we're going to be asking for an adjournment. I hadn't been able to get in contact with Mr. Rucker. It is because he isn't able to have a phone based on his bond conditions. I was going to request that he be able to buy a flip phone and use it, one that does not connect to the internet. That way we are able to talk to him about his case.
Oh, I see. People have a position on this.
Does he have no bond condition that says no phone use, or is it no using a device?
That's the internet connection.
So he's able to. Okay. Okay. We'll talk about that later.
Where do you get a flip phone? Never mind, my bad.
From somewhere, I don't know.
What?
I can Google it. I'm not sure right now. I have one in my room. No, it's my old one.
You are not old enough to have had a flip.
It's not. It slides. It doesn't flip. It slides.
You are not old enough to have a true flip phone. I'm just telling you right now.
All right. I'll get rid of it.
People stopped using those probably when you were about 2.
That's so funny.
All right.
All right.
I'll turn this to May 15, 2025, 9 a.m. If you arrange for the flip phone or the non-phone, what I'm going to suggest you do is at least take a picture of the packaging and maybe the serial number above it so that there isn't any miscommunication. Get that to the prosecutor.
Definitely.
Okay.
Thank you, Your Honor.
Thank you. Bond continued. Thank you, sir.
Thank you.
Okay. No, it's okay. See,
Great.
Ms. Cannon was all in the business and everything until it came time to, no, you show back up. Now she's not all up in. Court calls the case, People versus LaDonta Skinner.
And yeah, people.
Assistant Public Defender Jay Bell on behalf of Mr. Skinner, who approaches. Good afternoon, Your Honor.
Good afternoon. Thank you.
Your Honor, we're just seeking to set for preliminary examination on this.
Better be bringing the track shoes May 6th. Discovery.
Yes, Your Honor.
People have the witnesses available May 6th.
We'll do our best, Your Honor.
Preliminary examination in person, May 6th, 2025 at
Well, yeah, before you.
12 noon before me. Continue.
Thank you. All right. Well, okay. All right.
Court calls case People versus Ira Smith.
Jennifer Douglas. Stephanie Cannon, we have Mr. Smith, who is not present, Your Honor. I would just ask for a show cause. I'm just asking.
Really?
I'm just asking.
You got that from Daddy, didn't you?
He's
That's part of this team thing.
my hero.
Did you ask him when you got that from him how well that works?
How well does it work for you?
What?
Does it work well?
No saying if you don't ask, the answer's always no. The answer's always no.
Central warrant will issue for defendant's failure to appear. Bond 10,000 cash surety. That warrant will issue immediately.
Thank you, Your Honor.
Was that a whole team thing too? No, nobody else was like.
It was worth a shot, but
Court calls the case, People versus Virgil Stafford.
yeah,
Stafford.
if your client doesn't show, Judge Simpson, it's not going to happen, but you can always ask.
Stephanie Cannon on behalf of Mr. Stafford, who is also not present, Your Honor. However, I did provide this court with confirmation that he is currently hospitalized at Havenwood Hospital. I've given it to Madam Prosecutor as well. We're just simply asking for an adjournment of this matter. And I do believe there is a green sheet that should have been provided.
But you don't know.
I mean, I feel confident in your staff, so I'm gonna go yes. Good answer.
In my staff?
Good answer. I gave it to Ann. I did, I promise. Oh, yes. Good answer. Good answer. Okay.
She had no idea.
I did. So Your Honor, I'm asking for a 2-week adjournment to give me the opportunity to speak with him to see how we're going to proceed on this case.
May 15th, 2025.
Thank you, Your Honor.
And bond continues. Thank you. Court does call the case of the People versus Derek Stewart.
And Your Honor, Alexis, am I appearing on behalf of Mr. Stewart, who is in the vestibule right now? Wait, which one? It's Derek Stewart.
Yelling. Who's that yelling? No, who is yelling? Why were you yelling?
I didn't hear the first name.
We're talking about.
And Mr. Stewart, could you state your full name?
Thank you, sir.
Your Honor, our office has received a copy of the competency evaluation in this matter. Have gone over it with Mr. Stewart, and we are not objecting to the findings of that report.
I am objecting. That the defendant at this time is incompetent to stand trial, but with treatment would likely regain competence within a statutory period of time.
Yes.
Any other additional evidence on matter said?
No.
I need a 3 months because excuse me. Set a competency review hearing July 24th, 2025 at 9 a.m. Counsel, you'll prepare the requisite order.
Yes, and Your Honor, if I could briefly address bond.
Yes.
So I, for whatever reason in OnBase, I'm not able to find the most recent community corrections bond order. But Mr. Stewart is on some kind of a GPS tether at the moment. I'm not sure if it's just tracking or if it's an exclusion zone. That is both very uncomfortable for him, and because he currently doesn't have housing, it's very difficult for him to make sure that it's charged to get somewhere where he can plug it in. I will note that he has been, at least the last few times that I've represented him, he has appeared on time for court. Nothing, nothing by way of new offenses. He's compliant on bond. He would just ask Your Honor to consider removing that tether.
Any response from people?
Your Honor, I understand it may be uncomfortable, but unfortunately, the nature of these allegations seems to require it. Mr. Stewart is
I'm disabled. What am I?
Pay attention to jail.
Y'all will, I'm just in it.
May I continue?
Go ahead.
The nature of these allegations appear to require Mr. Stewart is charged with 1 count of witnesses bribing, intimidating, and interfering. Essentially, the allegations in this report describe Mr. Stewart. These are physical confrontations in terms of rushing this individual in this area. Now, him no longer living, I think, close by may assist with that, but I don't have any assurance that Mr. Stewart is going to be able to essentially not contact this person. I might feel differently if we were dealing with text messages and emails and phone calls and that sort of thing. These are physical confrontations.
Your Honor, I do believe Mr. Stewart is no longer living at that location. This incident occurred back in 2022. At the time, I believe Mr. Stewart was still at that apartment complex. He had since been evicted and isn't staying there anymore. It's my understanding that you are usually in downtown Ann Arbor, or Delano Center as his mailing address. Okay. But either way, I don't think he plans to or has been going back to that location.
Well, you evicted me, why should I go back? All right, the original order, that's what may help, is that, at least as I see it, the original order was back on September 21st of 2023. However, there was a period in time at which, for whatever reason, as it was proceeding, it came through, and then I think at some point the defendant bench warranted, and there were some other issues. At later date, I then set aside the bench warrant, reinstated his previous bond conditions, which is why he has the tether on now. Okay. So I'm a bit reluctant. Well, what I'm going to do is this. I'm going to deny your request at this moment. And what you would need to do is file a written motion that I can consider fully as to the release, where he is, and lay all of that out to me. So at this time, the motion for bond modification is denied. Thank you.
Okay. Thank you.
And bond will continue for July.
Yep.
Huh? Oh, is that what it is? Okay. I don't know what it is.
I'm going to fetch myself another beer.
Court calls case, People versus Elijah Stewart.
Your Honor, again, on behalf of Mr. Stewart, who is appearing to my right. Mr. Stewart, when you are present, please state your name for the record.
Is Elijah Stewart?
Thank you. And Your Honor, we're simply asking for a 2-week adjournment of this matter for
You didn't know?
some additional investigation. No, yes.
Public cause conference will be adjourned May 15th, 2025, 9 a.m.
And Your Honor, if I may, could you please remind the defendant that there's to be no having third-party contact with the victim in this case?
Why am I reminding him of that? What do you?
He has been having some contact with the victim. Whatsoever.
Your Honor, this is the first I'm hearing about this. I've talked to my
I don't
client.
even know what it is. So what are the specifics? I mean, because I'm not gonna admonish somebody if they're not doing anything.
Thank you.
Oh, you were gonna sign on to it like I care. No.
This, I think that is informing that someone's been coming to the victim's house. We don't have any information as to that.
That's attached to him?
It's unclear at this time. We just want to make sure that no contact.
Well, I think he understands his bond conditions, but I don't even see that it's remotely approaching any type of bond violation. I'm not gonna admonish him. I'll
Thank
wait
you.
till you give me something that I can do. Bond will continue. Thank you.
Thank you.
All right. Right, okay. So I don't know. I don't have any information. Court does call the case of the People versus Cynthia Subtle.
Maybe Richard McDuffie for people.
All right, what are we doing?
Your Honor, we have we've come to a resolution in this matter, for an advice rights form, as well as the sentencing judge waiver. If Mr. Duffy can offer on the record.
Well, I'm not, okay, I can do that one step. Miss Solo adjourned.
Go ahead.
Okay, I didn't know if you were waiting for this.
No, I don't know what, I'm just, go ahead.
Miss Solo adjourned last time so that she could make one last payment to complete her restitution payments to get the misdemeanor offer in this case. Miss Solo did in fact make that payment, but it was extremely recently, I think within the last hour or so. So I did let Mr. Carriac really know that I was not gonna be able to get the form filled out before the case was called.
I apologize. I must have misunderstood her, Judge. I thought she said that she would get the plea form filled out before the case is called, after we confirmed that the payment was made. That's my apology. I literally missed the word.
I'm glad that communication is working so well.
It's not.
So if it was really happening,
But I
No,
if not.
no, I'm not.
Okay.
I'm sorry. I would normally do it, but
Okay.
you can blame that person standing next to you. Wow. Wow. The funniest thing is I've never seen that really move that fast. Anyway.
Okay, so we're obviously.
Why don't I just put it out to the 6 in the morning? Okay. So probable cause conference May 6, 2025.
Okay.
9 a.m.
Okay.
Bond continue.
All right. Thank you so much, Judge. I'm sorry about that. Thank you.
Court calls case of the People versus Troy Swope.
Assistant Public Defender, Chinazi K. I can rule you on behalf of Mr. Troy Swope. Don't you was in here a moment ago? If I can just check for him in the phone.
Sure.
Swope.
Oh, Swope. Oh, she's gonna mess it up. You want me to call for him and then she gets the name wrong? This isn't gonna work. Thinking really? Good job. Not only have you lost a client, you now lost another attorney.
This is for slopes. I mean, this is for a settle. I'm sorry, Judge. Settle. Okay. Can we recall the case, Judge? He went to the restroom, she said. I'm here with you.
To make things more interesting, even though it's really, really interesting. I just set a goal on YouTube. And I set a low goal. 15 super chats, $2 or more, and within the end of the stream, and I will take a shot of whiskey. Hey.
Well, no, he went to the restroom. That's fine. I just didn't trust, like, you laughed and then Cannon said something. I didn't trust him.
He is here, Judge. Here, and I'm handing the courts a green sheet now. We're asking for an adjournment in this matter. Mr. Swope has been having some medical issues, so he was in and out of the hospital. Well, he was in the hospital. We weren't able to have contact with him. Obviously, he's here. I'll confirm his contact information and see if we can figure out what's going on this case and come to a resolution with the people. We are in communications with them in regards to a resolution, but we have not been extended an offer yet.
Go ahead.
I think that before we get to the adjournment, we should address bond. There was the violation report sent out indicating that Mr. Swope was released and on April 12th, and that he was supposed to be reporting to community corrections, which he never did. He did not go to community corrections for intake, let alone the 2 times a week testing he's supposed to undergo, Your Honor. My understanding is that Mr. Swope did not appear money, Your Honor, so it does not appear that there is a legitimate reason for Mr. Swope not showing up. At the very least for intake, he really couldn't afford to pay for some particular tests. And my understanding is that he'd still be able to test, he just might end up owing some money. So, Your Honor, at this time, I believe that Mr. Swope is in violation of his bond conditions, and that perhaps it would be appropriate so that he came today. However, we have no idea.
Yeah, out on bond, not reporting. That's somebody who is going to get a bench warrant and thrown in jail.
Using substances during this time. And how, or why did not even show up for anything?
And Your Honor, I did have a conversation with the people in regards to that. She did ask what the reason for his failure to report was, and everything that she stated is correct. I spoke with Mr. Swope. He stated that he did not have any money, and he thought that he was required to present money at community corrections. Now, if there's a change in the rule, I did tell him that we still encourage our clients to go and form community corrections.
To go.
Yeah.
He just hasn't done anything. Is he working?
No, he's not, Your Honor.
If I were to test you right now, you're going to test clean? No, you're not. I didn't think so. Mr. Allen.
Yeah, he's fucked. Congratulations, stupid. You're going to jail.
I'll set this probable cause conference for May 6th, 2025, 9 a.m. At this point, defendant's bond is revoked. Defendant's remanded.
Thank you, Your Honor. Yeah.
Court does call the case, People versus John Terry.
I mean, by the way, this guy here, waiting on Zoom, did he put up a clipboard of himself? I haven't seen him blink once.
Alexis, I'm appearing with and on behalf of Mr. Terry, who is approaching. Mr. Terry, could you state your full name?
John Martin Terry? Oh, I would have taken the other charges. No, I'm kidding.
Your Honor, we were just asking for a brief 2-week adjournment. Mr. Terry is receiving some treatment. He's just going to get some letters from his providers to give to the prosecution as proof.
Oh, is that correct, sir? Yes, sir. All right. No objection from the people. How much time did you need? Did you just say you want the 15?
2 weeks. Is that the 6th?
I don't know.
I don't know either.
12 days out. So I don't have the 8th, which
Oh, okay.
So you have the 6th or the 15th, which is going to work better for you.
15th.
Of course I need that. Probable cause conference, May 15th, 2025, 9 a.m. Bond continued.
Thank you.
Thank you, Your Honor. Thank you, sir.
Oh, he's looking.
Let's call the case, People versus Delco Thomas.
I think it's a bot.
Thank you, Your Honor. Constable Basin, on behalf of Mr. Delco Thomas, who's present to my right. Can you say your full name for the record, please, Mr. Thomas?
Delco Thomas.
Thank you. Today's the date and time set for PCC. At this time, requesting a brief adjournment. There is some additional discovery my client wants to provide me that I would like to take a look at.
With him. Okay, probable cause conference, May 15th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you.
It's almost as if he heard me because all of a sudden he's moving. Hey, Dark Lotus, $2, helping a brother out. Skål, my Viking friend. Cheers to you too. And that makes it 2 out of 15 for a shot of whiskey.
Court calls case people versus Lewis Moraldi.
Kevin Addish on behalf of Mr. Varaldi appearing on Zoom. Mr. Varaldi, can you state your name for the record?
Louis Feraldi.
He talks. He talks. Oh, he's a defendant. No, okay. That's okay. He looks like an attorney. Let's see what allegedly did.
All right. We're not.
Your Honor, we have come to a resolution with prosecution, but we are going to be asking, sorry, I confused. That's my bad. We're going to be asking for an adjournment because we need to continue plea negotiations with prosecution.
Got it.
Yeah, that was another thing.
That's because you've been hanging around Cannon. I'm just saying that will happen to you. So what I will do, probable cause conference without objection. I'll adjourn this to May 15th, 2025, 9 a.m.
Thank you, Your Honor.
Thank you, Your Honor.
Continue.
I'll talk to you, Mr. Varaldi.
Thank you.
Court does call the case, the people versus Stephen Watson.
Alexander on behalf of the people.
Michael Gaddy, Assistant Public Defender on behalf of Mr. Watson, Your Honor.
Mr. Watson, I need you to turn on your camera and unmute. Yeah, well, that's gonna be a problem.
Yes, Your Honor.
Mr. Watson?
Your Honor,
Where is he?
he's at the St. Joe's Hospital. He contacted our office, said he was at St. Joe's Hospital with a sick family member. He is endeavoring to get proof to us. I asked if he could appear by Zoom. I gave him the information just in case, but I'm asking now that he be allowed to appear by Zoom for the probable cause conference. Looks like he's standing outside of St. Joe's. Mr. Watson, can you hear and can you state your name?
No audio connection.
There's no audio connection.
Tell you what I'm gonna do. I'll adjourn this 1 week out, May 1st. Given all of the circumstances, May 1st, 2025, 9 a.m.
Thank you, Judge.
At that moment, but their client may need to be prepared to go in, given the results I'm seeing.
Understood.
Court calls case, people versus Delani Wright.
That's for the people.
Assistant Public Defender Duffy Lee on behalf of Mr. Wright, who is approaching from my immediate right.
Thank you, sir.
And we're going to be requesting an adjournment today. We have reached a resolution in this matter, however, that requires the upfront payment of $1,000 by Mr. Wright, and he's going to be needing a couple weeks to come up with some money.
Okay, how much time are you gonna need?
2 weeks, Your Honor.
I was asking him. Is 2 weeks gonna work for you?
Yes, that's what I told my lawyer.
Okay, but it's not gonna work for you.
Yes.
I don't. Probable cause conference, May 15th, 2025, 9 a.m. Give you a little bit more time than that. Try to make sure it gets done. Okay, thank you.
Thank you.
Court calls case, people versus Roman Whitfield.
Jennifer Douglas for the people. And Assistant Public Defender, Your Honor, on behalf of Mr. Rowland. State your name for the record.
Roman Whitfield.
Judge, I do have a green form.
I do not.
I have a green form to submit to the court. I didn't finish.
Really, Gaddy? Yeah, I know he did. He did. I didn't think that was. I didn't think that was you. It's the old fish steak. All right. How much time are you going to need this afternoon?
There's just a little bit of information that the people and I need to flesh out, Judge. It's 2 weeks. 2 weeks should be fine, Judge.
You want the 6th or the 15th? Jeez, we've been at this all day. I can just close this. Oh, now you're going to ask him?
The 6th is fine, Judge.
The 6th?
Yes, Your Honor.
Okay. May 6th, 2025, 9 a.m.
Thank you, Your Honor.
Because he told you hi last time. Yeah. Take care now. All right, I think, that's it for that block. Oh, rather efficient. Thank you, Mr. Gaddy, for being here and keeping us efficient on this. I know. You need to talk to the rest of your folks. Because they were trying to mess it up. Court's gonna stay in recess.
All right. 14A District Court of the County of West Lafayette, Tennessee is now back in session. The Honorable Judge Jason.
Yeah, for you who just got here, thank you for being here. This stream is the entire week of Judge Simpson. I recorded as almost everything, but as you might know, Judge Simpson deletes his streams when he begins a new one. Then he deletes his prior one. So I might have missed out on half an hour on one part or 15 minutes over there because I wasn't fast enough to record it, but I recorded as much as possible, and it turned out to be 10 and a half hours once I took out all the breaks, all the pauses, and the silent moments. And this I'm streaming now, all of it, but I also cut it up into separate videos. Those will be published starting 6 p.m. Eastern Time, and then a new video will appear. It is 10 videos in total, I think, that will be up and going from 6 p.m. today to 6 p.m. tomorrow.
You may be seated.
So if you don't want to see the entire stream,
Court does call the case, People
it will
versus
be out
Zhejiang
in video
Gao.
format as well.
People versus. Well.
I'm back.
No, anyway. Welcome back.
Thank you, Madam.
What the frick happened?
People versus. Well.
I'm back.
No, anyway. Welcome back.
Thank you, Madam. Well, good afternoon, Victoria Burton here, Chief Assistant Prosecutor appearing on behalf of the people. I think I might be missing for the council on the other side of my matter.
Yes, Simone.
Your Honor.
Oh, he's in. Yes, sir.
Appearing via Zoom. Thank you, Your Honor. Good afternoon. Orlando Simone, Student Legal Services. And with Zoom. Your Honor, would we be able to either pass this matter and come back to a bench conference or do one right now, briefly?
A bench conference?
Yes.
Yeah, I can do it, but then everybody else is gonna have to wait, and I'm not doing that.
Understood.
I'm
willing to pass.
Let me pass it, counsel, and I'll figure something out. I'm not sure what that's gonna be, but I'll figure something out.
You're right. Thank you, Your Honor. I'll be standing by.
Okay. Yeah. Court calls the case People versus Cynthia Lake Pier.
Good afternoon, Your Honor. David Champion, Cynthia Lake Pier.
Ma'am, your name?
Cynthia Lake Pier.
Thank you.
Your Honor, you should have a plea form in front of you there.
I do. Plea form indicates that she's going to be pleading that there are going to be 2 counts added. Count 3 of operating while intoxicated, the 93-day offense. Count 4, resisting and obstructing attempt, the 1-year offense. On her successful plea to those charges, counts 1 and 2 would be dismissed. That's the court's full understanding of the agreement.
That is correct, Your Honor.
Has she signed an advice of rights form?
She did. Should be in the file. We did the last time we were here.
That guy. What's going on with that guy? Attorney K. Orlando Simon, he, his, him. And that's a bad to pay. Yeah. Now, I understand people who wants to add their pronouns on their social media. I mean, go for it if if it makes you happy. But as an attorney in a professional setting, your name is enough. No add-ons.
First one. Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth to help you God?
Two.
State your name.
Cynthia Lake here. All right, ma'am, it is this court's understanding that you are going to be pleading guilty to 2 charges. Is that your understanding? Yes. The first charge is that of operating while intoxicated. That's a misdemeanor punishable by up to 93 days in jail, $500 fine plus court cost. The court could order community service and any rehabilitative programs the court deems necessary. Court could order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand all of that? Yes, sir. All right. Count 4 is the charge of attempted resisting and obstructing an officer. That's a misdemeanor punishable by up to 1 year, $1,000 fine plus court cost. You understand that? Yes, sir. All right. You understand also, ma'am, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Freshour in the 1483 District Court. You understand that? Yes, sir. All right. Now, understanding all of that, you still wish to plead guilty? Yes, sir. To the charge of operating while intoxicated, how do you plead? Guilty. To the charge of attempted resisting and obstructing, how do you plead? Guilty. Now, you understand that by pleading guilty, you'll not have a trial of any kind? Correct. You signed an advice of rights form, is that correct? Yes. Any question regarding any of those rights? No, sir. Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form. Yes, sir. You understand you're giving up your right to appeal of right? Yes. Are you on probation or parole? No, sir. Has anybody promised you anything other than what's been stated here today on the record to get you to plea? No, sir. Anybody threaten you or coerce? No, sir. You're doing this voluntarily? Yes, sir. Of your own free will? Yes, sir. And because you believe that you are indeed guilty of these offenses? Yes, sir. January 18, 2025, at the location of 9876 Main Street, Whitmore Lake, Northfield Township, Washington County, State of Michigan. Were you operating a motor vehicle? Yes, sir. Prior to operating that motor vehicle, did you consume intoxicating liquor? Yes, sir. What'd you have and how much? Captain and Coke, Captain Joe's, I don't remember, maybe. Right. Were you stopped by the police or was there an accident?
It was a single car rollover accident, Your Honor.
Okay. Did the police arrive? Yes. Were you taken to the hospital? Yes. Was there a blood draw? Yes. And what were the results of the blood draw?
It was 0.253, Your Honor.
Ma'am, do you have
0.253? That would be 3 times the legal limit. Yeah. Oh, that's not good.
any reason to dispute those blood test results? No, sir. All right. When the police did arrive and you were interacting with the police, what happened?
Did you attempt to kick one of the police officers?
Yes. And at the time that you were attempting to kick the police officers, what were they trying to do? Take me into the hospital. They were trying to get you into the hospital, get help for you, and you tried to kick them. Is that correct? Yes, sir. Counsel, have I complied with the court rule? Would it be proper to accept this defendant?
Defense is satisfied, Your Honor. Thank you.
Court will accept the defendant's pleas of guilty to counts 3 and 4. Counts 1 and 2 are dismissed pursuant to the plea agreement. Pre-sentence investigation and report is ordered at 1483 probation. Sentencing in this matter will be
16th and 9
June 16, 2025, 9 a.m. before Judge Freshour. And we'll continue. Yes.
There is a key corrections report, maybe slightly. Sorry. How I read it, there was a missed test in the evening, and then the following morning, they tested a very low alcohol, 0.006, I believe.
What happened? I don't know why they didn't say this is a violation of civil progress report.
I had just received the,
Mr. Allen. On April 11th, you tested positive for alcohol.
Your Honor, this was the first time she's ever been on any type of sober link monitor. It's the first time she's ever had a criminal offense. And this was the very first day. You can see she missed the test on the night of the 10th, which is the same day she picked up the sober link. And then she missed the next morning, or tested positive the next morning in the 5 to 8 window the next morning. I believe it was just a process of her getting used to being tested.
Excuse me? The day you picked up the device, you missed testing twice, and then you tested positive for alcohol, 0.11, the day after. Mrs. Did you do a final party before you thought, no, I can't drink anymore? Yeah, that's stupid.
I don't know what that means.
It means that alcohol is the undisputed heavyweight champion of the world. If she was drinking prior to that date, she quit, and she may have still had some residue left over. She has had no positive tests since the first day of testing. And if she hasn't figured out a way to stop drinking successfully, she is going to be found out when she's either continuing on bond or when she's on probation. And we would have no objection to her continuing on the sober link as long as Judge Sarshowers thinks necessary.
Well, except for the fact that I have an arraignment occurring in January 2025. Unless that date is wrong.
There was no, she was doing testing, random testing every week for 3 or 4 months, but there was no alcohol testing, regular alcohol testing. There was no sober link. There was no scram tether. There was nothing for like 3 months.
Yeah, but she was under an order not to consume alcohol.
I understand, Your Honor, and I'm not saying that she did. I'm saying that it looks like this was her first time ever on a sober link, and maybe it takes her a while or took her 1 day to realize what the expectations were, and she cannot have any alcohol of any kind to consume anything that would possibly cause a positive reading.
No, attorney, that's bull crap. That's bull crap. No. She's been subject for testing for a few months, random, and got lucky, I assume. But then she got the monitor thingy, and all of a sudden, boom, positive. Even if she stopped drinking the day before, she still had 0.11 the day after. That is an insane amount of alcohol she consumed the day before, if that is. And she was still under court order to not drink. Yeah.
She knows she's not supposed to have alcohol.
I did not. I had a root canal. I was in the process of that. Only thing I had was penicillin. Honest to God.
Folks, this is alcoholism. Her need for alcohol is so insanely high that she actually believes she wasn't under a court order to not drink after being caught in a DUI at 0.243. That's alcoholism. And it is a disease. She should be really happy she didn't kill herself and others on that accident. Because I can tell you, she's probably been drinking and driving for years and not being caught until that moment. And it seems like she still doesn't get it because she's still a raving alcoholic. She simply doesn't get it. She just wants to drink.
Is that what you really want to tell me?
I'm telling you that.
If you're, no, ma'am, is what you want to tell me is that on April 11th, you tested positive on a sober link because of a root canal.
I had no.
I've been doing this a minute.
I had
if
no.
That's what you want to tell me, ma'am. I'm just asking you a straightforward question. Is that what you want to tell me?
Yes, sir.
Okay. Well, then I'm going to let Judge Fresh.
And she's blaming a root canal. Yeah, Your Honor, I have a secret deposit in my teeth. So when I had a root canal, I got drunk. No, that's not happening.
Tell her handle her bond, but at this point, her bond is revoked. Defendants remain.
Thank you, Your Honor.
I'm done with this document.
Jesus.
Can we get another
You want
date
another,
prior
you
to?
want
the-
another round?
Well, I want another date prior
You
to
want,
the.
you want to
June-
still mess with me?
I want her to.
What, you know, I'd like to.
I under, you and I are on
Now,
the,
no, no, what, go ahead, what?
you and I are on the same, you and I are on the same page.
Yes.
And actually, I asked Andrew, to have her tested, to be tested. She's gonna be really mad when she hears that, but I don't care.
Do I have any questions?
It's May 19th at 9 a.m.
May 19th.
Yeah, I think that, thank you, Your Honor.
Are you done for today?
I am done for today.
Good, now I can be in it. No, I'm kidding. Thank you, Mr. Schiff. Court does call the case, people of the state of Michigan versus Mitchell Marion.
Ready, Your Honor.
APA Richard McDuffie for the people.
Yeah,
Joe Simon on behalf of Mr. Marion. Mr.
well,
Marion.
there goes that good.
I'm here to restore it. Restore it. Yeah.
Oh,
State your name.
Mitchell Marion.
thank you. And what do we do?
We have a resolution, Your Honor.
Is there a plea form? I don't see. Ah, there it is. Yes, I have a plea form that indicates that the defendant. What's happening with count 2?
I'm sorry, you want to place it on record?
Please.
Mr. Marion is originally charged with 1 count of resisting and obstructing. Count 2, I believe, is a regular OWI. Mr. Simon requested an offer. I was able to grant that request. That offer is that he can have the attempt RNO, which is the added count 3. He would still be pleading to count 2, but there wasn't actually a way to represent that on the plea form. So that count 2 is not going anywhere, with the dismissal of the original.
Is he pleading to counts 2 and 3 and
Yes.
dismissal of 1?
Yes, and count 3 will be under the prosecutor's deferred sentence program.
That's what I am. Okay, so I just need. He pleading guilty?
He is. And just to be unequivocal, the deferred is only to count 3.
I mean, you need to sign it.
Oh.
Thank you, Your Honor. Raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, have you done?
Yes.
State your name, please.
Mitchell William Marion.
Sir, it is this court's understanding you're going to plead guilty to 2 misdemeanor charges. Is that correct?
Yes, Your Honor.
First is a stated count 2 of operating while intoxicated. That is a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. Court could order community service or any rehabilitative programs the court deems necessary. The court could also order your vehicle immobilized. Court order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that?
Yes, Your Honor.
All right. And also that you'll be pleading to an added count 3 of attempted resisting and obstructing an officer.
Yes, Your Honor.
That's a misdemeanor punishable by up to 1 year incarceration or $1,000 fine plus court costs. Do you understand all of that?
Yes, Your Honor.
All right. So you also understand that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Freshour in the 1484 District Court.
Yes, Your Honor.
All right. Understanding all of that, you still wish to plead guilty?
Yes, Your Honor.
To the charge of operating while intoxicated, how do you plead?
Guilty.
To the charge of attempted resisting and obstructing, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form, is that correct?
Yes, Your Honor.
Any questions regarding any of those rights?
No, Your Honor.
Look at paragraph 5. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead guilty?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily
Yes, sir.
and of your own free will,
Yes, Your Honor.
and because you believe that you're indeed guilty of these offenses?
Yes, Your Honor.
February 23rd, 2025 at Marion Road near Michigan Avenue in Saline Township, Washtenaw County, State of Michigan, were you operating a motor vehicle?
Yes, Your Honor.
Prior to operating that motor vehicle, had you consumed intoxicating liquor?
Yes, Your Honor.
What'd you have and how much?
I had liquor and I believed it was only 3 or 4, but it was probably more than that.
Were you stopped by the police or was there an accident?
I was stopped.
What were you stopped for?
Speeding.
All right. You're not disputing the right of the police to stop you in this case, are you?
No, Your Honor.
Were you ultimately arrested?
Yes.
Were you taken to the hospital or to the police station or both?
Both, Your Honor.
Okay. At the hospital, was there a blood draw?
Yes, Your Honor.
And what were the results of that blood draw?
0.166.
Do you have any reason to dispute those blood test results?
No, Your Honor.
When you came into contact with the officers, what happened?
I pulled away from the officer and I did not obey his command.
He was trying to arrest you at that point?
Yes.
And it was a Michigan State Trooper that you did that to?
Yes, Your Honor.
All right. Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
The people are satisfied.
Yes, Your Honor.
Court will accept the defendant's pleas of guilty to counts 2 and 3. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 1484 probation. Sentencing in this matter will be June 10th, 2025. I'm sorry, 10. 9 a.m. before Judge Freshour. Bond, continue.
Thank you, Your Honor.
Thank you, sir.
That's right.
Court calls the case of the people versus Matthew. That it for you, Mr. Chairman?
Your Honor, I told you I was here to restore your good mood. There's only one today.
Wow. I am happy.
Next week may not be.
Yeah, I hear.
Jeremy Glick on behalf of Mr. Matthew Newton. Can you take your name for the
Yeah,
record?
Matthew Newton. Thank you. All right, you're requesting an adjournment.
Yes, Your Honor.
How long did you need?
After May 16th, Your Honor, he has an assessment scheduled with Mr. Statman on May 16th.
16th?
Yeah.
That objection, probable cause will be May 22nd.
Thank you, Your Honor.
Thank you, Your Honor.
25, 9 a.m. or as your invite indicates. Okay?
Thank you, Your Honor.
Continue. Thank you, sir.
Have a good day.
Court calls case of the people versus Michelle Lavas.
Lavas, Your Honor.
Wow, 2 days in a row.
Sorry?
2 days.
2 days in a row.
Don't see you forever, and then 2 days in a row.
Yes.
I'm sorry. Thank you.
Concha, Your Honor, with and on behalf of Ms. Lobas.
And you're requesting an.
We are, Your Honor. This is the first PCC. It's a pretty intensive discovery case, and we're still going through the stuff.
Gotcha. Will the 22nd work for you?
Yes.
Probable cause conference will be May 2nd, 2025, 9 a.m.
Thank you, Judge.
Bond continues. Thank you. Court calls case people versus Mark White.
David Knock on behalf of the defendant who's present, Your Honor.
Your name?
Your Honor.
Thank you. Mr. Knock, long time no see. How are you doing?
Peachy Keen, how are you, Your Honor?
I'm wonderful as always.
Your Honor, the prosecutor and I were having a brief chat about a modification of bond conditions. We expect to submit a stipulated order. One of the witnesses who my client's bond precludes him from visiting, he has a business with her. She's not a victim in the case. And so it's a landscaping business. They want to start making money this summer. Prosecutor doesn't object. And so I'm just giving you a heads up that I expect prosecutor and I to agree on an order about bond modification conditions. I also expect to file a motion for bond modification where I don't expect the people to agree about removal of the tether, but we'll submit something in writing before the next time we're in front of the court. And maybe I'll be happy, maybe I'll be wrong.
I would be objecting to a change in the tether, that's correct. And we did have discussions about some kind of modification of the bond's contact with Aaron Avery. I will say that we did discuss some kind of order. Ms. Avery is represented by Mr. Simon as well. I would be okay with some kind of limited contact as far as the equipment they share goes, but we'll see, I guess, if we can come to an agreement on the wording of that order.
Okay. The people got us some supplemental discovery as they promised, but they got it to us, I don't know, 2 weeks ago or something. We're making our way through it. And I asked if the case is still under investigation. They said it is. So I expect they'll get us some more discovery. So we're asking for an adjournment of the PCC.
How much time did you need? And you didn't fill out a green sheet, did you, Mr. Knock?
I would say a couple of weeks, Your Honor.
All right. Probable cause conference will be adjourned May 15th, 2025. 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you. I'll sign off on that. We'll get it just a second.
Thank you, Your Honor.
Court calls case people versus Marissa Bridgman.
Sherilyn Foster Tucker on behalf of Marissa Bridgman, who is appearing via Zoom.
All right. Ms. Bridgman, state your name, please.
Marissa Bridgman.
Counsel, you're requesting an adjournment.
That is correct, Your Honor.
Probable cause conference without objection, May 15th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you.
Thank you. Have a good day.
Mr. Vincent, go ahead, sir.
Good afternoon, Your Honor. Michael Vincent on behalf of Flores Nava. Put your name on the record.
Andres Flores Nava? Take your hands out of your pockets.
Yeah.
All right, what are we doing?
Need a prelim exam date, Your Honor?
Discovery is complete.
Yes, Your Honor.
People have their witnesses available to 6.
We'll do our best, Your Honor.
Will that date work for Mr. Vincent?
Yes, Your Honor.
Thank you. Preliminary examination in person, February 6th, 2025.
9 a.m. before Judge Perry.
9 a.m. before Judge Perry. Bond will continue. Thank you. Court calls case of the people versus Sadie Fidro.
Alexander, on behalf of the people, Your Honor.
I'm going outside. Michael Vincent on behalf of Sadie Fodderall.
Say your name.
Sadie Padron.
And again, we need a prelim exam date, and I'd like to adjust bond at the time.
And all discovery is?
Yes.
Thank you, D.
People had the witnesses available to six.
$5.
Preliminary examination
That's so
in
nice of
person,
you.
February 6th, 2025. That's gonna be Dan.
Yes.
At 12 noon.
Good afternoon.
That's before
Claude.
me.
Good afternoon to you too, DSN. And thank you for your generosity.
As the bond.
Yes, right now, Ms. Fodderall is not allowed, oops, excuse me. Thank you. Go to her home on 590, to 590, 590 Bagley, as a result of these charges. However, we have been informed, her father and stepfather, Chris Fry, who is here, was informed that the accuser in this matter has moved out of the house. The house is empty. Ms. Fodderall has a 4-year-old and a 2-year-old who would love to go back home. Mr. Fry is here to testify under oath regarding a text message.
But the individual that would be testifying is not the individual who resides in the premises.
He had been living there. He has now moved out. The house is empty.
And Your Honor, we have not received any confirmation from him or anyone that he has moved out as of today.
I have a witness I can bring forth to testify, Your Honor.
Well, but this witness, what's the relationship of this witness?
It's stepdad to my client who got a text message from the gentleman who's accusing my client of domestic violence and what all.
Yeah, I can't do anything with that. Has the people heard from the alleged victim in this case at all?
We have before, I don't know if we've heard from him before this hearing today, but we did before the last PCC hearing. We haven't had any confirmation that he's not at that address anymore. So I don't know.
Well, until we get that confirmation, Mr. Simpson, I'm sure you can understand. I mean, I get the position that your client's in, but I'm not going to change that condition.
I'm reluctant to contact this gentleman. I don't like doing.
I know, and that's fine, because what's really going to have to happen is they're going to need to communicate to the victim's advocate or the prosecutor that they're no longer at that address. That's typically the only way that I'm taking it.
I would appreciate it if they would proactive contact this gentleman.
I think Ms. Zenda is probably all over it already, even before you got all those words out.
It's pretty fast.
Yeah. Okay. All right. So at this point, Bond will continue with this condition.
Thank you.
All right. Thank you. Court calls the case, People versus Zane Huckabee.
That's the one for people.
Good morning, or afternoon, sorry. Sometime. Charles Noe appearing on behalf of and with Mr. Huckabee.
All right, I have a plea form.
That's correct, Your Honor. The defendant is going to be pleading guilty to added count 4 of operating while intoxicated. Second offense, 1-year misdemeanor with mandatory minimum 5 days in jail, as well as currently charged count 3, open container in a motor vehicle. In exchange for pleas to those counts, count 1, operating while intoxicated, third offense, and count 2, driving on a suspended license, will be dismissed. This plea is made with the understanding that the defendant has been screened and accepted for the Lenawee County sobriety court already, and he'll be entering into that at some point. I did discuss with the defense counsel that generally what we do in Washington County is allow someone to be sentenced by their respective district court, in this case, judge, not sure which judge, will be 15th, and then you'll go from there into Lenawee County sobriety court. There are no other agreements.
Is that a quick statement, counsel?
It certainly is.
All right. May I have him sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your name.
Zane Huckabee.
All right. Sir, it is this court's understanding that you're going to plead guilty to 2 misdemeanor charges. Is that your understanding?
Yes.
The first is the charge, the stated count 3 of open and intoxicating the motor vehicle. That's a misdemeanor punishable by up to 90 days, $100 fine plus court costs, community service, and substance abuse screening. You understand that, sir?
Yes.
Okay. The other charge is the charge added count 4 of operating while intoxicated, second offense. That's a misdemeanor punishable by up to 1 year incarceration, a mandatory minimum of 5 days in jail. Court could also order, could also order court costs, could order you to pay the cost, could order community services as well as any rehabilitative services. The court could also order your vehicle immobilized, could order you to pay the cost of prosecution as well as the cost of any emergency governmental services. You understand all of that, sir?
Yes.
All right. You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Moore in the 15th District Court.
Yes.
All right. Now, understanding all of that, do you still wish to plead guilty?
Yes.
To the charge of open and intoxicating a motor vehicle, how do you plead?
Guilty.
To the charge of operating while intoxicated, second offense, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes.
You signed an advice of rights form, is that correct?
Yes.
Any question regarding any of those rights?
No.
Please look at paragraph 5 on that form. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading guilty, you're giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily?
Yes.
Of your own free will?
Yes.
And because you believe that you are indeed guilty of these offenses?
Yes.
I know. On the date of November 3rd, 2024, location of North University near Fletcher Street, in the city of Ann Arbor, Washington County, state of Michigan, were you operating a motor vehicle?
Yes.
Prior to operating that motor vehicle, did you consume intoxicating liquor?
Yes.
Do you know what you had and how much?
Vodka and 4 or 5 shots.
All right. Were you stopped by the police or was there an accident?
I was stopped.
Well, why'd the police stop you?
Driving without headlights.
All right. Are you disputing the right of the police to stop you in this instance?
No.
All right. Were you ultimately arrested?
Yes.
Were you taken to the hospital
Yes.
for a blood draw?
Yes.
What were the results of that blood draw?
0.228.
0.228?
Yes.
Do you have any reason to dispute?
Almost 3 times the legal limit. Jesus Christ. And that from a young kid?
To contest those blood test results?
No.
Had you previously been convicted of operating while impaired on October 15, 2019 in the 79th District Court and or operating while intoxicated on or about December 17, 2021 in the 2A District Court?
Yes.
On that date, when you were stopped, was there open intoxicants in the motor vehicle?
The prior, not this case we're on, the prior one, you mean?
No, I'm talking about this case. Was there?
Yes, there was.
Was there alcohol in the vehicle? What was it?
Vodka.
Vodka? What was it in a container?
Yes.
It was in the bottle?
Yes.
Was the seal broken?
Yes.
Did you know that it was broken?
Yes.
Was it yours?
Yes.
Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
People are satisfied.
The court certainly has and would be proper.
All right, court will accept the defendant's plea to guilty to counts 3 and 4. Counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing in this matter will be
April 25th tomorrow at 9 a.m. It's the only day I have.
tomorrow.
Yeah.
That's the quickest I've ever seen.
How did,
That's the day they gave me.
for this week?
Yes. And I double check what they come over. And it was for 25th.
I think that Judge Moore generally has dockets on Friday mornings for these types of cases.
Okay, but there's a lot of those coming up. And I know she's listening. Here she comes.
Would you like me to contact them?
Yes, thank you. Have a seat. We'll get you a new date.
Okay, thank
All right,
you.
that actually will. All right.
Do we have to go back on the record? Can I just get that from the clerk?
Bond will continue. We'll get you a new date.
Okay.
And you don't have to come back.
Thank you, Judge. In bond, we did present the court with a bond stipulation to amend bonds.
Yes.
And so my client can go to South Korea for work.
We discussed it at the last hearing, Your Honor. People had no objection as long as the vendor remains testing and compliant with this testing.
Yep, that's why I put the clause in there, all the terms remain in full force and effect.
Okay, that'll work.
Okay.
We're good.
So no sentencing tomorrow, right?
We're gonna call.
Okay.
Yeah.
All right, we'll figure it out.
And we'll just pick a Friday.
Yeah, we'll figure it out.
All right, we'll figure it out. All right,
Okay.
but you can get that from my staff.
That's all I'll do. All right. All right. Thank you. Thank you, Your Honor. Nothing further.
Court calls the case People versus Michael McClure.
And good afternoon, Your Honor. Joseph Hall appearing for and on behalf of Mr. McClure, who appears by Zoom without objection. Mr. McClure, if you could please state your name for the record.
Michael Thomas McClure.
Thank you.
All right, what are we doing?
Your Honor, at this time, I've discussed the options with my client, and after being fully advised, he desires to waive his right to a probable cause conference and proceed to the circuit court.
Into a preliminary examination?
Yeah, yes, Judge. Thank goodness you're here.
I know. I speak Joe Hall, so I know what that meant. All right, sir. Sir, you're waiving your right to a preliminary examination?
Yes, sir, Your Honor.
All right, you understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes, sir, Your Honor.
And you understand you'll not have that hearing and that you'll proceed to circuit court for further resolution.
Yes, sir, Your Honor.
People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on a single count. Mr. Hall.
Your Honor, at this time, my client would waive formal reading and stand mute.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial in this matter will be set for
June 25th at 1:30 before Judge Conlon.
June 25th, 2025, 1:30 before Judge Conlon.
Thank you very much, Your Honor.
Thank you. Bond will continue. Thank you.
Thank you, Your Honor.
Thank you. Thank you, Mr. McClure.
Thank you.
Court calls the case, People versus Matthew McGill.
Take a count, Your Honor.
Jim.
Good afternoon, Your Honor. My name is Randall Lewis, and I'm standing in for Ms. Parisa Cedrina. And that is with Mr. McGill's consent, and he consents to have this hearing by Zoom. Is that correct, sir?
Yes, sir.
Okay, and state your full name for the record, please.
Matthew McGill.
Thank you, Your Honor. We're here for we have to address two issues. The first is the competency report, dated March 21st, 2025. By Dr. Margot Gilbert at the Forensic Center. I believe that both parties are stipulating to that report at this time and await the court's finding on the issue of competency, which is authored at the end of the report.
And they are indicating that he is competent to stand trial at this time. Is there any additional evidence from the people?
No, Your Honor.
All right, the court, after review of that report, would find that the defendant is competent to stand trial. Specifically, the court would find that the defendant can understand the nature and object of the proceedings against him and can rationally assist in his defense. Therefore, the defendant is deemed competent. And counsel, what you will need to supply to the court an order on competency.
We will, Your Honor. Thank you. As to the preliminary hearing, Your Honor, at this time, we've executed a waiver, and that was sent to the court this morning by Ms. Cedrina. And my client waives his right to have a preliminary hearing in this case with an understanding that the matter is going to be bound over to circuit court for further disposition.
Is that correct, sir?
Yes, sir. That is
all right.
Correct.
And you understand that a preliminary examination is a proceeding where the people have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes, sir.
And you understand you'll not have that hearing. You'll proceed to circuit court for final resolution of this matter. You understand that?
Yes, sir, I do.
People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendant is bound over to circuit court on both counts.
As to arraignment, Your Honor, my client stands mute and waives the formal reading of the charges.
Defendant having waived formal reading, standing mute, court will enter not guilty plea as to both counts. Pretrial in this matter will be set for
June 25th at 1:30 before Judge Conlon.
June 25th, 2025, 1:30, Judge Conlon.
Your Honor, thank you very much.
Thank you. Bond will continue. Have a great day, guys.
You as well.
That's it for me today. That's it. All right. Court calls case of People versus Spencer Norton.
Good afternoon, Judge. Jeff Perlman on behalf of Spencer Norton.
Mr. Norton?
I believe my client was on Zoom.
I don't. You haven't? Spencer Norton? I did not have him, counsel.
Judge, would it be possible to waive his presence? We're requesting an adjournment of the PCC.
I don't waive the presence unless the people agree, and I don't think they are given this.
I would ask to approach, Your Honor, but I can't do so in this format. I'm actually not going to agree to waive his presence. I believe, was he authorized up here on Zoom as well today?
I don't know. I'm assuming he was he?
I believe so. Yes, so I'm not, for that reason, he had easy access to court today, so I wouldn't be waiving his presence. We were planning to adjourn, but I'll leave that up to the court.
Judge, if the court's not in agreement, I just asked to pass the matter briefly so I can get him on.
I'm running out of time in this block. I got a big hearing in front of me, but I'll pass it. But you got about 4 cases to find your client.
Thank you.
Court calls the case of People versus Kennedy Braddock.
Originally different for the people.
David I. Goldstein appearing on behalf of the defendant.
Kennedy Braddock.
Thank you.
Any Friday.
May 28th, you're
on? I should have just picked one.
May 28th, that was the date yesterday.
Yeah, exactly. It was Emily's choice. That's what it would have been. All right. Okay, what are we doing in this case?
Your Honor, I was going to ask the court to set a preliminary examination, but that's going to depend on an answer from a question I have to ask Ms. McDuffie, okay?
Oh, boy.
Okay, when we were here last week, I asked for videos, and I did get some videos. What I got were body cams. My question to her, and you may not know, is are there any store videos?
Well, Mr. Goldstein, I'm not sure because you actually had Ms. Douglas last week. I had a potential.
So you're right. I'm sorry.
I had a potential offer for you. Why don't you go ahead and turn that green sheet in and we can go from there.
Okay. All right, Your Honor, I'd like her to check and see if there's going to be any.
So we're adjourning. Yeah. All right. How long is it going to take you to check?
2 weeks, Your Honor.
You want the 15th or the 6th?
15th, please.
Cause conference adjourned.
May 15th, 2025, 9 a.m. or as your invite indicates, bond will continue. Thank you, ma'am.
Thank you.
Thank you, Your Honor.
Thank you. Court calls the case People versus Antoine Pitts.
David I. Goldstein appearing on behalf of the defendant.
Mr. Pitts, come on. It's your case. State your name.
Antoine Pitts.
Thank you.
Your Honor, I've requested an adjournment in this matter, and I'll let the court know why. Again, there were videos that I requested. I did get them. However, they're coming on a new platform directly from the Michigan State Police, and we're having a lot of trouble getting them to download and open. So I'm still working on that. So if you were to ask me, do I have all the discovery? I'd have to say no.
Got it. Okay. Probable cause conference, May 15th,
Please, Your Honor.
2025, 9 a.m. or as your invite indicates, bond will continue. Thank you.
Your Honor, there is one quick matter on this bond. When bond was set in this matter, he was ordered to test at community corrections. He was already testing for probation. And he was asked me to ask. He's on probation to Washtenaw County Circuit Court, Your Honor.
And my job is like on me about it.
So it's basically testing twice.
How often are they testing?
Once a month.
Once a month?
Yep.
There's testing here, the frequency is one time per week.
Yeah. I don't want to get fired though, Mr. Simpson.
Pardon?
I don't want to get fired though. I got to keep calling off my job. Oh, I got to have a job.
This is a drug possession offense, Your Honor, with a relatively useful offense. And so, Your Honor, we do believe that the more frequent testing is appropriate at this time.
What was the alleged drug of choice for him?
Cocaine.
Got it. And you're working?
Yes.
What I'll do is I'll send over an order. I'm going to reduce this testing. Young man, if you mess this up,
I'm not.
I know people tell me that all the time. So just listen to me. You mess it up, Mr. Goldstein to tell you, I'm not going to be listening to a lot. You will go. You hear me?
I understand.
So I'll reduce this testing to once every 2 weeks. So I'll cut it in half.
All right, thank you.
Thank you, Your Honor.
All right, that way at least he'll have 3 tests. He'll have 3 tests in a month.
That's right.
Get 1 down there.
Instead of 5, and that's
right.
That's great. Thank you, Your Honor.
Court does call the case People versus Ashkan Khan.
Ready, Your Honor.
Rachel McDuffie for the people.
Good afternoon, Your Honor. For the record, Tim Davalski on behalf of the defendant.
Okay, I have before me a plea sheet that indicates that the defendant is going to be pleading guilty to counts 3 and 4, added counts 3 and 4, which is use of a narcotic, 1 year fine for cost offense, and open intoxicants in a motor vehicle, which is a 90-day, $100 fine for exploit cost.
That is correct, Your Honor.
All right, upon the successful plea to that charge, counts 1 and 2 would be dismissed. There is also an agreement of no objection to 7411 in this case.
That is correct.
Sorry. Okay, I have him sworn.
Raise your right hand. You solemnly swear to affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
State your name.
Ashkan Khan.
All right, sir, it is this court's understanding you're going to plead guilty to 2 misdemeanors. Is that your understanding?
Yes, Your Honor.
The first is an added count 3 of use of a controlled substance. That's a misdemeanor punishable by up to 1 year incarceration at $2,000 fine plus court costs. You understand that?
Yes, Your Honor.
And also the charge of open intoxicants in a motor vehicle, a misdemeanor punishable by up to 90 days, $100 fine plus court costs. You understand that?
Yes, Your Honor.
Understanding all of that, you still wish to plead guilty?
Yes, Your Honor.
To the charge of use of a controlled substance, how do you plead?
Guilty.
To the charge of open intoxicants in a motor vehicle, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form, is that correct?
Correct, Your Honor.
Any question regarding any of those rights?
Oh, yeah.
Please look at paragraph 5. Those are your rights which are part of the trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right?
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily?
Yes, Your Honor.
Of your own free will?
Yes, Your Honor.
And because you believe that you're guilty of these offenses?
Yes, Your Honor.
November 9, 2024, at the location of Carpenter Road near Packard Road, Pittsfield Township, Washtenaw County, State of Michigan.
Were you in a vehicle at some point?
Yes, Your Honor.
And was there alcohol or some type of liquor in that vehicle?
Just empty bottle with what
was it?
Yes, Your Honor.
What do you have? What kind of alcohol was it?
It was just whiskey.
Whiskey? And the seal, there was at least some liquid in that bottle.
Correct.
And the seal was broken on that bottle? All right. And on that same date, you were using a controlled substance, hydrocodone?
Yes, Your Honor.
Did you have a prescription for it?
No.
All right. And you knew you had it in your possession?
I didn't know I had it.
Yes, you did.
Yes, I did.
All right. And you had used it recently or that day?
Yes, Your Honor.
All right.
Oh, good save by the attorney. Did you know you had it? No, I didn't. Yes, you did. Oh, I did, Your Honor.
Counsel, have I complied with the court rule?
You have, Your Honor.
Defendant's
He wants that question.
Court will accept the defendant's pleas of guilty to counts 3 and 4. Counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 14A1. Probation sentencing in this matter will be May 14th, 2025, 9 a.m. That's before me.
Thank you, Your Honor.
Thank you, Bond. We'll continue. On the left-hand side down the hallway, when you're walking out, you can stop at our probation department and begin the process so that we will have a smooth sailing come the 14th. Okay? Thank you. Court recalls the case People versus Spencer Norton.
Maybe Rich McDuffie for the people.
Good afternoon again, Judge Jeff Perlman on behalf of Spencer Norton. Judge, I've called him several times, continues to go to voicemail. I'm not sure what's going on. He knew about today's court date. Again, I would request for a brief adjournment. He hasn't, since I've been representing him, he hasn't missed any court dates. And I'm hoping there's a valid explanation.
Well, there's a process for setting aside if there's a valid reason which you can get to the court. But at this point, I'm going to issue a bench warrant for his failure to appear. Bond is set amount of 10,000 cash surety. That warrant will issue immediate.
Thank you, Judge.
Thank you. There's Ms. Britton. Tell and the Mr. Simpson into a break. All right, I'm gonna leave. Court does call the cases of the people of the state of Michigan versus Willow et al. Counsel, please state your appearances. I'll start with it.
Good afternoon, Judge Reichman on PA 3665 on behalf of the county.
Thank you.
And I'll also stand in for Mr. Hadar on behalf of Mr. City.
Got it.
Okay. Thanks. Good afternoon, Your Honor. May it please the court. Amir Mack representing Samantha Lewis is present.
Good afternoon. If it please the court, John Minnick appearing on behalf of Avi Taknafram, who is here via video, and also with the court's permission and with the consent of Mr. Kozler, standing in for Stacey McNulty on behalf of Mr. Kozler.
Check right, Mr. Kozler.
Yes.
All right. Very good. And
good afternoon. Jamil Puja appearing on behalf of Samoa.
Or on behalf of Mr. Cage.
all right, thank you. And Mr. Tetrafrom, you'll need to turn your camera on, please, sir. All right, thank you. All right, this is the
I'm guessing drugs.
defendant. Well, let me try to clarify one thing from the beginning, because defendant's motion to disqualify the Attorney General. All parties except one joined. And I just want to make sure, was this argument on behalf of also Mr. Ada?
Your Honor, on behalf of Mr. Siddiqui, standing in for Mr. Hadar, Mr. Court would accept our oral motion to join.
All right, very good. Actually, to make things a little bit easier if he's joined. All right, very good. All right, now that we've done that, who is going to begin the argument?
I will.
All right, go ahead, sir.
Thank you, Judge, and may it please this court. Your Honor, we're here today on the principle that an impartial justice demands that the prosecution of my client, Samantha Lewis, and her fellow student protesters be handled by a neutral third party and not by the Department of Attorney General and by and through our Attorney General, Ms. Dana Nessel. It's our position that that office has already demonstrated both actual and apparent bias towards pro-Palestinian protesters. Let's be clear here, Your Honor. This is not a motion rooted in politics. It's rooted in the law. It's rooted in our Constitution. It's rooted in the fairness that we're seeking from this honorable court and the due process that we're entitled to. Judge, it's rooted also in the basic expectation that prosecutors are ministers of justice and not political actors. And the reason why we bring this up is, and I'll begin with really an exhibit that the prosecuting attorney in the Attorney General's office attached to their response to our motion. A letter in May of 2024 directed towards the General Counsel of the University of Michigan, Mr. Tim Lynch. In that letter was a solicitation of these criminal prosecutions. In fact, and I quote this letter, that it's written that by Ms. Hageman Clark, who I believe is going to be arguing for the prosecution in this case. It says, I write today to offer the DAG's assistance with investigating and prosecuting any cases that arise from recent demonstrations on U of M's campus. That's a direct solicitation. It also goes further, Judge, and this is really very interesting to the defense, that they indicate, I would also note that our department has specialized expertise in the intersection of First Amendment free speech rights in the context of criminal prosecution. Judge, they're telling the University of Michigan Attorney General that we're experts in the criminalization of free speech. That's what that sentence indicates to me. And the attorney
That's fair. I mean, I don't know that that's what it's indicating. I mean, as I read it, and I'll let you certainly argue, counsel, but I don't know if that's fair. I mean, what it seems to me it's really saying is that sometimes when you're dealing with the criminal law, there are other constitutional implications. One may be the free speech, and that trying to sort all of that out, that we're experts in dealing with. I mean, that is just as fair a representation, isn't it?
The court can look at it in that light, Judge, but I'm asking the court to look beyond the narrow scope of this and take a look at some of the other factors that come into the totality of the circumstances of this solicitation for this type of work. Your Honor, it's true that they've bypassed local prosecutors, city attorneys, county prosecutors who at the time of this encampment had foregone the opportunity to bring criminal prosecutions and any pro-Palestinian protest activity. Peaceful protest conduct wasn't prosecuted by anybody.
Can I just stop you there for a moment?
Yes.
Because that was one of the things for me, and I would certainly give the Attorney General an opportunity to respond to this. As I'm reviewing all of this, the letter, there are certain assumptions being made about what the local prosecutor did or didn't do, right?
I agree with that.
Your brief, and it's kind of cited in the response from the people, and then also cited in your reply to their response. What evidence or anything do I have of what Mr. Savitt did or didn't do?
Your Honor, I can't stand before Your Honor. I cited public articles that had some statistical data that was presented in the Guardian and in national publications. I didn't subpoena or FOIA any of the declined prosecution requests where warrants were denied or things of that nature from Attorney Savitt's office, prosecuting Attorney Savitt's office. What I do know, and this is proof that this is a letter from the Attorney General's office, and this is in an offer to take up some of these cases. And it writes, and I'll bring it into this argument, Judge, that Washtenaw County Prosecutor Eli Savitt recognizes that his authority is confined to Washtenaw County. He is comfortable with the DAG overseeing these cases based on his jurisdiction being limited to only Washtenaw County, as if this was an acquiescence by the county prosecutor saying that it's okay, we're in agreement, we're comfortable, is the word that's in this letter, that the Attorney General's office can take it. Now, when we go further to some of the conduct of the Attorney General herself, Judge, we didn't know that there was going to be an appearance of impropriety or implicit bias until the Attorney General's office themselves filed a recusal from a high-profile case involving Arab American elected officials in Hamtramck. In that specific context, and it was written, and I attached that in our initial motion, that she publicly rallied against them and admitted that critics had alleged bias against Muslims and Arabs in her handling of other pro-Palestinian matters, which was a reference to this specific case. And that's what she used, the standard, when she asked a court to remove her office from being a prosecuting attorney in that case, Judge. And so
before you get into that issue, I want to just back up to the letter again, because I've got a lot of questions regarding that. Is it the defense's position that Mr. Savitt declined to prosecute, then the AG took up the cases, or that these cases are just sitting there, that nothing is happening with them, and that the AG takes them up? Because those, to me, would be very different things.
I can say, as an officer of the court, in my investigation of that specific question, I spoke to members of Mr. Savitt's office. And my understanding was that it's not that they declined to take these cases, that the Attorney General's office offered to take these cases, and then they didn't have a problem with that opportunity to have something that's not on their docket anymore. You know, they didn't need to have this workload. And so when the Attorney General's office came in and made this offer to the university, the local prosecutor, which would be the normal form of jurisdiction in this case, in any trespass case, Judge. This is a trespass case and a resisting and opposing case. These are state cases that are filed by local county prosecutors or city attorneys, if they're just misdemeanors. That would be the norm. But Eli Savitt's office, from my understanding, didn't say we're not taking these cases or declined warrants on these cases, only that because the Attorney General has asked to take on this investigation and the potential prosecution, that they would acquiesce to that request.
Okay. And if that's true, is there a writing which evidences that?
Not that I have discovered as of yet.
Okay. That's fair enough.
And Judge, further, the letter is arguably soliciting for criminal prosecutions. I mean, that's what it looks like from my perspective. And it's from a public university, which is a third party. And the Attorney General's office is actively offering to investigate and prosecute any cases that arise from recent demonstrations, quote unquote. Those are the words used in that letter. It has potential ethical concerns. Prosecutors are supposed to remain detached. We're supposed to remain impartial arbiters of justice, not proactive hunters of politically sensitive cases, especially when local prosecutors are available. It undermines the confidence and the fairness of the neutrality of that office. And when I go to the next point, Judge, of recusing, the Attorney General recusing themselves from the Hamtramck investigation in case, I think that shed light on that the Attorney General herself believed that there was an appearance based on appearing biased, warranted recusal in that case. And now they claim that they have neutrality here. And the same criticisms have been raised. What's good for the gander is good for the goose. You can't go in that argument in that jurisdiction and say that we don't want to have an appearance of impropriety, and so we're asking for appointment of a special prosecutor, and in the same breath, come over here and say, no, the appearance of impropriety is not the standard. The appearance of it's actually been MCR or MR PC 1.9 doesn't say that appearance of impropriety is the standard anymore. You can't make that argument now and say in her petition for special prosecutor in the Hamtramck case, she specifically said to avoid even the appearance of impropriety, justice can be more aptly served by the disqualification of the MDAG and the appointment of a special prosecuting attorney. Your Honor, they don't get to make that argument on both sides of the coin. They can't say in that case that that's not the standard, then come over here and say, well, Judge, don't worry about the appearance of impropriety anymore, because that's not what the court rule says. There's case law, however, that does support. And I cited the case law, Judge, People versus Pappel, which is 246 Mishap 282. And in that case, it is a appearance of impropriety standard. Your Honor, these are selective prosecutions. These are situations where this prosecuting attorney is attempting to circumvent their own political opinion and bringing these prosecutions. Our Attorney General has filed a response indicating that they didn't participate in demonstrations against pro-Palestinian speech, which is unlike what she did in Hamtramck, where there was some demonstration about not having flags in support of gay rights being flown in Hamtramck. And she spoke publicly about that issue, and that's why there's a distinction in this case. However, Judge, I say that's not true. She was very, very public about her response to our Congresswoman, Rashida Tlaib, and called her protest activity as anti-Semitic. She has never said that pro-Palestinian speech is potentially, she has never said that pro-Palestinian speech is allowed under the law. She's never spoken in support of the ability to free speech on that issue. She's only always criticized pro-Palestinian speech in the media and in meetings with people and individuals. So that gives us another argument. Now, also in their response, Judge, they compared this case to other scenarios of different race. And they believe in the belief and the like to show that removal is not proper when the prosecutor and the accuser are of different faith and belief. There was a sentence in their response that spoke as to the Jewish faith of our Attorney General. And I'm saddened that was a response that they gave, because that's not the position of the defense by any means at all. And I think that argument takes away the merit of what we're trying to accomplish here. They're mischaracterizing the defense's argument and trying to distract from the real issue. The Attorney General's conduct it's not about her religion. It's her conduct that gives rise to the concerns about bias. It's not her identity that necessitates the recusal in this case at all. But the public statements she made in condemning pro-Palestinian advocacy. And the example that we cited is when she called Rashida Tlaib's protest speech as anti-Semitic. Her disproportionately aggressive charging decisions. She's charged these students with felonies. Other jurisdictions didn't charge, and every case stands on its own 2 feet, Judge, I could say that. But in Wayne County, Kim Worthy's office filed 0, none, not a single case was prosecuted in Wayne County. In Eli Savitz's jurisdiction, I think maybe a small handful of cases were charged. None of them were felonies, from my understanding. Now, and then you add in the identical case of a situation where Arabs and Muslims are targeted for, in the Hamtramck case, and she herself acknowledged the appearance of impropriety. They brought that issue up. It's not something that just we pulled up and said it. We made it up. They brought that issue up first, Your Honor. We didn't know that there could be an appearance of impropriety until she said she believes that she could be biased or appear to be biased. And so if you feel that you can be biased in Hamtramck, you cannot be impartial here. And that's the major point in this case, Your Honor.
Can I just, so I think, and I'm relying upon my memory, but I state what happened here in Washtenaw County. All of the felony PCs come past my desk. So I seem to recall, listen, that there were cases that were filed by Mr. Savitz's office that ultimately I think were resolved. I think they initially started as felonies and then were resolved as misdemeanors. I'd have to double check that.
I think the court's right in that recollection. I think that you're right.
And I think that's what happened. And I hate sort of bringing you back, and I want to make sure that I get to your full argument. That's why I'm trying to figure out, there were those cases that I'm recalling, and then there are these cases.
Your Honor, in those cases, they were settled into diversionary pleas. They were settled into pleas under HIDA with no convictions. And they were not brought with this type of vigor.
Well,
yeah,
right.
Yeah.
But all that aside, what I'm getting at is I'm trying to figure out if those cases were brought and then resolved, however they were resolved, but they were brought, what happened with these? I mean, because my understanding is they all were hit at the prosecutor's office roughly the same time. I think co-counsel may want to. Four. Two misdemeanors under HIDA. Others got street diversion dismissals. Right? And it was very early on in the piece. No insistence on these statements.
That's correct. Yeah, Your Honor, Mr. Kuja, who was counsel on those cases.
Hold on one second. Right.
And Mr. Minnock.
That's exactly what you're saying. Okay, go ahead.
The brother counsel, Mr. Kuja and Mr. Minnock, were both involved in those in the defense of those cases and are acutely aware of the interactions more than I am, Judge. But Mr. Kuja recognizes that and told me, Your Honor, just now that 4 of those were done at the early stages, PCC, where they offered diversion and pleas under HIDA. And I want to circle back on the people's argument about their willingness to participate in plea negotiations in this case, Judge. In this case, and the court really doesn't usually like to get into plea negotiations, and I don't want to get too far into that, but they brought it up, Your Honor. That to me doesn't make it more, the people are trying to make it appear that they've been more lenient or have done more to favor our collective clients in this case by engaging in potential plea negotiations when, they shouldn't have brought these felonies into the first place from our defense position. But you can't just charge students with felonies and say, hey, well, we're engaging with plea negotiations, and so we are acting in good faith and we're going to be lenient towards you. That leniency does not excuse the initial and politically motivated decision to charge these cases. So they brought that up, and I just want that to be noted for the record, Your Honor. And then they're demanding certain things in a plea negotiation, which I don't want to get too deep into in front of Your Honor. But
counsel, again, I realize this is a difficult question to answer, but something I think that plays into my analysis as it regards where these cases were.
All right.
So I had, and I was correct, my staff let me know, I was correct that there were these 4 felonies, and I think that's what Brother Counsel was indicating to you.
That's right.
There were these 4 that came through. They were resolved in some way that there were misdemeanors. Now,
yes, under advisement of diversion, which didn't have a conviction at all.
That's factually, I don't think anybody can dispute that, sir, right? At the same time, there are these cases, right? Or cases like them coming in. And what I'm trying to figure out, and maybe this may properly be addressed to the Attorney General,
or maybe Mr. Savage's office is, what happened with those cases? Like, maybe put a better way, is there were those 4. And then I have these 7, and there are 2 more floating around someplace else. But my concern are these 7. These 7 take a different path, right?
Right.
And so why is that? So sometimes it can happen where a local prosecutor says, we are not prosecuting these because for X reason. And then they send it up to the AG's office for reassignment to someone else. Or where they say, we're not doing these, and the attorney general then takes and they prosecute the case. Okay. And I have those come through all the time. What are you believing? As I listen to your argument and I read your argument, you're saying that that did not happen.
What I'm saying happened, Your Honor, is that Dana Nessel's office went and picked these cases up. That's our position. Not that Prosecutor Savage was unwilling to prosecute them or didn't or decline them. This Attorney General's office went and solicited this work and picked up these files, these specific defendants.
Okay, so if that's true.
Because this letter is dated May 24, Your Honor, which is only 2 days after the encampment, I believe. Am I right? 21? 2022?
Okay, so if that's correct, what legally would prevent the Attorney General from doing that?
Your Honor, that's the ethical conundrum that I see, Judge. I think legally that shows, under the court rule that we've cited in the case law, in conjunction with the other issues that I've raised in the brief, that this is a selectively prosecuted case. This is not done as a neutral and impartial minister of justice that the state is, supposed to have. This is somebody that cherry-picked the case and decided, I'm going to be the one who takes this on because it is my office that has a specialized expertise in the intersection of free speech rights in the context of criminal prosecution, which I already told you what I believe that means is I like to criminalize free speech.
So you're saying that if the AG's office did that, that there is an ethical issue. I'm going to have to say I have some qualms. While I know what you mean, I have some qualms about the use of selective prosecution because that can mean a different thing in my mind. But I think I get the concept of what you're putting forth when using that phraseology. All right.
Thank you, Judge. Okay. Right. I agree. We're on the same page, Your Honor. Yes. Your Honor, that's the totality of my argument today, Your Honor. Unless the court decides that we should have an evidentiary hearing on some of these unanswered questions, I'm open to that opportunity as well if the court would like that.
Good evening, Your Honor. Danielle Heckman Clark on behalf of the people. I'll start with the issues that the court has raised. Since I'm the one who actually wrote that letter, I'm not criminalizing free speech. It is as the court has said. We have a specific knowledge in our department because it houses the Solicitor General Bureau that deals with issues of First Amendment rights to free speech. And when you then add on criminal context, it becomes more complicated. I wrote that letter to Mr. Sabat after I spoke with Mr. Sabat and said to him, hey, we'd like to help you with these cases. Are you interested in that? And he said, yeah, because we weren't just investigating what happened at U of M's main campus. I think we all know we were investigating something much bigger in events that had gone across multiple counties. And so we are the only prosecutorial agency in this state that has multi-jurisdictional authority.
Did you indicate that you sent a communication or some type of letter to the prosecutor?
Oh, I talked to him on the phone, Judge.
Okay, go ahead.
Talked to him multiple times on the phone. Because contrary to public belief, the AG's office doesn't have an opportunity or a legal mechanism to simply come in and say, get out of the way, we're taking that case. There is no statute. There is no law. There's no case on point that says the AG's office can do whatever they want. And we don't operate like that. As the criminal bureau chief, I offer our assistance to all 83 elected prosecutors on cases from anything as simple as a misdemeanor all the way up to first-degree murders on a daily basis. It isn't selective prosecution, although I do take exception to that, because quite frankly, every time a prosecutor exercises their discretion to put pen to paper and charge someone, it's based on a review of the facts as applied by the law and whether or not we believe we can prove that case beyond a reasonable doubt. Some would say that is selective prosecution because not all cases get prosecuted. Oftentimes cases do get denied by local prosecutor's office, and our policy in our office is not to act as an appellate review to those 83 elected prosecutors. But if a local law enforcement says, hey, you know what, we think that maybe they just missed the ball on this one, or this prosecutor didn't look at this, or we need to develop more evidence, we want to bring it to your office to take a review, we do that every single day. And we've done that with cases in front of this court. The Isaiah Williams prosecution was one that this court heard multiple days of testimony about, where a young baby was kidnapped and murdered by a woman's boyfriend back in the 80s. Washtenaw County Prosecutor's Office looked at it and said, you know what, we're going to pass on that. And so the Ann Arbor Police Department brought that to our office. we charged it, we brought it to exam, we ultimately took it to trial. Mr. Williams is convicted. So it happens every single day. In terms of the SPA process, there seems to be a fundamental misunderstanding of how a request for a special prosecutor works. It has nothing to do with going to court. It doesn't get filed with the court. It happens by each one of the elected prosecutors, and it happens with the AG's office, where they put together the SPA petition. And they say, in this case, the facts of the Hamtramck SPA petition and the alleged voter fraud and ballot harvesting could not be reviewed by our office because the Attorney General protested those specific defendants that now they're asking the AG to take a look at to decide whether or not they committed criminal events. Her protesting them publicly and saying, you, Mr. Suspect 1, you, Mr. Suspect 2, you, Mr. Suspect 3, and 4, I publicly called you out, and now I'm being asked to take a look to review whether or not I should be charging you. This is a case that I believe, as the prosecutor, is rightfully placed somewhere else.
But, Madam Prosecutor, is that really indeed the case?
Yeah.
When I look at use in the petition, there's specific mention of the U of M demonstrator cases.
Yep.
Well, why, and also then by the press arm of the Attorney General's office too, but it's particularly in this, so why is that mentioned? If you're saying it's as simple as what you're saying, that I've been critical of these individuals, so I can't do this, I can't do that. Why are these cases even mentioned in?
Because if you look at paragraph 6 on page 2, it says she has been criticized for her prosecutions of pro-Palestinian protesters at the University of Michigan. And what always fails to get added to this discussion is this piece. Critics have alleged, albeit without justification, that these prosecutions were brought due to bias against Muslims and or people of different descent. It is likely similar that the same criticisms would follow any prosecution in Hamtramck. And I would say that this criticism of her bias has been a noise. It has been a distraction to what are the real issues in this case, which is getting to whether or not these defendants have committed criminal acts. That did not need to then go spill into another prosecution involving people of the Muslim faith. And I will admit that those folks are not of Arabic descent. I was mistaken when I said that. It's my understanding that they're actually Bangladeshi. So I clear the record on that. The difference between this SPA and the instant facts is the AG's own behavior. And defense wants to say that it is analogous to AG Nessel calling out our congresswoman, when it's the AG's position and our position that she simply clarified a misstatement. It is this phrase from the river to the sea that people differ in how they view that, whether it is viewed as a pro-Palestinian belief that Palestinian folks have a right to live free, or if it is being used as a full destruction of Jewish people. There are different opinions about what that means. And that is what AG Nessel was calling her out about. But to say that she has gone out of her way to criticize these defendants, she has not. There has been no conduct by the AG other than to say that lawful, peaceful, permitted protests are not against the law. And that she encourages folks to engage in that behavior, but that is not what we have here. And that is why these defendants.
But why even put paragraph 6 in? If it's as simple as you're saying, that there was criticism of these particular officials in Hamtramck, why even mention it? Why even mention these cases? Because she could have, if I buy what you're saying, because she was critical of the individuals in Hamtramck, the individual council people, without mention of any of these demonstrations, she could have recused.
Yes, she could have.
Then why mention it?
Because the noise around this and them calling her out consistently for being biased without justification would have followed her into the Hamtramck prosecutions. And so I believe
no, what I'm saying is she says, I'm handling cases. If she says even there's some unfounded notion because I'm Jewish that I feel this particular way in this and may feel that way in this case, or because of their view regarding gay rights, I may feel this way in this case in my participation in the rally. And I feel then, and I'm not going to say it as articulately as it probably should be said, but I feel that based upon that and the perceived notion of bias that may follow from those activities, those statements, those things, that I am going to recuse on the Hamtramck case. Except this is different because in this statement, as well as in the public statement that's made, they bring this in as part, these cases here, in as part of the justification for why I'm recusing.
Yeah, so perhaps my SPA was inartful. The recusal is based upon her behavior, protesting those folks. I brought, no.
Yeah, but that's not what this says.
It does say that, Judge. It says that on paragraph 5. It's undisputed that she's been critical of policy positions taken by the Hamtramck City Council. It's in there first, even speaking at a rally against these particular suspects. It's in the paragraph immediately preceding 6 and 5. It is the primary justification for why the refusals.
Then why even have 6? That's my problem. My problem here is I don't think, and maybe for this court, it would be a much easier decision had the defendants brought this motion and there weren't the statements on behalf of the Attorney General's office that even mention these individuals. Because frankly, from my standpoint, I would have said, okay, Hamtramck's Hamtramck, we're Washington County, this is these cases, and we're done. But it's really isn't it really the Attorney General's own statement and confluence of these cases and who these people are that make this an issue?
Yeah, I would say that I should not have added it. Standing here before the court today, if I had to do it over again, I certainly would not have included it.
Okay, but now, right, but now when I'm then asked to look at it and then try to make a determination as to whether or not there would be the appearance of bias, I can't say, gee, they said they shouldn't have put it in, so I'm not, I can't do that.
I understand. Okay. It's our position that the standard as laid out by.
Yeah, adding in unnecessary things in a filing can come back and bite you. Especially if you admit, yeah, we shouldn't have. Well, now Judge Simpson, he doesn't have a choice. He has to read it in its entirety. He can't just pick and throw one of the arguments away, because this is the entirety of your argument, including this paragraph 6.
Herrick and Pluffle is not an appearance of impropriety. It's included here because that is part of the analysis, but it's not the law. This court is directed to look at whether or not there is an actual conflict. And the actual conflict has been defined as being either in one of 2 categories. Is there a former attorney-client relationship between them? Clearly there's not. Or is there a situation where the prosecutor has an interest in the outcome, whether it is emotional or religious, as the defense has claimed, I would submit that it's not.
Judge, I would object to that because nobody has mentioned anybody's religion except for the Attorney General.
It's in the
Well, I think I did. So, look.
Oh, this is going to be interesting. But I missed a donation via PayPal from Shelley, who gifted $20. $20. Let's see, where are we now? 20 plus 5, 25, 30, 32, 34. What did I say? 15 times 2 is 30. Ah, folks, we are at a shot of whiskey. We are at a shot of whiskey. Oh, thank God I checked my email. Yay. And I'm doing it in my Bucky's shot glass. And thank you, Shelley. Now, that was an hour ago, and I missed it. I'm so sorry, Shelley. Thank you so much. That is so, so generous. Cheers. Ooh. Thank you, thank you, thank you. And now, back to court.
But I note the objection. I'm just going to say, look, I am not going to be paying attention to whose religion is what, because frankly, for the most part, unless you tell me, I have no idea. Nobody knows what my religion is, right? So I can't pay attention, and I'm not going to make a presumption about what somebody's religion is, or if they have one. It's irrelevant to me. Right? I mean, so it's noted, but I'm going to let people argue. Go ahead.
Thank you. So in their reply, they really narrowed it down to 4 issues. Whether or not the AG bypassed the local prosecutor, which I submit to you, we did not. It's my understanding that there were 4 felony cases that were charged by Prosecutor Sabat at some point in the fall of 2023. And then it's in May that I write the letter to say, hey, if you want help, we're here to help. There is no solicitation outside of the normal course of business. That happens, as I previously stated, all of the time. We offer to assist on everything. They cite to a higher charge rate. Now, again, using an article that I think is false, what I can tell you, because I have no idea how many warrants were sent to Mr. Sabat's office or how many warrants were sent to Prosecutor Worthy. What I can tell you is that there were 7 different incidents that were sent to our office for prosecutorial review. There were 37 suspects, and we charged 11.
Thank you, Lord.
So the numbers that are cited by the Guardian, we've repeatedly told them are incorrect. We've provided them with the correct numbers, and they refuse to change it. 2 of them have been resolved by way of plea, 2 are charged with trespass, and the remainder are here. So whether or not that is selective prosecution, I think I've already said that I believe every prosecution involves prosecutorial discretion. The public statements that are critical of pro-Palestinian figure, that being Congresswoman Tlaib. Again, there were posts about this statement of from the river to the sea and what it means to certain groups of people. The statement today that AG Nessel has never said, I'm supportive of pro-Palestinian rights. I don't understand that argument in the sense that he said everybody has the right to say what they want. Even repugnant things. If it was the right, those folks have the right to say that, even if I disagree with it. And what she has always consistently said is that peaceful, lawful, permitted protests are within the bounds of the First Amendment, and she encourages that, particularly given our political climate. And finally, we talked about the Hamtramck spa. They are factually very different. She protested them publicly. She has not done any of that here with these defendants. There's nothing on this record, I don't think, where they can point to that she has an interest that rises to the level of the standard, which is an outcome that is personal, financial, or emotional, either in the case or with the accused. There's nothing on this record to show that she has.
Counsel, that's where I'll be honest with you, you're kind of losing me. And I'm going to go back to paragraph 6,
okay? Because
in paragraph 5, you're right. Paragraph 5, you talk about the Hamtramck case. When I get to paragraph 6, in paragraph 6, the U of M protester cases are brought up. But then what ties it together is that last sentence in paragraph 6. And I'm trying to figure out why the Attorney General is not acting the same way with regard to Hamtramck as to these cases, because this is what's said. It is likely similar criticisms would be raised if the prosecutions were brought here as suspects 1 through 5 are of Arabic descent. See, to me, that's saying, look, I'd be criticized for that. I'm being criticized for that in these cases. So in the Hamtramck case, I'm recusing because there is that criticism and I want the appearance of fairness. But then it goes further to say, it is similar to, these aren't my words, this isn't my conclusion. It says these are similar to, that you tie the 2 cases together in the sense of what that perception is. And so it's hard for me, and maybe you can help me, to get to the point that if I'm recusing because I have some bias or perceived bias in these cases, and I think that that perception of that bias is or that criticism, that bias, whatever it is similar to these cases, then why, particularly as a prosecuting official, why wouldn't I deal with them the same way?
These cases don't have that added fact that the Hamtramck case, and that is listed in paragraph 5. There is not that public protest. That is the first basis.
It is likely similar.
It is.
Criticisms would be raised if the prosecutions were brought against these suspects, not because of the protest. It says, as suspects 1 through 5 are of Arabic descent.
Yes, because that is what she is consistently hearing, is that these prosecutions are based on the speech and who they are. And it is likely that that would have been the same thing that would have happened with the Hamtramck case. Again, it is a distraction. I think it's a distraction here, and it would be a distraction to those.
But then why wouldn't you treat them the same? Why wouldn't you say, if I'm going to recuse because of that in those cases, why wouldn't you do it here?
This case doesn't have that extra protesting that she did against those specific defendants. I believe that is what makes the difference.
Judge Simpson is smelling BS.
Thank you, Judge. I've heard it said a couple of times that defendants are entitled to a neutral prosecutor. I don't know that I've ever been neutral in any of the cases that I've ever prosecuted. And I don't think that that's a fair standard to apply to any. Anytime you put on the paper and you charge someone with a crime, whether it's a misdemeanor or life sentence, you understand as a prosecutor that your duty is to do justice, and you follow the evidence no matter where it goes. And that is what we have tried to do with these cases and with every case that we hear about. I would submit that the agency does not have a conflict in this case, and we should be allowed to continue.
So, okay. Good. Fine. Okay, so some of the issues that were raised was that in the Hamtramck case, there was a public protest by the Attorney General, and that's the difference here. But in this case, there also was a public protest by the Attorney General when she called press conferences with other politicians, specifically to go after the phrase, "From the river to the sea, Palestine will be free." Because that is a phrase that these protesters and just about every protest demanding Palestinian rights going back decades.
For you who don't know, the phrase "from river to the sea" in practicality means eradicating all Jews who live between the river and the sea, which is the entirety of the state of Israel. That is what that phrase means. Now, there are a lot of people who have no idea that Israel is between the river and the sea. But that is, and as you said there, it's been screamed for decades. Yes, because it comes from a time where Israel was under a direct threat of annihilation. And it's been going on nowadays, especially amongst students or younger people. They don't know. It's a cool chant. But the actual meaning of it is eradication of Jews. That's today's history lesson.
Is used. Attorney General Nessel, I think State Senator Jeremy Moss held a press conference where they say that it is an anti-Semitic and it is a battle cry for those who want to kill Jewish people. Dana Nessel then said at the press conference, those words are anti-Semitic to us. And it looked as if she was holding back tears. I said, it is still painful. It still hurts us. And there is video from this protest of these defendants using that same phrase that Attorney General Nessel called a battle cry for those who want to kill Jewish people. Anti-Semitic words that are still painful and hurt us. And she's gone out of her way time and time again to attack the only Palestinian American member of Congress for nothing that concerns the duties of the Attorney General.
Now, in this, if the Attorney General is disinvested, then yes, she should recuse herself. Because it's too close, in my opinion. It should be handled by a more neutral party, in my opinion.
But she has held these for what? To criticize that Congresswoman's speech. That is the same speech that these defendants engaged in. And yes, I think we should look at the letter that they wrote for Hamtramck. Because as the court points out, paragraph 6, they chose to include it. They can't say, well, hey, we had one standard in Hamtramck, and then, oh, by the way, it was a mistake on our part to include that paragraph because we didn't realize it was going to mess with our prosecution in Washington. Because that's what's essentially being argued here is, well, maybe we didn't need to include that. Could we ignore that we did? Could we forget about it? Because now it's come back to bite us here in Washington. It doesn't work that way. They filed this in court. They signed it. We only know about it because the Detroit Free Press reported on this case. That's how we found out about it. We don't know anything about Hamtramck. And the fact that those individuals were protesting on another issue, those individuals, the Attorney General protested their positions on gay rights and the waving of a gay pride flag outside City Hall. And the Attorney General points out today that, yes, I mistakenly referred to them as Arab. They're actually from Bangladesh. I'm assuming they might be Muslim. Judge, we don't mix this all up. We don't, I don't know what their views, I don't know what the relevance is of those individuals being, even if they are Arab, all of them, or some of them are Arab, and some of them from Bangladesh, or if their religion is Islam. I don't know what bearing that has on this case and why this case was mentioned there. I don't know what those Arab individuals and the individuals from Bangladesh, what their views are on the Israeli-Palestinian conflict. I don't know if they agree with the Attorney General's position about from the river to the sea being an anti-Semitic battle cry for the elimination of Jews. I don't know what their positions are, but the Attorney General felt that they're all together. Those Arabs and those Muslims in Hamtramck and these kids protesting for Palestinian rights in Ann Arbor, they're all the same. If I'm biased against some, I'm biased against all of them. That's the position they took. And it's not right to now just come here and ask to ignore it because one party found out about the argument they made in about another party. And so, Judge, I'd argue that the Attorney General's insistence on multiple times going out of her way to attack the speech of Congresswoman Tlaib that is identical, and we see it on video, to the speech that is being exercised by these individuals, that is the equivalent of what she did in Hamtramck by specifically protesting those council members and their views. Because these defendants' views are identical to the views expressed by Congresswoman Tlaib that the Attorney General called an anti-Semitic battle cry for the death of Jews. That shows the emotional connection that when she appears to be holding back tears, saying this hurts us, this is painful. It's a battle cry to kill our people. That is the emotional attachment. And then you combine it with the essential solicitation of a criminal case to send a letter to the University of Michigan and say, hey, I already took it upon myself to speak to your local prosecutor. And it would be great if you submitted these cases to my office and not his. And I'll tell you what the difference is. Because when he prosecuted these cases, the way in which he handled them was not sufficient for people emotionally invested in this case, in this type of issue, such as the Attorney General and the individuals on the Board of Regents of the University of Michigan. What did he do? He reduced felonies to misdemeanors immediately and entered into agreements for probation under HIDA for some. Others, he agreed to diversion, which resulted in a full dismissal. That didn't meet the standard that individuals like Ms. Nessel and others that wanted these students' speech criminalized, they weren't satisfied with that outcome. And so that's why the next time this issue came up, we bypassed Prosecutor Savitt and we go to the Attorney General's office. Judge, this court has been practicing long enough. Just common sense. We don't see the Attorney General's office in here on misdemeanor trespass, 30-day trespass misdemeanors. But some of these two defendants are facing that charge alone, charged by the Attorney General's office. Or even this low-level felony resisting obstructing arrest. That is not the type of case that we typically see the Attorney General's office in courts ever, let alone before any case is submitted, before any evidence is gathered. Sending a letter to the university saying, hey, I'm an expert at finding the right balance between free speech and criminal laws. I'm your office. Send them here. And was mention made of prosecutions in Wayne County. I actually represented some individuals prosecuted in Wayne County. The officers in Detroit, Wayne State University police officers wrote tickets. They actually issued misdemeanor citations. And so these individuals went to court. And then upon review by Prosecutor Worthy, she said, I looked at the video, I looked at the evidence. These kids were exercising free speech. I'm not pursuing these charges. And she instructed the assistant prosecutors to dismiss those cases. But those cases were filed by criminal complaints initially by the police officers, then the prosecutor's office refused to go forward. The Attorney General's office talks about the multi-jurisdictional allegations. This is the only jurisdiction right now of any criminal cases regarding Palestine speech in the state, as far as I'm aware. There are no other cases where the Attorney General's office has filed in multiple jurisdictions. There's no other jurisdictions with this stuff pending. And we look at other issues. Judge, this is not the first issue that people protest, and it won't be the last. But people have protested about the environment. They protested Black Lives Matter. I represent individuals that were prosecuted when Black Lives Matter protests took place. Those were all handled by the local prosecutors. I represent individuals in Lansing, others in Detroit. It never reached the level where the Attorney General's office said, hey, I will handle protester cases. Only on this issue. And it happens to be the issue where time and time again, she goes out of her way to criticize this speech and people's positions on this issue. For what? For demanding that people from the river to the sea will be free? What else should they be? So, Judge, with her filing the petition in Hamtramck, with her public statements, all of this, and the letter soliciting the prosecution, we don't look at any one of these things in a vacuum. Look at the totality of their circumstances. There is, if not a bias, an appearance of bias, which the Attorney General acknowledges in a filing made in another court of this state. And we can't just ignore it because now they wish they never wrote it. They acknowledge it. And it is part of the reason they asked for recusal in Hamtramck. And if it was enough for them to seek recusal in Hamtramck, it is enough to recuse them here. So we ask that you recuse the office of the Attorney General and appoint a special prosecutor based on either the actual bias or the appearance of bias that they acknowledge themselves.
Judge, I just wanted to respond to two quick things.
Yeah, well, and I have a
Do you have any
question.
questions? I didn't mean to walk away after my
Pardon? No, I'm good. But I have a question, and I'll certainly let you respond with whatever you're responding to. And it goes back to paragraph 5 and 6.
Okay.
If the recusal in Hamtramck was solely about the protests that the Attorney General had been involved in, and the criticism, why is there any mention of someone's ethnicity, nationality, their race, their religion? Why does it, if I take you for what you're saying, that that's the reason for the recusal, I don't have to say anybody's there. I don't have to say anybody's, I don't have to say any of that, because on the face of it, I was critical of these people, and so therefore I shouldn't hear the case.
Yeah.
That would have been it. But that's not what this says.
Right. It was included because it is the charge that has been made against Attorney General having Washington State in his report. She's been accused of Islamophobia. She's been accused of having bias against Muslims. She has had a bias against Arabic, of people of Arabic descent. And so that's why it's included. It is only because I wrongly, obviously I've already said it, wrongly believe that the folks in Hamtramck were of Arabic descent. They're not. They are Muslim, because that's what our investigation has said. And so that's why it was included. In terms of this SPA process, I keep hearing this phrase, it got filed in court. It got filed in court. The SPA petition does not get filed in court. Under the statute, when a prosecutor, the 49.10, when a prosecutor says, I have a conflict, they fill out this SPA form. It goes to the prosecuting attorney's coordinating counsel along with the police reports, where then it comes to me. I get to look at it and say, oh, prosecutor in Ontonagon County has a conflict on this case. Pack, send it someplace else. Send it to another prosecutor. Or I can say, you know what? That's a case that the AG's office is going to take. And the AG's office will take that case up. Of the, I think we're up to like 500 already this year because there's just an inordinate amount of SPAs. Our office has taken over 100 cases we've taken through the SPA process alone. But it never gets filed in court. It never gets filed with anyone other than my office and the prosecuting attorney's coordinating counsel as something to be able to send on to another prosecutor's office to say, hey, would you take a look at this? Because there also is no ability for me to be able to say, you know what, Muskegon County, you're taking this case, or Washtenaw County, you're taking this case. It is a process by which the prosecutors have to decide, you know what, I'm going to take that case for Washtenaw County or for the AG's office. That's how that process works. And so I just want the record to be very clear that this isn't something that gets filed in court. It gets drafted by the prosecutor or some of their staff, in this case by me, and sent to the PAC to say, hey, can you find something else with this?
I get that. But the statements in it are no less binding.
Sure, I agree.
Okay.
I agree. In terms of these cases that Prosecutor Worthy dismissed, that she viewed the video and she dismissed, I think we can all agree that every situation has to be viewed independently on itself. I've not seen those, but what I will say is that if we truly are vindictive and we have a personal emotional interest, because I love it when you say that I want to be emotional. If I had an emotional interest to go out, I could go to Wayne County and say, don't give me those cases, because I'm vindictive and I'm going to selectively now prosecute those cases that were dismissed by Prosecutor Worthy. That has not happened. That has not happened on any of these. The cases that we've looked at are the ones that have come directly to our office. We never bypassed any prosecutor. We never overruled any elected prosecutor's previous charging decisions here. So I just want that to be very.
So, okay, but that then begs the question, what was happening with these cases here at Washington? In your, what, there's these 4 cases that we know about that were charged.
In the fall, I think 2023.
Right.
Yep.
Then there are these 7. And I think there might have been some other. Anyway, so were these cases just sitting for somebody to come along and grab? I mean,
What was happening here to these cases?
I don't think anything was happening to them. I think they were still being investigated. I think they all happened, again, I think, don't quote me on the timing, but I think they all happened fairly quickly. An honors convocation, a graduation ceremony, event at the art museum. I think they all happened relatively close in time. They all get investigated. I send a letter to U of M to say, hey, I understand you have control over your police department. If you want help, you can send him to our office and we'll take a look at him. I've talked to the prosecutor, so I don't want to make him mad. I don't want him to think I'm coming in to just take his cases, because again, I've worked really hard over the last 6 years that I've been in this position, and previously I worked for PAM, which is a subgroup of the Prosecution Coordinating Council. I worked really hard to develop relationships with prosecutors, so we don't do that. That's what's happened as far as I know. Hey, you want our help? We're here to help. There isn't some backdoor, we want to be heavy-handed. We're looking at the cases, we view them, we decide whether or not the evidence fits the law, and then we make an appropriate charging decision as we see fit. We then send them to a magistrate, and an officer has to swear to the probable cause for it. If there wasn't probable cause, they never would have gotten issued in the first place. We're now here past exam, where this court has had an opportunity to hear all that testimony, has given defense counsel an opportunity to brief these First Amendment issues as far as I know. Again, I wasn't here for the exams, but an opportunity to brief these issues, have us respond to them, and then ultimately make a charging decision. If these were wholly without merit, I'm sure this court would have dismissed them after the exam. But we're not at that position.
Okay, I still am at a loss as to where these cases were. Now, and maybe after some 40 years or 26 years sitting on the bench, I'm just ignorant of the process. But it seems to me the police file their requests for charges with the prosecutor. So as I understand with these 7, that was done with our county prosecutor.
Sorry, I don't understand what you've done with it. Like, ask him, maybe do we?
Yeah, they send over and they're requesting charges. They send over the report and they want them requested. Certainly when I was a prosecutor way back, that's what would happen. The police department sends a report, you're looking at it, you make a decision as to whether or not it should be charged. So I'm gonna, well, and maybe I shouldn't make the assumption. Is that what happened here? And then there wasn't a decision by the local prosecutor?
There was not a decision by the local prosecutor, because I remember that there was a report that said these were all denied by the prosecutor, and then they were sent to our office. That's not true. I know for a fact that there was no charging decisions made by Ellie Savitt in his office. The phrase he used with me was he administratively closed them and had the law enforcement officer bring them to our office.
What is that? Yeah.
As far as whether a decision was made by Mr. Savitt or not, they preemptively wrote the letter on May 24th. They can give them to us. We want to prosecute these folks, and all they know about them at that point is that they were engaging in advocacy for Palestinian rights. That is all the Attorney General knew on May 24th when she wrote this letter saying, hey, forget it, like Savitt, send them here. And it begs the question, why did it not happen on any other issue?
Why? But hold on a second. When you're saying preemptively did it, what do you mean?
There's a letter, the letter that they submitted a few days ago, I think 2 days ago, they submitted this letter that they sent addressed to Mr. Lynch of the University of Michigan.
I recall that letter. Yeah.
Right. And so
I'm trying to figure out why you're using the word preemptive.
Because the conduct happened on May 21st. From the court knowing the amount of video and everything that we've all had to go through, Mr. Savitt would not have reached a decision by May 24th anyway. Right. And so
I see what you're saying.
This letter is sent saying, hey, Mr. Savitt, do you really want to go through all this video? Why would he? Fine, you want to take it off my hands? Have at it. And so it's not, and you know, Judge, if combined with the pattern of criticizing Palestinian Americans and those who advocate for Palestinian rights, to then, you know, on your own, send out this letter saying, hey, if you want to prosecute these guys that were talking about Palestine, you know, we're your office. Send them here. And what I would say is if these were Black Lives Matter protests, the Attorney General never got involved in prosecuting any of those, as far as I know, right? But if we had an Attorney General who had made racist statements and criticized people protesting for Black Lives Matter, and then within 2 days of a protest, sending letters saying, hey, if you want to prosecute any of these folks that were involved in Black Lives Matter, send them here. That shows the bias. And that's what took place here. She spent a year going on TV criticizing Palestinians and then says, can I give it to me?
I don't jump to the same conclusion that necessarily shows bias, because I'm more looking at process. So more so rather than what you're purporting to be general initial statements.
I'm more worried now that you pointed out to the court about this 3 days. Because that's a real short period of time to do anything. And it even highlights really what my difficulty was when this all started, when I was reading through everything over the past few days. Something happened that I can't see when I look at that letter. And it makes it even more curious for me that it's only a 3-day period. Something happens on the 21st. Most of the time, quite frankly, there are reports written up that are going to go over to the prosecutor unless it's something by that time. But okay, 3 days later, I'm presuming there was a phone call to Mr. Savick, which you've indicated.
Right.
And then this letter is written. What happens in those 2 days?
I don't think anything happened because defense is kind of focused on the day of the encampment because that's why we're here. But that's not the only thing that we looked at. We had the honors convocation, which
occurred before.
Again, like I'm not going to lay down and say that this is the date, but I understand that graduation is coming up, and I assume if they graduated from a college, they tend to happen around the same time every year.
Yeah.
So I would think honors convocation is probably end of April, beginning of May. Graduation is May. So there's the honors convocation event, there's the art museum event, there's the graduation event, and then there's a couple of events that occur during the encampment, I think, that are related to the destruction of the flags that actually get charged. We looked at all of those. We reviewed 37 warrant requests for these individuals and laid it on just the ones that we've already talked about. So I'm not sure that focusing on 3 days or 2 days or what have you is the appropriate time frame. If you look at all of it, all of that is happening in April and
Okay, so let's do this. Let's say it's a month. What happened during that month?
all of those things.
No, what I'm saying is, what happened to cause the letter to be generated? It can't just be the phone call. It can't. And maybe what Mr. Macklin was inviting this court to do, although at some point I got to get through this case, get a life back. But we may need to hear from Prosecutor Savick about what happened, because I'm not getting an answer about what occurred. I got the defense saying it's 3 days. You're saying it's not 3 days, but it's a relatively short period of time. But nobody can tell me whether it's 3 days or a month. What the heck happened? I don't know. Everybody's giving me their explanations of it, but I just don't know. And nobody seems to be able to answer for me what these cases were doing. That they were just sitting? Okay, that's been known to happen.
And there was no case. That's what we're saying. We're saying there was no case until the Attorney General said,
No. When I say a case, I mean the request for an authorization from the police department. So there's a request for authorization that's coming from the police department to the prosecutors.
Right.
That request for authorization, I don't know what day that happened on these cases. I don't know then, once that request came in, and I keep saying it over and over, but I don't think anybody knows, which is why I'm not getting an answer. I don't know what was happening with those requests for authorization. Were they just sitting on somebody's desk doing nothing? Or was somebody staring at them? Was somebody about to do something? Was somebody calling around saying, we're not touching these? Well, I don't know what anybody was doing. So,
I have an officer in charge who knows more about timing in terms of when warrant requests were presented. It's my understanding from having a quick conversation with him that there had been some of these events like the honors convocation and the graduation that had been prepared and sent over, and they just weren't doing anything. And then the encampment case never went to the prosecutor Savick. It just came to our office because at that point, as the letter says, there had been this conversation with prosecutor Savick where he's like, feel free to take them.
So, okay. So now I'm getting kind of confused. So these 7 never went to Prosecutor Savick's office?
That's from what they're saying, yes. And it makes sense because before they had a chance to get to Prosecutor Savick's office, they got this letter from the Attorney General saying, send them here instead. So it sounds like is they were never sent to Savick. They were sent directly to the Attorney General in response to her letter soliciting the cases, which is dated May 24th. The report has not been completed.
Can I? So why did, and maybe you don't know, I see the letter, but why did that happen?
because we understood that there were these cases and that there is definitely that connection between the First Amendment and between crimes. And we have that specialization and we have the ability to be able to do the review. So we offer, just like we do in hundreds of other cases.
Thank you so much, Polly Popcorn, for giving me a
You're not
membership.
too smart.
And went
But
to ladies'
isn't that
bar.
strange? I think because, no, hold it, because at some point, I have cases that are really gonna have these First Amendment things. Those cases get to the county prosecutor because they authorize. These don't, as now I'm to understand, I'm assuming, those never make it there.
These defendants, their cases were brought directly to our office.
Why? I mean, but that's what I'm asking. Well, yeah, you can send this letter, but if I'm a police agency, this is where I send my stuff. And then why? Whose decision was that to do that?
Decision to do what?
To send them to the Attorney General?
Ultimately, it's the police department. There, no matter what crime you're talking about, whether it is a murder case or a drunken disorder, the investigating agency decides where they take it.
Okay, so why did they change gears? Why do I send some to the prosecutor here in Washtenaw and then all of a sudden decide with these infamous 7, they go elsewhere?
They're not just these 7, Judge. So everything that had previously been sent and everything afterward then came to our office. So again, there were cases that had been submitted by the police department to Mr. Savage. He authorizes a couple of them in November, and then there's more that come probably at the end of April, beginning of May, and there's no review done. The letter is written, and then all of those cases are, quote, administratively closed by Mr. Savage because he says send them to the AG's office, and then all of them.
Okay, so hold it, folks. Again, apparently you're confusing me because I just heard, and maybe I heard it wrong, that these 7 cases never made it to the county prosecutor.
That's right.
So if that's the case, what is Mr. Savage administratively closing?
All of those other cases that had already gone to him, the honors convocation, the museum, the graduation, those ones all get closed, and all of them get transferred over to our office.
Judge, all of these cases are about May 21st. I don't know about honors convocations or anything else, but everybody here in front of you is from May 21st.
Oh, I recall.
Right? So we're throwing out other days, but.
So there's been this big argument about the, selective prosecution and how we've charged 85% of the cases. That's just simply not true.
Right, okay. I get some of that. I do. What I'm not getting. So everybody's in agreement. These cases never went to the Washington County prosecutor.
We accept that representation by the Attorney General.
All we can do is take their word for it. We have nothing to indicate otherwise.
Okay.
Right.
So then the question becomes, what caused the police department to not send cases where they would normally send cases?
The letter, the May 24th letter.
But I don't, do I know that?
Oh, I'm sure you do.
Well, no, I mean, but I haven't heard that. I mean, I don't know that. Do I know that the police agency saw that?
Judge, I think you could safely say that if Prosecutor Savitt wanted these cases, he would have told his agency to bring them to me. And if he didn't want them, as he sent them to us.
Well, no, I don't know that that's the case. I think that he would have to assume that the cases would have normally come to him. And then if they weren't coming to him, he would have said, whatever. But I don't. Mr. Reddick.
I don't know if it matters to your consideration, but it would probably be relatively easy to establish when the police reports were completed and when they were received by the Attorney General. My memory from the discovery is that the reports were some days after this, that may not have even been the same month. I don't recall when the reports were finished, but I believe it was well after this May 24th letter. That may not be dispositive here, but I think it does put a gloss on the connection made by the Attorney General between the Hamtramck cases and this case, as you noted in paragraphs 5 and 6.
Yeah, if everything here is about paragraph 6. Had they not included that, the judge would have no issues. He would have made an easy ruling. But now they included paragraph 6. And now all of a sudden, he's conflicted.
How fast can somebody retrieve those dates for me?
You have that here.
Of when the reports are finished and submitted? I mean, you say it might be in your discovery?
I think officer just looking for
Oh, right. Pardon?
The question, the date that the review was submitted to the AG's office?
Yeah, when the reports were finished, when they were submitted to the AG's office, and then I guess we would kind of know when the charging happened, but also if we have that date of the charging, I mean, those 3 dates seem to be critical. Let me also say, Madam Attorney General, the microphone there is hot, so to mute it when you're talking at the table, you'll have to hit it. It will turn green, and, okay.
Oh, okay.
Okay, so that, no, not a problem. All right, well, they figured that out, folks. I'm gonna take about a 10-minute break, because
I do have one.
my head's hurting, but you're not gonna let me do.
I'm sorry.
No, go ahead.
Well, listen.
Fine, no, it's okay. The comfort of the judge doesn't matter to anybody. Go for it.
You were asking about the dates. I found their voice at May 22nd, that's all.
May 22nd for,
It was written at 12:13 a.m. That's,
when the reports were written. Okay, then it's the other 2 dates that then become critical. All right. Folks, you're gonna have to give me 10 minutes. Court's gonna stay there. I got everybody?
Yes, sir.
All right, back on the record in the case of People versus Willow. All right, counsel is present. Were we able to figure out those dates?
Yes,
Okay, go.
I have this case was submitted to the AG's office on June 13th, and charges were announced on September 12th.
September 12th. All right. Does that comport with? So, all right.
We announced some September 12th date. We don't know about the June date.
I'm sorry. You don't know about the June date.
Well, now it's September 12th. But go ahead, Jeff.
I think for purposes of our discussion, the June 13th date is fine, even if it was an approximate date.
Okay. I have one question for the, well, 2 questions really for the defense. First one being, as I look at the dates of when things are occurring that you're relying upon, why is this raised now as opposed to some earlier point?
We only found out about the issue when it was, we only found out about the recusal of Attorney Dana Nestle's office in the Hamtramck case. As soon as we found that out, we immediately filed this motion. That was the catalyst of why we brought this forward. That hadn't been on our radar otherwise. And when the Free Press published this petition, was written by the Attorney General's office, at that point, we decided to file a motion to recuse and disqualify the Attorney General and ask for the appointment of a special prosecuting attorney. We only found out about that, Judge, within days of filing this motion.
I know, Judge, that the petition filed in the Hamtramck case was dated March 10.
but I just note that it was filed, it maybe didn't March 7th, but we didn't know about it until it hit the Free Press, like maybe 3 days before we filed this motion. I think I found it in the Free Press, emailed it to the rest, and he went from there by trying to research the law and everything. I think, we had an idea of everything else we talked about, these public statements of the Attorney General. But a lot of it, to bring the motion early on would have been more speculative. But once we had this petition combined with all of that, I think it gives us grounds to file a motion that we believe should be granted.
Hypothetically speaking, and I want to make it clear, the court hasn't made its decision. If I were to grant the motion in this case, what do the
how does the defense view the proceedings which have transpired thus far? Are we going to do another prelim?
You don't believe we're entitled to that? Mr. Mayor, I can speak to that.
Yes.
No, I don't. We discussed this during the recess. We don't think that there would be another preliminary examination. There would be a change in the prosecuting official. And we believe that the Attorney General has correctly identified that process, namely that they would go to the prosecuting attorneys coordinating council. And they, in conjunction with other local prosecutors' office, probably somebody peripheral to Washtenaw County, would select who was going to handle it.
And it doesn't work that way.
No? I thought that tried to eliminate drive time.
The purpose of the preliminary exam is for the magistrate or examining judicial officer to be always of the same person at all times.
Yeah, no, I'm not saying that this court wouldn't be the same court. I'm not saying that they get another preliminary exam. I'm saying that PAC does not have the ability to say, Jackson County, you are taking this case. That's not how it works.
Of course, they would have, the receiving county would have to agree to take it on.
Yeah, typically. So it would go there and the receiving county would be the one to say, yeah, we'll take this.
That's right.
We have 83 counties.
You're right.
Washtenaw would be out. So of those 80,
Why would Washtenaw be out?
I don't know. Okay, let's say Washtenaw still in. So yeah, I guess Washtenaw wouldn't be out because they haven't even seen, according to.
They looked at the evidence. Nobody has.
That's assuming that there's no other reasons in their own judgment why they would accept or decline.
I think you have to recognize, first of all, that this has not been an easy lift. There are hours and hours and hours of video. There has been lots of media around it, and there are probably many prosecutors who would say, thank you, but no thank you. So I don't expect that it would be an easy task to say, hey, take this one. Will it get placed? Yeah, eventually it'll get placed. Otherwise, we'd probably have to hire somebody to do it separately and independently.
And
I disagree with the right prosecutor.
well, I don't know that that's fair. Saying that. And I don't, you know, look, people can disagree on things, but I really don't think that that comment was necessary. I am, you know, when I look at this, if what you want me to do is attribute some bad faith to the state's attorney general, I don't see bad faith. I see that there may have been something that is difficult to explain, but I want to, you know, and I guess maybe given that comment, I want to make it real clear. People can have their views publicly about a lot of different issues. But I think, as the Attorney General here said today, I've had cases where the Assistant Attorney Generals, under the direction of General Nessel, have come down and tried cases before me. And if I were to look at those cases, and the defendants look all different kinds of ways, and to try to say that somehow or another that there is some actual prejudice or bias, I'm not going to buy it. And I'm just going to tell you, if that's your argument, as I would say to anybody that's going to say anything about anyone having some actual bias against somebody, and then particularly a government official because of that bias acting in a particular way, well, you better bring it, because I think that's a high burden. And I'll make it clear, I've not seen that in anything that has come before this court, in any case that has been handled under under General Nessel. I just not seen it. And I don't even see it necessarily in this case. What I see in this case is what may be a perception. And sometimes perceptions take on a life of their own. But it doesn't mean that that person, because of that there's some evil or mal intent in that person. So, you know, you can say all of that stuff, counsel, if you want, but those kinds of comments are going to fall on deaf ears with this court.
Did it mean, yes, it's withdrawn.
Thank you. Because yes, you did mean disrespect, and it's not going to happen in this court.
I was withdrawn.
All right. All right. Was there anything else anybody else wanted to say, which is like the judge's great fear to ask of a room full of 8 attorneys?
Respect for this time. Thank you for the court's opportunity to hear our arguments.
All right. Anything else? All right. There are a couple of things that I want to think about, and I think the court's thing was sort of leading to it. If the parties are in agreement as to the time frame and how these cases got there, then this court needs to think about what, if anything, that means. And I'm not going to be hasty about the decision. I think that the decision is a heavy one. Disqualifying the prosecuting official on that. And I want to the best of my ability, make the right call. The other issue, though, that I have is paragraph 5 and 6. And as succinctly as I can put it, if, as the Attorney General has indicated, the reason for the recusal in the Hamtramck case is because of public criticisms made of those council persons. And I'm not entirely clear that part of that can't be true. But then there would be if that's the reason, there's no necessity for paragraph 6. There is then no necessity for the mentioning of anybody's religion, race, ethnicity, anything along those lines. And I want to make sure to give everybody an ample opportunity to tell me. And so I certainly have heard the argument today. And my intent would be to reconvene on, I know, Ms. Askew, you said you were out for a period of time in May.
Yes.
But I have the 5th of May because I want to make this decision as soon as I can. Either way it falls. You're still, okay. So I will everybody else be May?
Sorry, but it is the Indigenous Peoples' Day, and I'll be in Grand Rapids in March recognizing MMIP work, and so I will not be here. If you need me specifically, then ask for a different day. If I can send a colleague, I can certainly do that.
Okay, why don't we try to do it this way? Because I really do want to get this, and I think she has told me I lose Ms. Askew most of May. So I'm just trying to work that out.
Are you thinking the afternoon on May 5th?
I think it's the morning. Morning. Is that a problem for you?
I have a matter in Bloomfield Hills.
No way.
No,
I'm kidding.
I'll reach out to the Attorney General. I don't think that's a problem.
Okay. Here's what I'll do, Madam Attorney General. I will allow, because part of the issue for me is going to be, and I've heard the argument, but paragraph 5 and 6 are causing the court great problems. So I certainly will allow anybody to submit to the court. I don't need it in response to each other. Anything by the 30th of this month for the court's consideration regarding that basic issue, if you feel the need to do it. I think the court has a great grasp on it, but I want to make sure anybody that wants to tell me something gets to tell me something. Okay. And then if you could send somebody else, I'd just like to get this done.
Yep.
So we will do that. Counsel, you know, one of the reasons I guess in a lot of ways I'm proud to be a lawyer is because sometimes when you get good arguments from counsel, it just gives you a great deal of gratitude for the profession that I've chosen to be my life. And you guys have done an extraordinary job of presenting the issues, answering the court's questions and the like. I wish I could bring a group of younger attorneys who seem to have a lot of problems with answering court's questions in to see how it really should be handled. So I thank you for that today. So we will adjourn.
Yeah, just look about 6 hours back into this stream. You will see some attorneys that have a hard time answering easy questions.
For the decision on this case to May 5th, 2025, 9 a.m. Thank you.
Thank you.
Court stands adjourned.
And there's a lot of Palestine scarves in the background there. Yeah, this will be interesting. Folks, I didn't know this was in it. I just recorded, put it all together in one big stream, and then cut it up to 10 separate videos. This I had no idea was in it. But now I'm happy I chose it because this was a higher level of lawyering than is usually seen in Judge Simpson's court. These are the top lawyers in the state of Michigan. You have the First Amendment attorneys who represented these students, and then you have the Attorney General's office. That it's been really, really good to listen to. Really, really good to listen to. Whew. I'm really interested in this case now. But I have, as you know, I'm starting a new trial on Monday. It's Michigan versus Sure. White cop shoots black suspect in the head, claims self-defense. And so that trial starts Monday. Me and Dave are going to cover that from gavel to gavel. We are co-streaming it. I will take morning, he will take afternoon, or something of the sort. If we both can be on the entire day, we will. But usually we will do morning and afternoon. Whew, this was heavy. Now we have about an hour and a half to go on the rest of on the rest of this stream. And we've been at it for 8.5 hours.
The 14th District Court, County of Washington, State of Michigan is now in session. All those having business before the court draw near. The Honorable Judge Simpson presiding.
And good morning. Richard DeHart and Cynthia DeHart, or DeHart versus Bonnie DeHart.
Good morning, Your Honor. Frank Gronert appearing for the plaintiffs, Richard DeHart, Cynthia DeHart. My P number is 34198. Mr. DeHart is present with me to my right, and Cynthia DeHart is present by Zoom.
Okay. And Bonnie DeHart, I do see you on the screen. If you could unmute. All right. This is a termination case. What is plaintiff's claim in this case?
Your Honor, this is a month-to-month rental agreement. A 30-day written notice was served on Bonnie DeHart on January 29th of this year, and her last day would have been February 28th, 2025. She has not moved, and we would move for immediate possession. There's also a supplemental complaint for unpaid rent for the months of March and April. Each month, $1,000, so the total is $2,000.
Mr. Hart, Bonnie DeHart, I guess I got to clarify. What's your position on this, ma'am?
Unfortunately, I've had 2 car accidents this year, and that has affected my ability to pay rent. I also have no credit and no money saved to move. I simply don't have the money to move. I'm working 3 different jobs, Your Honor, and trying my hardest.
I didn't hear that last part, ma'am.
I said I'm working 3 different jobs, Your Honor. I'm trying my hardest to make the money.
Well,
I don't have anywhere to go.
Are you gonna seek the assistance of counsel in this case?
I guess not. I can't afford a lawyer.
There's free legal services available. What is, Mr. Groner, what's the relationship of the parties?
So, Mr. and Mrs. DeHart, the plaintiffs, are current ex-in-laws of Bonnie DeHart. Bonnie was married to Mr. and Mrs. DeHart's son.
Okay. It was early in the morning. It was hard for me to follow that way you said it the first time. I got it though.
I know.
Okay.
Yes.
All right. Okay. So, ma'am, what I'm gonna do is I'm gonna adjourn it out. Well, I don't have, what's my next day?
16.
Okay. Counsel, I don't think I can issue I have to give her an opportunity to at least defend or move. Ma'am, you can contact legal services and see if there's any other type of remedy. What I may
also suggest to you is that you contact Mr. Gronert, see if you can work something out. My problem is normally, Mr. Gronert, I'd adjourn it out a week. I do not have the next 2 weeks. I don't have second hearings the next 2 weeks because of, there's a bench bar.
Yeah, the judicial conference.
Bench bar and a statewide judicial conference. So my next date, regrettably, is May 16th. Is the best that I'm going to be able to do on this for adjournment.
Very good. What time, Your Honor?
All right, I'll adjourn this matter May 16th, 2025 at 3 p.m. That is an in-person appearance.
Thank you, Your Honor.
All right, thank you. Let's call the case. Moorville Road, 10489 LLC versus David Hisham.
Good morning, Judge Simpson. My name is Scott Munzel of counsel with Deaver EB ISA, and I represent Moorville Road, 10489 LLC. With me on Zoom is also Joe Maynard. He's one of 2 members of the LLC. And this is our complaint for forfeiture of a land contract for property located at 1059 Overlook Drive in Saline Township against David Picken, who is the land contract purchaser.
Mr. Picken?
Yes, sir.
What's your position on this, sir?
I've taken care of all of the things that they requested. I've talked with Joe, and I believe everything has been worked out.
With all due respect, Your Honor, I do not think that's the case. My understanding is Mr. Maynard went out to the site last night. The makeshift building that Mr. Picken constructed without building permits is still there as of last night. The problem the township had was, number one, it was constructed without a building permit, and there's also no sanitary sewage disposal facilities, and it appears Mr. Picken is living there without, appropriate potable water and sanitary sewer.
First of all, living in a building with no nothing, bad. Other thing, that guy up there on the top right of your screen is that a cousin to Kurt of On Civil Law? Yeah.
The township has cited him for the violations. I attached a letter to my complaint, and as far as I know, as of this morning, the issues have not at all been resolved. And the essence of the problem, Judge, is that the LLC owns 5 other parcels that adjoin Mr. Picken's parcel, and that his activities out there are prohibiting the sale of the other parcels. And so it's not. It's more than just what he's doing on his own parcel. It's what he's doing is affecting the adjoining parcels as well. And that's we tried to work with Mr. Picken earlier. There have been numerous communications. He had earlier hired a different attorney that I had worked with, but we've been unable to resolve them. And we were forced to file this land contract forfeiture action. So we would still nevertheless request that that it be decided today that the land contract is forfeited. So that we could try to, address the problems quickly. And for that matter, Judge, just kind of a technical point, Mr. Picken has paid $50,000 of the $175,000 purchase price. So he normally would have a 90-day redemption period under MCL 600.5744, but 600.5744(3)E does allow for a shorter redemption period when there's a serious and continuing health hazard. And, Joe Maynard went out there yesterday. He could smell the raw sewage. And so our position is that there is, in fact, a serious and continuing health hazard. And we'd ask the judge to set a shorter redemption period so that if Mr. Picken doesn't solve the problem himself, that the land contract would be forfeited, the writ of possession would be issued, and then, Joe can go and clean the site up himself. So I would ask the judge that the redemption period be no more than 30 days. We'd like it to be shorter, but we want to be reasonable. And then just to follow up on that, the land contract does allow for the award of attorney's fees if they have to enforce it. To date, they've incurred $2,620 in attorney's fees, $130 for the filing fee, and $150 for the service fee, for a total of $2,900. So we would ask also that the judge award that today.
Has the, Mr. Renzel, hold on, sir. Has the township actually cited the owners?
The township, according to the January 28th letter that I attached, they told him that he is in violation of the Saline Township zoning ordinance. And,
Yes, sir.
I did talk to Fred Lucas, the attorney for the township, and, their position is that he is in violation. They have not gotten around to further enforcement action. They kind of were hoping that this would get resolved by the parties, but that has not happened. So, yeah.
All right, Mr. Pashon?
Yes.
You just indicated to me that you were, I guess I assume we're in contact with the owners, and you believe that everything's resolved?
No, Your Honor. I have done some things. I have moved out of the trailer, and I'm going to contact the owner to remove it. And as far as the building goes, I will have that torn down and everything removed. I was getting ready to have the well drilled. So anything else that they would like me to do, I would be more than willing to do to keep the property. I was not notified by the township, though.
Okay. But you're going to take down that structure?
Yes, sir. It was.
When are you going to do that?
I can start on it right away. I have a worker, and between him and I, we will take it down.
Judge, not to, interrupt, but I appreciate Mr. Pickens' willingness to take it down. The important question is, when is he going to finish? When is he going to perform and have the trailer and the makeshift building removed?
The trailer immediately. Just thinking I get my things on, I have to go and get another storage unit at Sauk Trail, and I would need probably 2 weeks to get the structure down.
All right. I'm going to give you an opportunity so that if necessary, you can seek the advice of counsel. But I am going to order that you get that building, that non-compliant building off or torn down, as well as the trailer turned down. I will adjourn this to May 16th, my next available date, 2025 at 3 p.m. That's an in-person hearing.
Okay.
So you'll have to be here, but I want that building and that trailer out. And then you can see exactly where we are with reference to the property.
Sure.
Right.
Okay. Thank you, Judge. I appreciate it.
Thank you, folks. Everybody have a good weekend.
You too, Your Honor. Thank you.
House case of Town Center Place versus Viola Hines.
Good morning, Your Honor.
Good morning.
Jackie Snyder-Potter on behalf of plaintiff.
Ms. Hines.
Yes.
Hello.
Hello. Can you hear me?
Pardon?
Oh, I didn't know if you could hear me or not.
Yeah, we can hear you. We can see you.
Okay.
Okay. What is plaintiff's claim in this case?
This is a non-payment, Your Honor. The past due rent is 1,000. Sorry?
No, I don't know who that was. That's somebody else. Go ahead, counsel.
Okay. The past due amount is $1,008. Court cost of $177.40 for a total of $1,185.40.
Okay. Ms. Hines, how are you going to get that paid?
I applied for SER with the Department of Human Services, and I also have an appointment on the 28th with Hawk.
On the 28th of this month?
Yes.
Okay. Okay, and they should, the figure, they should be able to help you, I think, if your circumstances haven't changed. Okay, what I'm going to do, and I think you heard, counsel, I don't have a date until the 16th.
I did.
As a thing,
Yeah.
so
Yeah.
May 16th, 2025, I'll adjourn it up to that date at 3 p.m. That's an in-person hearing, okay, Ms. Hines?
Okay, I'll be there.
All right, now if Hawk's going to pay, tell them to try to get in touch with the landlord so we can try to see if we can get this thing resolved, okay?
Okay, thank you.
All right, Ms. Hines, you're looking well. It's good to see you.
Thank you. Good to see you too.
All right, take care.
Uh-huh.
Have a good one, Your Honor.
Yes, take care, counsel. Beal Properties versus Kendrick Osborne.
Good morning, Your Honor. Brent Tinger for the plaintiff.
Ennis Osborne, not here. You paid for second service. If you raise your right hand, you may take a default. Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God?
I do.
All right, go ahead.
Thank you, Judge. I am showing the rent to retain in this at $6,290.97. Cost of $175 for a redemptive total of $6,465.97. This to be a default judgment of possession only with a writ in 10 days.
Judgment is mine. If that's by default for possession, redemption amount, any amount requested. Writ issue 10 days.
Thank you,
Alrighty,
Judge.
Thank you.
Wow,
Alrighty.
six grand.
Set for that. So we'll stand in recess.
Pay your rent,
This court is
folks.
now back in session. The Honorable Judge Judge Simpson presiding.
And good morning. Court does call the case of Chittister Place Apartments versus James Waters.
Thank you. Good morning, Your Honor. Paul Hughes, P31986, appearing on behalf of the plaintiff.
James Waters? You have it. He is not checked in. If you'd like to take a default, raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God?
I do. Thank you, Your Honor. Plaintiff requests a default judgment for possession only. The amount of rent due is $188 for the landlord's ledger, $175 in court costs, for a total of $363. We would ask that a judgment be entered requiring.
Just hiring that attorney must cost much more than the fees they are asking.
The payment by I believe the redemption date would be the 5th of May for a writ to issue.
Judgment to the plaintiff. That's by default for possession, redemption amount, any amount requested with the writ issue in 10 days.
Thank you.
Chittister Place, I think that's it for you, but Chittister Place versus Sackett Ferguson and Chittister Place versus Blair Corser. Those matters are dismissed on plaintiff's motion without.
Thank you. I will see you at 1.
All right, sir. Evergreen Apartments versus Nancy Matthews and Nubia Robinson.
Good morning, Your Honor. Jillian Engen for plaintiff.
Ms. Robinson here? There she is. Hello. Okay, and what is plaintiff's claim?
I have a balance including court costs of $2,007.
May be seated.
Yeah.
Court calls the case.
Yeah, sadly, that was one of the recordings that were deleted on Judge Simpson's channel. So that was all I could get from that one. But now we get the rest of it at least.
Glencoe Hills versus Angela Stoker.
Mary appearing for plaintiff. Good afternoon, Your Honor.
Good afternoon. Angela Stoker. Not here. Would you like to take a default?
Yes, Your Honor. So this is the case where the balance was $50 in late fees.
The balance was $50.
Correct. Your Honor, I don't have authority to waive the late fee. She's not here.
Okay.
I requested.
Raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, help you God?
I do.
All right, go ahead.
Your Honor.
So just to have that attorney show up in court for this hearing is about $500, give or take. And it's default for $50. Yeah. Don't do that too often, Mr. Landlord.
The rent to retain possession is $50, and that is the total judgment amount. Plaintiff is requesting entry of a default judgment for possession with a writ to issue after 10 days. If the total amount remains unpaid, I'm assuming no writ without a hearing.
That is correct. No writ without a hearing. Judgment to the plaintiff, that's by default for possession.
And we will set it aside if she pays.
Understood. All right. Glencoe Hills versus Susan Smith.
Mary for plaintiff.
Oh, she's in jail. Ms. Smith, I need you to unmute. Is she actually on a phone? That's an odd looking phone.
Yeah,
She is. Okay, Ms. Smith, can you hear me?
Yes, Your Honor.
All right. How much is owing on this?
This
Is a termination. Smith?
Yeah.
Okay, what's your position on this termination?
I am in the process of packing my belongings and moving out.
You're moving out?
Yes, sir.
Okay, when are you going to be out?
I should be out by Monday.
Oh, by this Monday?
Yes, sir.
Okay, so here's what I'm gonna do. If you're moving out, I'm gonna find no tribal issue after a hearing. I'm gonna grant them a judgment for possession. And they can't forcibly remove you out until, what's the date? The 5th. No writ before May 5th, all right?
Okay. Yeah, thank you.
All right, you're welcome. Take care.
Thank you. Have a nice day.
You too. Gulfside Lakes versus Patrice Hayward.
Where's the Gazari for plaintiff?
Thought that was you over there. I couldn't see because of the glass. You just sitting over there in the corner trying to hide. How are you? State your name.
Patrice Haywood.
Come all the way up to the podium. All right, where are we on this case, Ms. Higgins?
Your Honor, I believe that, maybe 30 minutes ago, I got an email from Legal Services indicating that payment had been mailed. Is that right, Ms. Haywood?
Yes, it said it should arrive by May 2nd, is what she said.
For the balance, plaintiff's concern is April rent, but how?
Or April or May, you mean?
I'm sorry, May rent.
Okay, and how much is your monthly rent now?
$1,549.
Okay, how are you gonna get?
Jesus Christ, your
How are you gonna get
rents
that
are
paid?
ridiculous. Of course. For you who don't know, I have a farm. 46 acres, 46 American acres. The house is, let's see, about 650 square feet, 700, something like that. My mortgage is roughly 1,200. Why are you all paying 1,600 in rent for a 2-bedroom? I don't get it.
Yes, well, my check doesn't come until the 5th, so.
Of May. So let me ask you this. If they send out the check that's gonna clear you through April and you get a check on the 5th, are you gonna be able to have May paid on the 5th?
I hope so, yes. Hopefully it will cover everything.
Hopefully it'll cover everything. Okay, so let me ask you this. If it doesn't cover everything, then what's your plan? You have to
Second,
wait till the next check.
the 9th,
The
yes.
9th? So you get a check on the 5th and the 9th?
Yes, it's partial on the 5th and the full one will come on the 9th.
Gotcha. Okay. So here's what I'm gonna do. Then that one check's on the way that should clear you through April. You got a plan to cover yourself in May. I'm not available the first 2 Fridays because of judicial conferences and events. So I'm going to adjourn this to May 16th, 2025 at 1 p.m. Okay. And so hopefully if it all works out, you'll have it paid, right?
That's right.
And then you won't have to come see me.
Oh.
You gonna miss me? You say when you take care. Hamilton Crossing 2 versus Tiffany Roots.
Where's the Gazari for plaintiff?
Tiffany Roots? No response. You've been sworn. If you'd like to take a default, you may.
Was I sworn?
Yes, for the $50.
Oh, yeah.
Remember? Okay. How could we forget? No.
Yeah. I'm just going to show you guys what's available in Lund, the nearest town from me. It's a university town. It is considered high priced. Let me show you here. All right. This is an apartment. 2 floors, I believe, or 1 floor, in a nice neighborhood. Really nice neighborhood. Really nice neighborhood. And, oh, sorry. Bedroom, living room, kitchen, balcony, hall, bathroom. I mean, and For this, let's see, times 3, 250 square feet apartment, you pay $1,000. And it is located, in the outskirts, in the suburbs. $1,000 a month. And I do believe, let's see here, I have to check. Dun, dun, dun. Heating included, but not normal electricity. You're saying, and that is a high rent. Or maybe it's not 200. No, 75 square meters. Hold on. No, 800. Sorry, 810 square feet. Sorry, I miscounted. I don't do math. So 810 square feet apartment in the suburbs of Lund, one of the lowest crime areas in Sweden. Yeah, with heat included, but not, the other electricity bills. Sorry. Yeah. I said 250. I don't do math. It's 800 square feet apartment.
Pardon? No. Okay. Go ahead.
Your Honor, the rent to retain possession is $760, court cost of $176 for a total redemption of $936. Plaintiff is requesting entry of a default possession with the after 10 days, the total amount remains unpaid.
Judgment to the plaintiff, that's by default for possession, redemption amount, any amount requested with the writ issue 10 days.
Thank you.
Oh, what's your name, ma'am? Angela. Oh, come on now. Let me recall that. Thank you. State your name for the record.
Angela Stoker.
All right, I didn't hear you call your last name. You just did. So we did call your case. You took a judgment
Okay.
for a whole $50.
Which is the late fee.
Yeah. Do you have it? Or
I will
when will you have it?
for May. So I'm just added on to my rent. I'm just pay it with that. I didn't want to pay it, but I'm going to.
Okay, but when are you going to pay your May rent?
What, the 30th?
I didn't want to pay it. Yeah, you're going to have to.
29. It'll be paid April. It's in a couple days.
Stoker, you're confusing me. All right, so
I'm going to pay it in a couple days.
you're going to pay it like right around May 1st.
Yeah.
Probably the last part of
So
May.
when I get my statement for my May rent, I'm just going to add. And
You're going to add the 50 onto it. Okay, so you were going to move to set it aside if she paid it, correct? Okay, so here's what I'll do, Mr. Stoker. We'll leave the judgment that we entered in place. You'll get that paid, and then they're going to set aside this
I
judgment.
don't have to come back.
You don't want to come back?
No, I've been here 4 times.
Come back and just say hi to me. She said, I don't want to come back. just say all that hurt.
I'll see you on YouTube.
No. We'll leave that, and then you don't have to come back.
Okay.
All right, you have a great weekend.
Thank you.
You're on Vista Apartments versus Angie Evans.
Horrific theory for plaintiff.
Angie Evans, no response. You may proceed.
Your Honor, okay, I think this was a case we were trying to do a COD with, so
Yeah.
if she later does sign a COD, we will set aside this judgment.
All right.
However, the rent to retain possession is $3,304, court cost of $176 for a total redemption of $3,480. Plaintiff is requesting entry of a default judgment for possession with a writ to issue after 10 days if the total amount is not paid.
Judgment to the plaintiff by default for possession, redemption amount, and the amount requested with the writ issue in 10 days. For a cause case of here on Vista versus
Deanna Rogers. Hello, what's your name?
Deanna Rogers.
All right. And where are we with Miss Rogers?
The outstanding balance is $4,810. My recollection from the last hearing was that, Ms. Rogers was going to seek the legal services, regarding, to make sure that she understood what was being offered to her regarding the forgiveness plan and talk assistance. I can tell you that the update I received from my client was that she has applied for, assistance, but they are waiting for income verification before, SOS will approve it.
That's totally wrong.
Okay.
I just talked to somebody, a day ago, whatever, to ask if I could, move out in 30 days. Cause I can't, I told them, I explained my situation that I can't afford it and, I'm mentally disabled and I haven't been working.
Okay. So let me ask you this. You need to move? Is that what you're saying?
Yeah.
Okay. So where are you gonna go?
It's a hotel.
Huh?
A hotel. Probably to a hotel.
Pardon?
Probably to a hotel.
Okay, but if you're not working, how are you gonna afford that?
I get SSI.
Okay. And how much is her monthly rent here? Is what, 1859? Okay. And yeah, that's what I had here. I think way back 1839 or 1837 something. And if you don't mind me, how much is your SSI?
13.
Pardon?
13 something.
13 something?
1350.
So your SSI doesn't even cover your rent.
Right.
Yeah. Okay. Okay, so how much time do you need to move?
I'm asking for at least 30 days.
Okay, do you have anything that you can pay in the interim or?
Right now.
Well, when's your next check come in?
It comes in this coming week. But I gotta go towards me being able to move.
Have you?
Because I explored options for assistance and stuff and haven't been able to get it. No assistance.
Okay, when you say you can't get assistance, what do you mean?
To help to pay.
To pay this?
Yeah. I'm gonna have to go on a payment plan or something.
Okay.
I just want to see if I can.
Yeah.
So I think that the update that we had from Caitlin Ordo from SOS was that they were waiting for proof of income for you to approve the 3,000. And then the balance on this after payment of the 3,000 would be 1,810. And the forgiveness plan did require monthly payments going forward timely, but then they would waive the rest of the balance on this if the 3,000 was paid.
They have not told me that.
Okay, but
I was not told that at all.
Huh?
I was not told that at all.
Okay, but
I still
hear that now.
Wouldn't even be able to afford it.
Right. The problem's
I'd still be behind.
Okay, hold on. The problem, that would be a good possible solution for you, but your SSI doesn't even cover your rent here.
Right.
So the one check that you get, you can't even make the timely payments. All right. So,
Sherazad?
ma'am, if I can,
Over here.
let me ask you this. At some point, you were paying your rent on time, right? Everything? Or?
No, I was waiting on, SOS was supposed to pay something. I was waiting on them to pay their portion to see what my portion was. So no, I haven't paid anything.
All right. So did you have a voucher?
No.
Were you in some other type of program with SOS?
A homeless program, yeah.
Okay. And was somebody supposed to be helping you with this rent now?
They don't pay the rent. They just pay
like the moving in and stuff.
The move-in costs. Right.
Okay, but
I had got mentally just sick, and I wasn't able to work anymore.
Okay. Was it legal services gonna be here? Oh, great. Okay, so they won't be here, or the plaintiff, your landlord attorney won't be here. But let me ask you this, can you come back at 3 o'clock today? Here's why I'm asking, okay? I would prefer, before we do anything, have you talked to anybody from legal services?
Yeah.
When did you do that?
2 days ago.
Okay, so what did they tell you?
Well, thank you so much, Sherazad. Egyptian pound. Thank you so much. Thank you so much. That is so nice. It's $3. Yeah, I can see on the color of it, but it looks good. 150 Egyptian pound. Oh, thank you so much. That is so generous. That's so generous. Thank you so much. Oh, first Egyptian pound I believe I've ever gotten. Yeah. Thank you so much. Well.
That's basically the same thing that, saying that I can't afford it and stuff.
Okay. I'm just worried about what you're gonna do. Okay. So let me ask you this, can you come back at 3? For me, so that you can talk? I want to talk to the folks at legal services to know that the circumstances that you're in, and whether or not there's anything out there that might help you.
I took the bus here.
Oh, you did? Okay. That's the earliest that they'll be here.
Yeah.
Who's on that?
So you don't
even have.
I don't even have them.
You don't have them.
Yeah.
I got a copy of what they said.
Okay.
Of what legal aid
Okay.
on my phone.
Okay, but hold on a moment. Let's do this. When do you think you're going to be, if you move out, when do you think you're going to be out? By the end of May? Is that what you're looking at?
Yeah. Okay. No, not the end of May. This is April. I'm talking about 30 days from now.
And today's the 25th of April. So you'd be out, you think, by the 25th of May?
Yeah.
Okay. Ms. Rogers, who are you with CMH at all, or?
Yeah.
You are?
Yeah.
Okay, who's your worker? Do you know?
I don't have a specified one, but who I've been working with is Sharon Stets.
Okay. Does she know the situation?
I just talked to her today. Yeah.
Okay, so you just talked to your CMH worker today.
Yeah.
If you don't mind me asking, what'd she kind of tell you to do?
Oh, she didn't say no. She just said sorry to hear that.
Okay, did you ask her for any help at all or anything?
No.
All right. All right, Mr. Rogers, here's what I'm doing. Maybe certainly over the objection plaintiff, because they'd certainly be entitled to a judgment today, but I'm not comfortable doing that. I'm going to adjourn your case out to May 16th, my next day at 1 p.m. I need you to come back at that point, and then we're going to figure out sort of where this is going to go. So if you're planning on moving out and you start moving yourself out, you still got, I want to see you before that finally happens. Okay.
Mm-hmm.
All right.
May 16th.
May 16th at 1 p.m. Okay. You need that written down for you?
Yeah.
Okay. Let me We'll write that down for you and give you a piece of paper on that. Okay.
I mean, the compassion of Judge Simpson when people deserve it is phenomenal. Absolutely phenomenal. He might not be able to do much except try to get things rolling.
Okay.
Okay.
All right, Ms. Rogers, you have a good weekend. New Park Ridge versus Treasurer Wallace Douglas.
Afternoon,
Good afternoon. Name?
Treasurer Wallace Douglas.
Where'd you get that name from, Treasurer?
My mom's a girl. She was trying for 13 years. I was born on Valentine's Day.
And she named you Treasurer.
Mm-hmm.
I'm glad I asked. All right. What's her balance?
Your balance is $1,665.
$1,665?
67.
57.
65. You may, maybe I could.
1,600.
67.
67. Okay. Thank you. All right. How are we going to get this paid?
Where did this balance occur from? Because when I was here last week, it was 800 and something odd dollars.
No, on the 18th, the balance they gave me was $1,489. You had indicated you were going to pay $811 on the 21st.
Correct. I have
pay that.
They have a 1030. I gave them 1030 on Monday. $1,030.
Okay. So you gave him $1,030 this past Monday?
Correct.
You see that on your?
No, I do not.
That's okay. That's probably why.
It looks like the difference from the amount that you had last time was that we didn't have the court costs added in.
Oh, okay. So this is inclusive of court costs. Gotcha. Okay. So if she paid, so she's at 1667 and she paid 1030. And my math says I need 637. So when do you think you get that? Okay.
I need to try to work out a payment plan. I mean, I can pay probably a good 400. Well, I get paid next week.
So you can pay 400, do you think, when?
So
next
your
week
math is me and my date. Okay.
You get paid on Friday?
I get paid on Wednesdays.
So the next Wednesday, this upcoming Wednesday is the 30th.
Okay. Yeah.
You think you can pay 400 by then?
400. Let's say Friday, just to.
Okay, the second.
Yeah.
Okay, that's fine. Except that, how much is your monthly rent?
644. But also, sorry.
No, go ahead.
I was also wondering, is there any way to get the court costs and fees removed?
Well, not on this case, but what I'm trying to do is I'm trying to figure out a way to do this so that you don't end up with another set of court costs coming out.
Mm-hmm.
That's how I'm viewing it.
Right.
These court costs will probably have to stay. But so if you get, so you can do that by the 2nd. Then when's your next check after the 2nd? Is it going to be 2 weeks out?
It will be, but so right now my dad just had a horrible accident after I left here on Friday, and he really doesn't have anybody. He has Medicare insurance, so they're taking him out to the hospital. Basically, he needs somebody to take care of him, to help him. He has broken ribs, shattered pelvis, neither here nor there. But I will go back to work, but it's going to be my time is going to be split between the two. So I won't be getting all the hours that I need to get. I will be also getting paid to take care of him, but that's not going to kick in for a month and a half, maybe. So,
okay,
yeah.
so you got a lot of stuff.
Lot, but I'm definitely.
Okay, hold on. Let's see what we can do.
I have one thing to say. I think that this additional 176 is maybe an error.
So that the 1489 that I had before was the right amount, including court costs?
It would be 1491 now because of the $2.
Because of so 1491 now. Gotcha.
So if you pay the 400.
So if she paid, so then we're at 461 that she would. Okay, let me ask you this.
I can scrape up $61.
Okay, so you can do that, you think, by the 2nd?
Yeah.
Okay, so here's what I'm going to do. Just so that we can cut this off and let you focus on what you need to focus on with your dad.
So I'm gonna find no tribal issue after a hearing. I'm gonna enter the judgment for that full amount of the 1491, but understanding you have 1,030 that they haven't credited yet to your account. And then you'll have to the 5th to get that balance paid. And you're done with this case. And then you can work toward trying to get your May and everything gone. Sound okay?
It is. I appreciate it.
You take care, all right? All right, and take care of your dad. All right.
I see a bunch of questions over at Rumble regarding my farm, and I saw some questions here on YouTube as well. So here it is. So this area plus another area belongs to the farm. And here's the barn, here's the house. This is where we have spare parts. And yeah, I must say I'm enjoying myself really well here. And I do have shorts and videos when I walk about the farm for members. So that's, yeah. Yeah. So I like it here. I really do. I really do. I don't think they have. I don't think that, no, there's no street view here. No, no street view out where I am. All right. Back to Judge Simpson.
Evergreen Apartments versus Kendrick Haynes, and here on Vista versus Chanelli Brown. Those matters are dismissed on plaintiff's motion without.
Thank you, Your Honor. So this should be an amended judgment then.
On treasurer?
Yeah.
Hold on. Yes, that's an amended judgment. That's an amended judgment for her. So that way it clears her account up and she'll be good. You're good. I just didn't want to talk about your case without you here.
Thank you. And Your Honor, I do just want to state on the record though, if for some reason
It didn't go in, then yeah, no, I get it. But she'll get it paid.
Okay.
I think. All right. Okay, quarter standing recess. We'll come back with the next block that already started to run. All right. Mylan Village versus Renee Bell.
Good afternoon, Your Honor. Max Moon on behalf of plaintiff.
Hello, your name?
Renee Bell.
Okay. And where are we on this case?
Your Honor, at this time, my client indicates that there's a balance owing with court costs included in the amount of $1,201. I believe that we adjourn this matter to give Ms. Bell a bit of time to look into funding assistance. And I believe Ms. Bell was also instructed to make a $500 payment to management. As of right now, I do not have an indication that she has done so, and I'd be interested to know if she has, and I don't have that update on the ledger where we stand on that.
Did you pay the 500?
I was not able to. I have 250. The reason I couldn't pay 500, someone stole money from my purse, and I didn't realize it.
The total amount is 1,201, including cost, counsel?
That is correct, Your Honor.
All right. Well, I'm going to find that there's no tribal issue after hearing in this matter. I'm going to issue a judgment for possession in the total amount of the $1,201 with a writ to issue on or after May 5th. So you're going to have to get this paid now.
Okay.
All right.
All right.
Thank you.
Okay.
Thank you, Your Honor.
Thank you, sir. Six Trails versus Jillian Fox.
Good afternoon, Your Honor. City Kiss on behalf of
Uh-oh. What did Jukas do? Yeah. Your name?
Jillian Fox.
All right. And where are we on this case?
Your Honor, this is a non-payment rent possession case. There's currently a balance due with including court costs totaling $2,752.2752.
I was told by SOS that they would be able to help with this funding. I did submit all of the required papers for her. I have also contacted her 3 times this week. I have not heard back. I'm gonna.
So you had an appointment with Hawk?
Yes, I had an appointment before the last hearing that we had. I submitted everything that she requested, and I have not heard back from her. So I am still under the assumption that they are able to help. That's what she did say. Once those.
Did she say they were going to pay that full amount then?
Yes.
Okay. Here's what I'm going to do, and you can
put this in any writing. I'm gonna find that there's no tribal issue after hearing. I'm gonna issue the judgment in that amount of $27.52. However, rather than have the writ issue on the 5th, I will have the writ issue on the 12th.
And Your Honor, Amy's here. Is she able to just look that information so we have something by deal?
Oh, she's on the line. Yeah. I haven't seen her all day. She's been so quiet. Hello, Amy.
Good afternoon, Your Honor. I just wanted to offer that the caseworker is actually waiting on landlord documents. So if Mr. Katz can encourage his client, I've also let the court know to reach out to you directly, attorney, if that's okay, to seek those documents as well.
Well, I'll let my client know to respond to them.
Thank you.
Then
And that seems to be the only hold up here.
Okay, perfect. Your Honor, I'll put down the 12th on that. And
very good. All right.
Thank you. Have a good weekend.
Time on the 12th.
You don't come back on the 12th.
Oh, I don't? Okay.
So what I gave is additional time so that they can get everything together.
Okay.
And then hopefully get it paid by that day.
Thank you, Your Honor.
All right, thanks. Have a great weekend.
You as well.
Thank you.
Thank you, Mr. And Willow Ridge Apartments versus Abdullah. Yes, Mr. Katz?
Yeah, I forgot. That one's mine too. I sent it in dismissal.
Yes, you did.
Good thing I was
And
late
your
in
name,
this
sir?
time.
My name is Burhanu Abdullah.
Abdullah.
Yes.
They're dismissing this case. You okay with that?
Absolutely.
All right, case is dismissed.
Thank you.
Have a great one.
Thank you, Your Honor.
Thank you.
Yeah. Revolving door, and he's
All right, you folks
out
must
of
be ready for
there.
3 o'clock. All right, well, I'm going to step off, wait for everybody to get here, and then I'll come back up. We'll get that done. Court stands in recess. Thanks.
Hey, District Court of County, Washington State of Michigan is now back in session.
Maybe see. That's on the case of Spice Tree Apartments versus Cameron Hall.
Good afternoon, Your Honor. Brianna Kingsley appearing on behalf of the plaintiff.
And Latwana Mitchell.
Good afternoon, Your Honor. Gail Rosen on behalf of Cameron Hall.
That's a cute lawyer.
All right. And where are we on this case?
I just became involved in this case, Your Honor, and I have referred Ms. Hall, and she has several appointments with some services at University of Michigan, which might be able to help her with some of the back rent that's due. And so I'd ask for some more time to allow her to do that. She also was just hired for a full-time position, so hoping that will start soon and will help with the rent as well.
So you took the advice and went and talked to him, huh?
Yeah.
You feel better?
Yeah, I do.
You know why I'm asking that?
No.
Because when you were up here the first time.
Oh, that's the girl from. I streamed about this earlier this week. She had, I believe that is the girl whose mother was a co-signee and then screwed her daughter over, leaving her with as a student with a $1,600 or $1,700 rent, while she went to school full time and had 2 jobs.
You were lost.
Yeah, I was.
Yeah, you weren't even sure what you were going to do nor how to go about doing it, right?
Yeah.
Remind me again what your major was?
Sport management.
What?
Sport management.
Yeah. Still trying to.
The sports management girl. Yeah. Just a few days. Was it last week or just maybe a few days ago? I don't remember. Maybe it was last week. And she had such a hard time. I'm so happy she actually contacted the student board so she could get help, because her mother really, really screwed her over by having, imagine that, being a mother, a parent, but you are so irresponsible because your daughter signed for this apartment because you wanted to have somewhere to go. So she put herself in a larger apartment than necessary while in school, and then the mother just bails, does nothing. No, doesn't pay rent, no nothing, and then just moves out and in and out and in and out. Oh, I'm so happy for her. I'm so happy. Oh.
Figure that one out. Right, okay. So, how much does she owe at this point?
The balance with costs as of today's date is $3,280.08. It looks like some payments were made on 4/18, so that brought the balance down to $32.8040.
On 4/18, they made payments?
Mm-hmm.
And how much is her monthly rent?
Rental rate is $13.80 per month.
Oh, $13.80.
So we're going to be back on the first. We're going to be back up on around the $4,500 mark.
Okay. Kingsley, I know you can't agree if I agree to give her more time, right?
Your Honor, actually, I just received Ms. Rosen's answer in affirmative defenses today, so I would like an opportunity to respond to the affirmative defenses. So I have no objection if you want to set this one out. I have Ms. Rosen's email. I'm happy to discuss a resolution with her.
I will then, I do not have the next 2 Fridays because of judicial matters that I'm going to deal with, so I will adjourn this. I'm sorry?
I will actually be gone the first week of May anyway, so if we could put this
Okay, so my next available date is May 16th, if that works for everybody.
It does.
Fortunately,
Oh,
I will be out of town on the 16th for my niece's graduation.
got it. 23rd? Yeah.
Sure. Okay. At what time?
23rd, 2025 at 1 p.m.
Okay. And I'm sorry, my eyesight's so bad. Miss Kingsley, what's your first name?
Brianna.
Brianna.
Brianna. Okay. Thank you.
So one of the things you learn is sometimes you got to reach out for help, right?
Yeah,
Yeah. Okay. Where are you from originally?
Southfield, Michigan.
You're from Southfield, so you're a Michiganian, right?
Yeah.
Okay. You worked too hard to get to where you are. Let this put you down, right?
Yeah.
Okay. All right.
Thank
We'll
you.
work out something.
Thank you.
Thank you, Ms. Russell.
This makes me so happy that, yes, she's behind on rent and everything, but she now has the student counselor, the attorney for the landlord, and Judge Simpson working together to get her out of this hole. And yeah. Oh. Because she's a teenager going to school. She's going to be in sports business or whatever's, sports management. And so she's going, if she succeeds, she can become an agent or whatever's, and make a very large amount of money. Unless her mother keeps being a cunt and keeps getting in her way. But it seems like the rest of the world is gathering around her and tries to help her. Hopefully, she has changed her locks and just told mommy dearest to fuck off.
And young lady, got a darn good attorney next to you. So.
Oh, I'm so happy.
Well, case of Barbara Woods versus Kyle Casey.
Brenda Kingsley for the plaintiff.
Here. Right. And what's the current, how much is this currently on?
So, Judge, I actually had an opportunity to speak with Mr. Casey earlier. I spoke with my client, and I believe we have an agreement.
Okay.
So, my client has agreed to waive some of the month-to-month fees that we talked about last week when we were in court. So, they're going to waive $222 for the month-to-month fees. That would leave him with rent to retain of $349.79, court costs of $186, for a total of $535.75. My client has agreed to allow him until May 9th to have that paid, and then May rental charges will be due May 23rd, 2025. And they've authorized me to do this agreement as a conditional dismissal.
Sir?
What does that mean, Ms. Curtis? Mean? I'm sorry, I don't know the lawyer talk.
No, it's okay. It's okay. They would have the option,
we're good.
They would have the option of entering a judgment right now against you. It could even have those same terms. What they're agreeing to do is the case would be conditionally dismissed as long as you comply with those terms, meaning the payment of the back due balance. You said by the 9th?
Yeah, I believe we spoke. It was May 9th for, what was it, like 525 or something?
535.75. Yeah.
535. Okay.
And then you would pay your May charges by May 23rd.
Yeah, which is
right?
720.
It's going to end up being like $780 when I calculated it.
So they're going to give me a late fee. They're not going to.
Because they're giving you additional time. Yeah, you'll have to pay the late fee for May.
Okay.
Okay. So, and the benefit for you is that there won't be a judgment as long as you comply with that. And once you comply with those two terms, then the case remains dismissed. Okay. If you fail to, and you're going to do this as a 4B case, counsel?
Yes, Your Honor.
All right. So if you fail to comply with those terms, the plaintiff, by submitting an affidavit, could have the case reopened, ask the court to enter a judgment as well as an order of eviction all at the same time, which the court would sign off on. Right. And then there would be a judgment against you as well as an order of eviction would be signed at that time. But as long as you comply with everything, then the case remains dismissed. You follow that?
Yeah.
Okay.
Yep. I got you. Yes, sir.
All right. You have any other questions regarding it? And so that you know, they could ask to reopen the judgment and the order of eviction. That would be done without a hearing before this court. They could just do that on paper to the court.
Okay. Yeah, that's no problem. I shouldn't have an issue paying that.
Okay. All right. You have any other questions about that?
I just want to ask Ms. Kingsley if because we spoke earlier about my more personal matters. If those things proceed, can I give you a call about something and maybe we'll Okay. Thank you. I'm good then.
All right.
I've already drafted the conditional dismissal. Mr. Casey, would I have permission to sign your name to it and file it?
Oh yeah, if you want, can you email me a copy?
Yep, I was gonna ask you if you want a copy. Do you want to put your email address in the chat so that it's not over live stream?
Yeah. Yes, I will right now.
We'll get that. We'll probably have to forward it, but if you put your email in there. And sir, I do have to advise you that you have 3 business days from the date of my signing of that conditional order dismissal. If you believe that there's some mistake, some confusion on your part, some right you didn't assert, or something along those lines, you'd have to file a motion with the court within 3 days of my signing of that conditional order of dismissal. That doesn't mean that I would grant your motion to set it aside, but you have those 3 business days to file that. You understand that?
Yes, sir.
All right, fantastic. I'm glad it all worked out. So I'll mark this file conditionally dismissed, and I'll wait for the order.
Okay, and I put my email in that chat. If you want to confirm, you can see it at least.
I can see it, and probably Ms. Kingsley, I don't know if you can see it or not. If you can't, you can.
But at least somebody can.
All right, I'm writing it down right now.
Okay. And yeah, I'm good then. Thank you guys, everybody.
Thank you, sir. Have a great weekend.
You too.
Arbor Woods versus Tamika Mason and Jimmy Mason.
Brianna Kingsley for the plaintiff.
Let's just say that attorney Brianna Kingsley shows the right, she shows a good profession within law, because it seems like she's doing it very, very effortlessly. And also, she also might work for a client that is also easy to work with. That is not always the case.
Hello, Tamika Mason.
Jimmy Mason. All right, very good. Okay, they're here. What is plaintiff's claim now in this case?
So, Your Honor, I actually also had an opportunity to speak with Mrs. Mason today, and my client has accepted her proposed offer, if I may place those terms on the record.
Absolutely.
So, rent retained is $1,497.25. There's $242 in court costs for a total of $1,739.25. That amount plus the May 2025 rental charges are to be paid as follows: $500 today, $600 May 2nd, $600 May 9th, $600 May 16th, $600 May 23rd, and any remaining balance, which I calculated out to be about $575, would be due by May 30th. And it's my understanding the defendant's lease agreement also expires at the end of May, and they're agreeing to vacate the property.
All right. Is all of that correct?
Yes.
All right. And you heard my explanation of a conditional order dismissal to the other party?
Yes.
Okay. So that if you fail to make one of these payments, the plaintiff can reopen the case, file a judgment, as well as an order of eviction be signed, and that would be done without a hearing. Yeah. All right. Do you have any other questions regarding that?
No, sir.
All right. And would Ms. Kingsley have permission to sign your name to that conditional order dismissal and submit it to the court?
Yes.
Yes. Okay. Fantastic. Then I'll mark this file conditionally dismissed.
All right.
Wonderful. It
Thank
worked
you.
out. Good luck.
All right, have a good day.
Have a good day. Arbor Woods versus Lisa Thompson.
Brianna Kingsley for the plaintiff.
Lisa Thompson.
Got it. All right. Okay, and where are we on this case?
So, Judge, we were here last week. Ms. Thompson was to make a $1,000 payment. My client confirmed that she did drop off the $1,000 payment. So, her balance with costs is $2,057.47. She dropped off a $1,000 payment. That would bring her down to $1,057.47.
All right, Ms. Thompson, how are you going to get that paid?
Sir, I don't get paid again until the 2nd, and then the 16th. So what my plan is to make another payment that following Monday after that Friday, and then have everything caught up by the 19th of May. And that's my main rent, lot rent as well.
Okay, so you're going to pay everything by the 19th, but on the 2nd, how much are you going to pay?
Sir, I'm hoping I can pay $1,000 by then.
Okay, so you're going to pay another $1,000 by May 2nd.
That's my plan. Well, the
Okay,
Monday.
The 5th.
Yes, because I don't get off work till after the office closes.
Gotcha. Okay. So I'll tell you what we can do in this case and what I probably prefer to do. Do you think if you could pay the $1,000, do you think you can pay the $57.47 also?
Well, yes, yes, I do. I think I can pay the $1,100 actually.
On that date? On the 5th?
Yes, I'll get another check, cashier's check.
All right. So here's what I'll do, ma'am. I'm going to issue a judgment finding no tribal issue after hearing. And the reason I'm doing that is that way we're not dealing with May charges. We're just going to get you caught up, okay?
Yes, sir.
And then what I will do is I'll give you to the 9th to get that paid. That's over the objection of plaintiff, but I'll extend your writ date out a couple of days, and that way you can get that all paid, and then you'll be all set, and you can then work on May.
Yes, sir.
Okay? So I'll
yes,
grant
sir.
that judgment to the plaintiff. All right? Thank you.
Thank you.
Arbor Woods versus April Tubbs Streeter.
Brianna Kingsley.
And Elise Streeter.
Hi.
Hello. What's your name?
April Tubbs Streeter.
All right. And where are we on this case?
So, Judge, we were here last week. Ms. Tubstreeter had appeared. She had raised a couple of issues, one with the lease agreement, the other one with the water sewer charges. So I have updates on both. A few things. She dropped off a $677 payment. The second thing is I confirmed with my client that they already adjusted the water sewer that was posted on April 1st. So those credits have already been performed on her account. And then the third thing is the way that DocuSign works, they can't reroute the lease agreement to go to Ms. Tubstreeter's email again. However, the lease agreement has been printed and it's ready for her to be picked up from the office.
And she's showing it. I think she picked it up, right?
Yeah, we did it this morning. She had just talked to you. We did it this morning.
Okay.
Yeah, she told me this morning. So perfect. Okay, awesome. So the remaining balance due with costs is $538.25.
$538 and I'm sorry, how many?
25 cents.
25 cents.
So they didn't make any adjustments?
No, they made the adjustment.
So that's with the adjustments?
Yes.
So is that including that water bill?
They adjusted your water bill. That's what she said.
No, so the amount of the water bill that was adjusted for us to pay, is that included in that?
Yes.
Yes.
Okay, can you break that payment down for me, please? Because I got rent coming up and mortgage.
I am showing that the water was adjusted to $34.17 and the sewer was adjusted to $17.58 for the month of April. So those credits were already done. So it would be the remaining balance due from the water sewer, late fees, court costs. We get to $538.25.
Because I have both of those coming up, can we break those payments down? And
Okay, just hold on. What are you trying to do?
The remaining balance that she said that I have.
You what?
The remaining balance that she said that I have?
Yes.
Because I have rent, lot rent coming up and I have mortgage coming up. Can they break those two payments down for me?
What do you mean?
Break the
Payment?
$500, yeah.
Okay,
Give
let
a
me ask you
payment
this.
for that. Yeah.
The $538.25, when can you get that paid? If you had to get that paid, when can you get that paid?
I'll have it all paid.
Pardon?
I can have it all paid by the 29th. Well, actually, you know what?
29th of this month?
No, I was saying by the 29th of next month of May, but I can have it paid by the 15th of May.
As well as,
My regular,
so you,
I want to pay May,
you can pay May?
and then by the 15th, I'll have that the remaining balance of the 5 something she said it was.
Okay, so hold on. No, I think I'm hearing you, but I just want to make sure. Your May rent is how much?
It'll be $677, correct? Because it doesn't.
Okay, because that's what you paid the other time.
Well,
Okay.
it'll be, just to clarify, Judge, it'll be $677 plus the water sewer and charges.
Right. Okay, so I guess what I'm getting at is you can have everything paid by you said 16th?
Yeah, and then I guess I would have to hold on to that because they have it now where you can't do a partial payment. So that would be considered a partial payment, right? Okay.
You're trying to make my life complicated.
I'm not trying to make it any complicated. No. But yes, I can have my regular payment.
Hey, hold on. And I know you're dealing with it where you're looking at each month that you're paying. I get that. So what I'm asking you, just put May aside for a moment because it's not due. When can you have this $538.25?
By the 15th. Well, you know what? Okay, you said we're gonna put that aside. So I can have that by the 30th.
You'll have that by the 30th
of April.
April.
Yeah.
So you can get that paid by April 30th?
Yes.
Okay. And get it into them by that date?
Yes.
Okay, then here's what I'm going to do. And this will probably be your plaintiff's objection, but I'm going to do it this way for you because I know you're trying to work. You're trying to get everything paid. My next date is May 16th. I'm going to adjourn the matter out to my next date.
Okay.
At 12 p.m. The reason I'm doing that is if you get that payment in before this month ends, they're going to dismiss the case.
Okay, so if I get the 5 something in.
The $538.25.
Okay.
You got to get that into them. I'm going to order plaintiff to accept her payment. However they're doing it. I don't know if they close the court or whatever, but to accept her payment, you will have paid through the end of April. Then you're good. It'll be done.
Okay, let's get this straight right here, Judge. So then by the 15th, I pay that 7 something, right?
Right. Your May. I'm not trying to deal with your May rent.
Okay, so okay.
I'm just what I'm trying to do is get this paid.
Okay.
Get this case dismissed. And then you get your May payment in. You may have the charges, you may have those other things, but you're not with the court case.
Right. Okay, I hear you.
You got it?
Yes, I do.
Does that make sense to you?
Yes, it does. I appreciate it.
Okay, good. Because a lot of people think what I say doesn't make sense. But Ms. Kingley's going to yell at me about something right now, aren't you?
I just want a point of clarification. Is she intending to pay online or in person? Because the online system cannot accept partial payments, and that's not something that my client has control over. It's just the way the software.
Oh, okay.
Yeah, I'll bring it in.
Okay. Bring it in.
Okay, perfect.
And I'll add the $10 because I've seen it on the thing today, and it is in the lease.
Okay, so you'll add that to
Yes, I
it.
will.
You'll get everything paid. And so when that clicks over effective that next Thursday, May 1st, you're going to be clear.
It'll be there.
That work?
Yes.
Okay, and then that way, if everything's paid, you don't have to.
Awesome. Okay, good.
Well, don't say it like that. Like you want to see.
I only have Fridays off.
Okay, all right. That's the reason. I think
Yeah.
you were hurting my feelings. Okay.
No, but it's you.
All
All
right.
done?
You're all done.
All right. You
Have a great weekend.
Thank you.
Donald Hammond versus Angela Hammond. Is it Chenard? Hammond? Well, hold on. Why do I have this case? Because this is not theirs. I don't know. That's weird. That is weird. Yeah, is that on today? That looked like it got stuck in there someplace. Northfield Estates versus Tracy Schoonfield.
Good afternoon, Your Honor. Brianna Kingsley for the plaintiff.
Schoonfeld? No response. You raise your right hand to be sworn. I'll let you proceed. Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but yourself again?
Yes, Your Honor. Your Honor, in light of the defendant's failure to appear, I would request entry of a default possession only judgment. I am showing rent to retain in the amount of $729.49, $213 in costs, total $942.49 for that amount to be paid on or before May 5th.
If that's by default for possession, reduction amount, in the amount requested, writ issue 10 days. Northfield Crossing versus Eugene Rinke.
Brianna Kingsley for the plaintiff.
Damn, she has the
Eugene
entire
Rinke?
docket.
Yes, I'm you. I'm not picking them up or whatever. Oh, there he is. Okay, can you hear me?
Yes, Your Honor.
Okay, we can hear you. All right, how much is owing on this case?
So, Judge, this is the defendant's motion, this continued motion,
Oh.
instead of the default judgment. So the default judgment was originally entered on February 14th. My client had requested the order of eviction. The order of eviction has been signed, and then the defendant filed this instant motion on March 25th, 2025. So we were here last week. He had posted $800 in escrow. He gave my client $800, and then another payment of $840 has been made. Now, as far as the judgment, that still doesn't cure the judgment balance, and we're left with a remaining balance of $1651.36.
1651.36.
Correct. That's if you
But
apply
that-
the 800 from the escrow.
Okay, gotcha. And all right. So, sir?
Yes, Your Honor.
All right. How are you going to get the remaining balance paid? The 1651.
Right now, I'm working with Salvation Army to see if I can be able to offset the balance. I really want a little time to be able to get that result. And
Have you had your meeting with them yet?
Yes, I went to the office severally. I didn't see the management to talk to, and I spoke to her this afternoon. She told me that most of the decision is not with her right now; it's with the court. Whatever the court decides, that's what she's going to follow.
Okay. Just made some significant payment. How much was left on the judgment amount, counsel? Was it? Okay.
That's what I'm reviewing right now. It looks like the judgment was entered back in February 14th
Yes.
for 27.
2710.86.
Yeah, that's what I have. 2710.86. So he has paid. He made one $800 payment, and then he made an $840 payment, and then that leaves us with $1,070.86, and then the $800 in escrow, that leaves $270.86.
2786 is what he paid. Okay.
That would be what's left on the judgment.
Oh, I'm sorry.
Yeah,
$270.
Yeah, that would
And
be
86,
the judgment. Mhm.
Okay, if that was balance, I can have that paid next week, Monday then.
Okay, but that only clears you through February. Then you had your March and April rent click in. And so after everything's applied, that's where the 1651.
Correct.
36 cents in. So, sir, when can you get that paid?
As I said, Your Honor, I'm working with Salvation Army. I just needed some little time to take care of that, but I think I can come up with $600 next week and pay $800 on it. And I'm working with Salvation Army. I just want a little time to see that work out, Your Honor.
All right. Well, here's what I'm going to do, sir. I'm going to you paid quite a bit, but you're going to have to let the Salvation Army know that they need to get a decision to you, because what I'm going to do at this juncture, because we're going to click into May, and don't want to do that on this case. I'm going to deny your motion on this case. I will sign the writ in this matter that has been filed with. I'm sorry.
We already have it signed. It's already been signed.
I don't know that it's been signed because I've got the order of eviction here.
Oh, we had submitted we had submitted an amended writ identifying that he had made a payment. So that second writ, I don't think has been signed. The first writ was signed.
The first writ was signed, and then I have a writ from March 3rd.
Oh, okay.
That's your date that was signed.
Yeah, that's the first one. And then a second writ was processed.
Was it?
It was processed by my office. I'm not sure. Maybe the second writ hasn't been signed by the court yet.
I don't see a second writ.
Okay.
I see the first one.
I can submit another one.
All right. So why don't we do this? Submit a new writ with those payments in. I'm going to deny your motion on this, sir. I will just indicate that the writ will not be executed prior to, well, when did you meet with SOS or Hawk, sir?
Last week Friday when I left the office, I left the court. I went to the office. It was locked. On Monday I was there. On Tuesday I was there. The manager was not available because he said she had emergencies. But I called her this morning and spoke with her. She told me that the court had a decision that the matter is not in her hand at this time.
All right, here's what I'm going to do. You're going to have to let them know this. I'm going to deny your motion. I'll sign the new writ. It's not to be executed prior to the 9th of May. Okay.
Okay, Your Honor.
All right. Thank you.
Thank you, sir.
Northfield Crossing versus Barbara Vargo.
Brianna Kingsley.
And, well, it's only in Barbara's name, but easier. Hello.
Hey.
State your names.
Barbara Varga?
Michael Vargo.
All right. And where are we on this case with them?
So we were here last week. Both of them had appeared. Mrs. Vargo had an appointment with the VA this past Monday. I believe she was trying to get assistance through them. So I'm not sure how their appointment went.
You're right.
We've submitted all the documents and we've scheduled another appointment for Tuesday of next week at 2 p.m. to review we got the document filled out this week for the landlord to complete. They've completed it.
The landlord did?
Yes.
Okay.
So the property manager, rather.
Okay.
And then submitted everything to her. So we have an appointment at 2 o'clock on Tuesday, April 29th to review the request. To go over our bank statements, everything, and then she'll give us an answer then what she can do for us.
Okay.
On the 29th.
All right. I'm going to go out on a little limb here, and I'm going to adjourn this to my next date of the 15th or the 16th. I've not heard of the VA turning it down.
Okay.
And so unless something strange happens. So I'm confident that they're going to come through and do something. And quite frankly, usually with their cases, they not only pay the back rent, but they make sure to pay what month you're in, so you're not right back.
If not, we're also working with a social worker through the Housing Bureau for seniors. Actually,
Okay.
Michael is. They're waiting to see what the VA comes back and if there's anything they can do, even if it's just our utilities or whatever.
Okay. So you're working with Housing Bureau for Seniors. They're waiting on the VA's determination. And then, okay, that all actually makes sense. So over the objection plan, if I'm going to adjourn this to May 16th, 2025 at 12 p.m. And by that time, you'll at least have an answer from the VA. You'll have that.
Yes, we will.
All right. How you guys doing?
Good. Working hard. My body's getting used to working.
Okay. All right. How are you doing, Tom?
It's sort of the same thing. I'm getting back up on my feet, doing stuff around the house and that.
Okay.
You know.
All right. Like I said, the last time I saw you, you're looking real good. All right.
Oh yeah, that's the guy who had a heart condition, who couldn't begin working again, so they fell back on rent.
You guys take care. Take care of each other, please.
Thank you. Thank you.
Every day.
Silo Farms versus Tiffany Copeland.
Anna Kingsley for the plaintiff.
Tiffany Copeland, not here. You've been sworn. If you'd like to proceed, you may.
So, Judge, this is actually defendant's continued motion to set aside the default judgment that was.
It is.
So we were here last week. The defendant had indicated that she had claimed that there were still some issues with the water meter to the home. I confirmed with my client, as I stated last week, the freeze plate was the issue. The freeze plate has been placed back on the water meter. It's functioning properly. That's been addressed. I sent a couple photos to Ann so you could look at it.
Yes, I can see it.
Okay, good. So Ms. Copeland has not paid the remaining balance. So at this point, I would request that her motion be denied and that my office be permitted to submit an order of eviction.
What's her balance?
So we have a default judgment for $8,411.95.
Ouch! 8,400. Yeah, that will get you thrown out.
With the prior motion she had filed, $5,915 were posted into escrow that's been applied to her balance. She then posted $1,000 into escrow for this account, for this motion. That would bring her.
Okay, so now she has $6,000 in escrow, which, yeah, takes care of the majority, but it's still $2,000 left.
Balance down to $1,561.95. That's remaining.
15.
61.95.
Okay, and I have on April 21st, she posted an additional 1590.
Oh, she paid it to the court?
I think she did because I have a total in trust right now of 2590.
Oh, okay. I was under the impression that she was supposed to pay it to my client. So my client.
I think that's what I said, but I think because she had been making all of the payments here, she must have just did it that way.
So
that's probably why she's not here because she's paid everything.
Because she paid it into escrow. Okay, so then could we enter an order denying her motion as moot and releasing escrow funds to my client?
Absolutely.
All right. Thank you very much.
All right. So this one I don't remember, but she cleared the debt, but they are still going to evict her or him.
Very much, Judge. Do you want me to prepare an order?
Yes, if you could send over that way, I will write it in the file, so it might be on this way by the signature, but
okay.
That's kind of impressive to get.
Silo Farms versus Joanna Hollis. I do.
Brianna Kingsley.
Yeah.
Excuse me for the plaintiff.
Your Honor, this is Victoria.
Oh, Victor?
Yes,
is that you?
Yes,
okay, she's here. All right. So he was supposed to pay $2,000 by today.
I don't believe that he's done that, Your Honor. I received an email from my client this morning. So unless he's dropped it off in the last 4 hours.
Sir, did you pay?
No, sir. I talked with the manager of the Silo Farm that I'm ready to vacate the place and sell the mobile home. I was unable to get the money, so I'm ready to vacate the property and sell the home.
What was the last part of what you said?
Yeah, the last time I promised to pay some money, but I was not able to get the money at this time.
You're
So I'm
unable
ready
to get the money.
Yes, sir. So I decided to vacate the property and then sell the mobile home.
All right, counsel, how much do you have, Owen?
Balance is $3,417.33.
Give that to me. I'm sorry. My brain froze.
$3,417.33.
I'm going to find that after hearing no tribal issue a judgment for possession with that redemption amount, and that needs to be paid within 10 days.
Thank you, Judge. I will prepare an order.
Thank you. Soil Farms versus Teresa Tomasi.
Brianna Kingsley for the plaintiff.
She is here. Ms. Tomasi?
I'm coming.
All right, you're right there. Okay. We got you. Okay. Hi. How much is owing on this account?
So the balance due is $3,041. We were here last week. Ms. Tomasi had applied and been approved for assistance through Hawk. She had a copay to make. There was a payment received for $442.28. I'm going to presume that was her copay that she had to make before Hawk will release the funds.
Yeah, the check came to the office from Hawk yesterday. The Jeanette called me yesterday. They got the 3,000 at the office yesterday. So that's the last I've heard. So if it's
Okay.
So Judge,
Is that correct, Penny, that you had to, I see Soil Farms on.
Yeah.
To our main office, Judge, and they had to send it back to us, but we have it. It's on. They already approved for us to put it on her ledger, so she is good with us.
Jeez. Oh, great. So this can be dismissed?
Patty, would you like to dismiss?
Yes.
Okay. I was waiting for somebody to tell me. Ms. Tomasi, congratulations. Fantastic. This case is dismissed. You have a great weekend.
You too, guys. Stay healthy.
All right, you too.
Thank you, Judge.
Thank you. Valley Ranch versus Brandon Kuchar.
Brianna Kingsley for the plaintiff.
Brandon.
And how much is owing on this?
So balance due is $4,645.49. We were here last. Mr. Kutcher had submitted a payment through MoneyGram. I believe there was an issue with MoneyGram, and he's trying to receive his money back from them.
That is correct, and we still have not. I wanted to get it by the end of the day yesterday to make it whole. We still haven't received it today, but we did speak to family today, and we can submit full payment. I know we've met several times now, and I don't want to waste any more time. But we can submit payment for the whole amount through the online process. Yes, it's just
Okay.
it's just not. Yeah, we just had to ask for help because our money hasn't been returned from MoneyGram.
So when can you pay this full amount?
I literally talked to my parents this morning.
I'm sorry, you're breaking up.
I talked to
You
my
can
parents
pay
this
it
morning.
when?
I talked to my parents this morning. We can do it this weekend at any point. The online portal was open all the time, so it can be done now, today, whatever.
Okay. So you can pay the 4,645. So what I'm going to do is I'm going to issue a judgment for possession, finding no tribal issue after a hearing. You get that paid, no writ before the 7th of May. Okay.
Okay. So yeah, absolutely. So just pay before we're issued, pay now, and there's no issue going forward. Continue, please.
Yep.
Okay. Thank you so much for your time.
Real good. Thank you. Court does call the case of Whitaker Oaks versus Marjani Green.
Brianna Kingsley for the plaintiff.
Marjani Green.
Marjani Green and Daniel Keener. And how much is owing now?
Balance due is $2,754.16. Brianna Kingsley for the plaintiff. I'm not sure if I put my parents on the record.
Okay.
Balance is $2754.16. We were here last week. Ms. Green had indicated that Hawk had approved her. However, I confirmed that she did receive a non-renewal notice. My office did issue her a formal notice to quit. It expires May 2nd. So I think at this point, my client would like to have possession of the property back. And it's my understanding that Hawk would not assist with payment. They would assist with relocation assistance in that sense.
Is that all correct, Ms. Green?
Yes, that's my understanding. I did try to reach out because Hawk said if they would extend the lease, then they would be willing to pay it. But I haven't been able to get in touch with the office.
Okay. So have you sought relocation fees or services through?
Yeah, I'm just trying to figure it out at this point because I don't really know what I can do further.
Okay, so what I'll do is this. You're not disputing the amount owed. They're gonna. Yeah. Okay. So I'm gonna issue a judgment for possession to the plaintiff for this amount. Finding no tribal issue after a hearing, but you need to get back in touch with SOS or Hawk regarding relocation assistance, and so no writ before the 9th of May.
All right, I will prepare.
Okay. Okay. Thank you, Ms. Green. Good luck.
Thank you.
And I have Northfield Estates versus Costco, Soil Farms versus Best, Soil Farms versus Rousseau, Soil Farms versus Leany, and all of those matters are dismissed on plaintiff's motion without prejudice.
Very much. Have a nice weekend.
Thank you. You do the same. Take care.
Bye.
Is that it for us?
Yep.
14A. Stand.
Yeah, that was it, folks. That was the entire week at Judge Simpson. And we got it under 10 hours. Thank you to Brain Socks over at Rumble for your $5 Rumble rant. Thank you to Erica for your $2 super chat. Thank you to Dark Lotus for your $2 super chat. Thank you to DSN for your $5 super chat. Thank you to Rosalind for your $5 super chat. Thank you to Polly Popcorn for a gifted memberships. And thank you to Sherazad for 150 Egyptian dollars. Marathon stream. All right, folks. If you were here from the beginning, why? But folks, thank you. Thank you so much. And I'm not sure. Now, I will keep recording Judge Simpson's docket. I will keep doing all the things, but I do believe I will portion the videos out throughout the week. And for instance, if I record Monday, I will post that Monday evening or Tuesday, and so on and so forth. Because 10-hour stream is it was rough. It's been rough. But everybody, thank you for showing up. Thank you so much. Sunday, I'm posting the individual videos right now. So you have the videos from April 21st, 22nd is already out. And I will continue with April 23rd, 24th, and 25th on Sunday. So, again, thank you. Thank you for allowing me to do this. And remember, folks, to hug your family. Unless your family is crap, then screw them and give your love to the people who deserve it. And I will see you on Monday around 9 a.m. Eastern Time on the Michigan v. Sure trial. Okay, see ya.